ಮಾಡ್ಕೋತೀನಿ. ಹೋಗಿ ಪರವಾಗಿ ಅದೊಂದು ಹೇಳಿ ನೀವು ಫೋನ್ ಮಾಡಿ, ನಾನು ತಗೊಂಬ, ನಾನು ನೋಡ್ತೀನಿ. ಹಾ ಸರ್, ಇದ್ರಲ್ಲ ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ. ಎಷ್ಟನೇದು? ಅವಾಗ ಬಂದ್ಮೇಲೆ ಕಾಲ್ ಮಾಡ್ತೀನಿ. ಅವಾಗ ಕಾಲ್ ಮಾಡಿದಾಗ ಅದೇ ಹೇಳ್ಬಿಡಿ ಸರ್. ಮುನ್ಸಿಪಲ್ ಗೌರಿಬಿದನೂರು ಸಿಟಿ ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್. ನನ್ನ ಕಾರ್ ಎಷ್ಟು ಅಂತ ಗೌರಿಬಿದನೂರು ಸಿಟಿ ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್. ಇಲ್ಲ ಅಲ್ವಾ? 4. ನಮ್ಮ ಕೊಟ್ಟಿದ್ದು ಹೋಗಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದು ಹೋಗಿಲ್ಲ, ಬರೀ ಇದೇ ಆಗೋಯ್ತು. ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀರಾ? ಮಾಡ್ಕೊಂತೀರಾ? ಆಗ್ಲಾ? ಟ್ರೈ ಮಾಡಿ. ನಾಳೆಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಅದರ ನಾಳೆಗೆ ನೀವು ದೊಡ್ಡಬಳ್ಳಾಪುರ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ 6ನೇದು ಇವರು ಯೋಗೇಶ್ ನಾಯಕ್ ಸರ್. ಕೊಟ್ಬಿಡಿ ಮೆಮೊ ಸರ್. ಸುಪ್ರೀತಾ KH. ಪಂಚಾಯತ್ ಡೆವಲಪ್ಮೆಂಟ್ ಪಂಚಾಯತ್ ತುಮಕೂರು, ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ತುಮಕೂರು ಏ ನಾಗರಾಜಪ್ಪ. ನಿಮಿಷ ಅವರೆಲ್ಲರೂ ಏನ್ ಗಲಾಟೆ ಮಾಡೋದು ಗೊತ್ತಾ? ಮಾಡ್ತೀನಿ. ಕೊಟ್ಟಿದ್ದಾರೆ 18265 ಸರ್. ಇಲ್ಲ ಅವರು ಇದೇನಾ? ಇದೆ ಅಲ್ವಾ? ಇದೆ ನಂಬರ್ ಅಲ್ಲ, 18326 ಇದೆಯಲ್ಲ? ನಾಳೆಗೆ ಹಾಕ್ಬಿಡು ಸಿಗು, ಮರಿಬೇಡ. 20 ಡೇಟ್ ಇಲ್ಲ, ನಾವು ಅದೇ ನಾವು ಕೊಟ್ಟಿರ್ತೀವಿ, ಅವ್ರು ಬರ್ದಿರಲ್ಲ, ಅವ್ರದ್ದು ಮಿಸ್ಟೇಕ್ ಅದು. ಇರ್ಲಿ, ತುಂಬಾ ಕಷ್ಟ. ಎಲ್ಲಾರನ್ನೂ ಸಮಾಧಾನ ಮಾಡಕ್ ಕಷ್ಟ ಇದೆ. ಪರ್ಫೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಕೊಂಡು ನಾವಿಬ್ರು ಬರ್ಕೊಂಡು ನಾನ್ ಬರ್ಕೊಂಡಿಲ್ಲ ಪರವಾಗಿಲ್ಲ. ನೀವಿಬ್ರು ಕರೆಕ್ಟ್ ಬರ್ಕೊಂಡ್ಬಿಟ್ರೆ ನೀವು ಯಾವ ಸೈನ್ ಮಾಡಿದ್ದು? ಯಾರಿದೆ ಪಾವಗಡ ಸರ್? ಪಾವಗಡ ಅದೇ ಯಾರು ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಅಲ್ವಾ? ನಾಳೆಗೆ ಬರುತ್ತೆ. AC ಹಾಕಿದ್ರೆ ಅದು ಸೆಕೆ ಆಗ್ತೈತೆ. ಬಂದ್ರು ಕೊಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್.
What you give us? Inform the government. Inform the
Let them
government.
serve a copy to us.
Inform the give a copy now, extra copy to the government and tell them the details so that they can take telephonic instruction.
That's all.
But tomorrow, my lord, petitioner have been disclosed.
Fresh matter
Fresh matter.
tomorrow.
My lord, tomorrow, my lord, date given matter, it has not been listed yesterday notice.
Date given.
Yesterday, date given matter. notice. Tomorrow.
Yes, yesterday also I had moved a memo for today, but it is not listed.
Hmm.
The matter pertains to the chief commissioner has passed an orders confirming the demolition order, my lord. Kindly have it tomorrow.
Scrutiny is complete.
Yes, my lord. One matter for B group, my lord. And anytime next week, my lord. He is
Just serve the other counsel and give it to the court officer during the course of the day. Yes, yes.
Fresh matter, my lord.
Give it, give it.
Property tax,
Give it.
my
Yes.
lord, for 230, my lord.
No, no. Why? What is the urgency for 2:30?
My lord, they move for auction of the property, my lord.
When is the auction?
It's not yet fixed, my lord.
Then wait tomorrow at least.
Tomorrow, my lord.
That's fresh matter. notice. Tomorrow, my lord.
Give it, give it.
My lord, fresh matter for 2:30 A.M.
Why? What is the urgency?
We are demolishing the petitioner's compound, the Bangalore,
BBMP,
BBM. Bangalore.
Mangalore.
Municipal Palika is demolishing the plain petition.
Standing council idara Manjuna. Mangalore Municipal Corporation. You serve, we'll have it at 2:30. Inform Harish Bandari and serve him a copy. Yes, yes, yes. There is no? Today.
2:30.
Can I inform the other side? Same.
So preliminary hearing.
Tomorrow we will start.
Mandamus.
Mandamus direction seeking.
My lord,
Patan Panchayat.
Preliminary hearing list. Yes.
Patan
my lord, I'm a
Panchayat.
parting person. I have finished the scrutiny and also obtained the CFA, my lord. The urgency in this matter is, mine is a old building constructed in 2008. Still, the BBMP wants to, take precipitative action against my building, though there are several judgments of this court not to move against property standing before 2013, my lord. And they have not given me enough time also to respond to them.
Tomorrow.
Yes, my lord. Tomorrow.
You serve advance copy on.
Yes, my lord. I have submitted to the BBMP. And Pawan, who is the counsel who comes, he has taken it, my lord.
You have become a trained lawyer now.
No, my lord, there are more problems in our neighborhood. That's why we have been forced to do that.
Yes.
Much obliged, my lord.
Yes.
ಎರಡು ID.
You can have it tomorrow. No, correct, only 2:30 means roof is going to fall, demolition, etc. Your inconvenience cannot be a ground for having it at 2:30. Day after tomorrow we'll have it. What will happen? We'll stay it. Correct. On 28th we'll have it on in the fresh matters list and put forward. 28th.
My lord, is a fresh matter, my lord. The respondent
Give it.
number 230, my lord, is respondent in a Gram Panchayati, my lord. Is the action bid of the petitioner shop, my lord. Day after tomorrow is a date going fix, my lord.
Tomorrow.
ನಾಳೆ Monday. 4th ಇದೆ ಅಲ್ವಾ ಡೇಟ್?
Okay, give it. Yes.
Assignments list 1, page number 1, 1 to 5, page number 2, 6 to 9, page number 3, serial number 10 to 15, page number 4, 16 to 21.
You're not a party there. That request of the petitioner relist the matter on intermodal
15th of April.
extending to the next.
15th of April,
Yes.
30. Page number 4, 16 to 21. Page number 6, 22. Page number 7, 23 to 25. Page number 8, 26 to 29.
Lordship, serial number 26, a week time may be granted to
26. Yes,
That request on behalf of the petitioner
petitioner.
relist week after next. Yes.
28,
Yes.
10 then?
28, I have objection, my lord. This land belong to Defense Department. They don't have any document. They have placed two documents which does not pertain to the land itself. They have been taking one or other proceedings before the various courts. Last time also they took time. It was specifically mentioned, my lords. Mainly I have it, my lords. It's 2 minutes. I will demonstrate how they don't have any right to that property. They don't have anything. The 2 minutes I submitted, my lords. They don't have any semblance of right about the property itself. Their own document, my lords. And they have misrepresented before this honorable court and say that they have obtained the interim order also. There is a suit pending for against me. They did not array me as a party here. I got implicated when I come to know about it. This honorable court, after hearing, I was allowed to come as one of the respondent. No, my property, how they are colluding each other, housing society and this private person. They are claiming that the property belongs to them. This is the issue. I will demonstrate in 2 minutes. They don't have any semblance of right to property.
Advocate name.
I'll have it on Monday, no
Yes, sir.
further adjournment.
Yes, apply.
Interim order earlier
First
granted
of
is
April.
extended to the next day. List the matter on Monday.
First of
Publish.
April.
Yes.
Page number 9, 30 and 31. Page number 10, 32. Page number 11, 33 and 34. Bairegowda N.
Bandar Kodu, Bandar Kodu. The memo for withdrawal has been filed, which reads as here under. Light of the same petition is dismissed as withdrawn. All contentions are kept open to be raised in the pending proceedings. In the pending suit and other legal proceedings.
Page number 12, 35 to 38. Page number 13, 39 to 43. Page number 14, 44 to 49. Page number
48. I appear to have the respondent number 2 and 3. On the last occasion, the lordship directed me to obtain instructions. I need another day's accommodation to obtain the.
Have you informed the petition?
I'll
Yesterday, 3-4 matters lawyers didn't inform, though they said they will inform. Then if that is so, then how I can? You get a signature on a memo from them and give it to the court office. Or when it reaches, I'll let you. Yes, thanks.
page number 15, 50 to 52. List to page number 1, 1 to 3.
Second matter, please, sir. I filed the withdrawal, memo for withdrawal.
Page number 2,
Second.
4 and 5. Page number 3, 6 to 8. Page number 4, 9 to 14. Page number 5, 15 to 19. Page number 6, 20 to 23. 22.
First list week after next.
Page number 7, 24 to 27.
That's
Wait.
number 25 minutes. I appear for respond number 2 and 3 minutes. Awaiting instructions in the matter.
Have you informed the
I'll
petitioner?
inform them. I'll
You have
inform
to correct. Yesterday, 2-3
I'll inform them,
matters.
right.
I was embarrassed. Because I said they've informed, they didn't inform.
25.
inform.
Inform, get the signature on memo and give it to the court officer, or when it reaches, I will.
Please.
Yes,
Page number 8, 28 to 31. Page number 9, 32 to 34.
Lord, serial number 32, my lord, I may be permitted to file my wakalat. I just received it yesterday, my lord, and a week's time, my lord, so that I can get instructions.
yes, but have you informed the other side?
Yes, I have informed the petitioner.
Land Council, Mallikarjun Reddy is permitted to submit that he would file wakalat on behalf of
Yes.
R1 and R2. Office to delete the name of Land Council B.S. Karthikeyan. Relist the matter in the same stage on.
No, I have not seen this one.
No, just.
32, 16th of April.
Obliged.
Yes.
That's
2:30, we'll take it up.
26 release and
List one, fresh matter, serial number one, Cyril Prasad. Thirty-two ಬಂದು second list 32. Second
caveat petition.
ಬರ್ಕೊಡು.
Manjunath,
Sir.
caveat ಇದೆ. Just verify there's a caveat. Copy to be served on the caveat. Relist the matter on short date. 1st of April. Yes. Tomorrow. Fine,
Okay, sir.
I'm fine. Yes. Now you take out, correct, you take out notice, because you have challenged the validity of the circular. So whatever you pay could be subject to the final outcome. I may not be in a position to grant an ex parte stay because you're challenging the validity of circular. So at least let it, we'll hear the other side and then we'll see what is. $340.
ಬರ್ಕೊಡ್ತೀನಿ ಸರ್. ಎಲ್ಲ ಬರ್ಕೊಡ್ತೀನಿ. ಎಲ್ಲ ಬರ್ಕೊಡ್ತೀನಿ. ಸರ್ ಚೆಕ್ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಯಾವುದು? ಬೇಡ. ನಾನು ಎಷ್ಟನೇ 28.
Only the last notice where I am talking. I challenge the file notice, but 4 demand notices of 5 and I want to make that.
25 ಇದೆ. 25 ಬೇಡ ಅಂತ.
Counsel for the petitioner submits that the issue raised is identical to the legal issue raised and pending and is pending adjudication in WP 28840 of 2023. The order passed in WP, interim order passed in WP 28840 of 2023 reads as hereunder. Next. In light of the same, there would be stay of the demand notices at annexure H. H is the demand notice.
Yeah.
The AG accepts notice for the first respondent, Sidlgatta Taluk, PDO.
Devraj.
Devraj is directed to accept notice for the second respondent. This is the matter along with WP number so and so. IA for IA 1 of 25 is allowed petitioners dispense with production of certified copy of annexure A, B, comma, D to H. Subject to the undertaking, same would be produced in due course. Yes.
3, Chetan AC.
Yes, take out notice. AG is directed to accept notice of the first respondent. Sarjapura Hobli, Anekal Taluk, Gram
MS
Panchayat. Yamare. MS Devraj directed to accept notice of second respondent. Your direction is only for maintenance of road. List the matter, get instructions. List the matter in preliminary hearing list.
Second. After second. 9 ತುಂಬಾ matter.
10th, 11th. 15th.
4, Manjunath AC.
No, that's only a notice. It's only a notice regarding the proceedings.
ಇಲ್ಲ ಇನ್ನೊಂದು 5 ಕೊಡ್ಬೋದು. ಅದು ಹೋಗ್ಲಿ ಬಿಡಿ
Under section
27.
Municipalities Act or Municipal Corporations Act? Huh? Municipalities Act. Section 41. Page.
Government utilities bill on the recommendation of the council. They remove any councillor elected or appointed under the act. After viewing the application being heard.
ಅವರೇನು ಊಟ ಮಾಡಿಲ್ಲ ಏನೋ ಕಡಿಮೆ ಇರುತ್ತೆ.
There is no any recommendation to initiate any. Based on the look the inspector, the inquiry. Demanded some bribe to issue Kata. But the interest of Kata is committed to the CEO. Councillor Black is not to they are going to take the issue Kata.
Yes, they're saying that there cannot be under 41, there cannot be action initiated except on the recommendation of the municipal council.
2 weeks.
And here it is local. Then we'll state, I'll keep it in the orders list till the next day. You find out on that only point. Land council for the petitioner submits that the notice is one without jurisdiction as the proceedings under section 41 can be initiated only upon a recommendation of the town municipal council. And in the present case, the notice itself would indicate that proceedings are initiated on the basis of the recommendation of the local. In light of the contention raised, there would be stay of the notice and proceedings pursuant thereto till the next date. AG is directed to accept notice for respondents 1, 2, 3. Emergent notice to respondent number 4. Municipal Commissioner Chikbalapura. Emergent notice to the 4th respondent. Petitioner is liberty to take out notice by way of hand summons of 4th respondent. List the matter in the orders list next week. Yes.
Serial number 5, Harish NR.
No, how do you say there is no plan?
Action will be taken and initiated for having no plan. In fact, visitation verified. By that time that they did not disclose any case details for having initiated the proceedings. Thereafter, it was admitted by the respondent, private respondent also. That there is no plan in the previous proceedings. That previous proceedings.
No, correct, but where is the reference that there is no plan there? Otherwise, I'll give them 3 days time, let them verify. If that is so, we'll stay. Let them verify. 3 days time we'll give. We'll have it on Monday. If there's no plan, then we'll stay. Yes. No. If you don't see, now what have you saw? Correct, by then he'll complete his building. Completed.
year 1994, madam.
No,
At
but-
that time itself, I have taken plan, everything,
No. No, that is there. Now you have at least objected when he's putting up construction, isn't it?
At that time also I have submitted representation.
Pawan
But
Kumar
they-
accepts notice.
Enforcement, it is some allegations, extra allegations are made. Therefore, this honorable by reserving my liberty to submit this representation. My petition came to the court.
Yes, just, Pawan Kumar accepts notice to respond 1 and 2. Emergent notice to the third respondent. List week after next date. Kodi.
17th.
Meanwhile, you complete your instructions. Yes,
6.
petitioners at liberty to take out notice to the private respondent by way of hand summons. Yes,
Serial number 6, Priya, okay.
After the more than 7 months now, they have not done anything.
AG accepts notice for the first respondent. Dodbalapura Town Planning Authority,
Yogesh D. Naik.
Yogesh Naik, directed to accept notice of second respondent.
Nene Kotralla.
BMRDA,
Lord, I've.
for 2 and 3. They only want to know allotment of civic amenity site. So what is the stage? Accept.
Please, my lord.
Read
There is
it.
a one rule, my lord. 2016 rule is there, my
No,
lord.
in terms of that
Please,
only,
please,
the
please.
process has started. They want to know what is the stage.
Please, please.
Find out.
Please, please.
They keep it pending for years.
No, you find out. This is the matter and preliminary hearing list on.
No, my lord, it cannot be, my lord.
that
Because, my
is-
lord, rules is very clear, say that, my lord.
9th of April.
9th.
Please.
You find out what is the stage of the process. Yes,
7. Serial number 7, Suprita H.
PDO Kunigal Taluk. Land Council, A. Nagarajappa is directed to accept notice for respondents 2 to 4, AGA. Accepts notice for the first respondent. List the matter in the orders list on. No, let us see. We don't know. Let them find out.
8th of April.
Huh? Okay, correct. Otherwise, you get Nagarajappa again. We'll pass over. Get Nagarajappa. Pass.
8.
I'm appearing for respondent number 2 and 3, ma'am. I have filed my statement of objection. Matter has to be heard, ma'am.
List the matter in B group on date code.
17.
Yes.
Please.
Serial number 9. 9.
Respondent.
Connected.
1606.
Yes.
The petitioner, my lord, is a developer, my lord.
Connected matter, sufficient.
Connected matter.
First matter,
6.1.
first matter is concerned, I filed the objection already, my lord. Second matter is objection ready, objection not yet filed. So
Like-
their contention only for the not given opportunity is concerned. That is concerned, I have no objection.
That's
Remand
right.
the matter. So main matter is concerned, I will file the objection.
That's right, my lord. I'm only on that short point. I'll just point out, my lord, what has happened and then, my lord, subject to what, my lord. My lord, we are the developers, my lord. We have developed a layout. We have purchased in the year 2005, obtained sanction plan from the then local body, my lord.
Lord, submission one, my lord.
May I just, my lord?
Please, please.
My lord, I had obtained a sanction plan and formed a layout, my lord. Then the chief administrative officer, my lords, of the Gram Panchayat, my lords, would write a letter, my lords, to the deputy commissioner, saying that the layout that is formed is in violation of the sanctioned plan. He does not say direct them to bring it in conformity with this layout plan. He says, resume the land back to the government.
No, but that appears to be the provision, isn't it?
No, minutes. Under the first, my lords, they'll have to issue a notice and direct me to bring it. No such notice. He only writes to the DC, my lords. My lords, the deputy commissioner would issue a notice to me, my lords, annexure M, saying that this is the allegation that your layout is not in accordance with the sanction plan. What do you have to say about it? We submit our reply. Now, my lords, DC has passed an order saying that the layout plan is sanctioned by the local body. Therefore, your conversion order itself is cancelled.
No, which is the section?
Millet,
Which is the section authorizing him to take action in case of violation of layout plan?
there is no provision, Millet, for the deputy commissioner.
No, but there is some section, isn't it?
No, Millet, not for the deputy commissioner.
correct.
To cancel the conversion, Millet. Today I am aggrieved only by cancellation of conversion. And the deputy commissioner, Millet, in his order would say that no reply is submitted by these petitioners. Though, Millet, there is admittedly a reply which we have submitted along with the seal of the deputy commissioner.
Annexure?
Millet, impugned order is annexure C, Millet. May I just, to that relevant page is page 25, Millet.
Now, under the Town Planning Act,
Yes,
in case the layout is in violation, there is a provision to institute for institution of proceedings. Which
yes.
is,
Millet, under that, what they'll have to do is they'll have to first conduct a survey, Millet, under the Town and Country Planning Act. 74.
Section 17.4, my lord.
74, Town and Country Planning Act. Put
Yes, Millet.
section
74.
17.4.
Planning Act.
First,
read.
please, my lord. If any person does agree work with a contravention of subsection 1 or contravention of the modification of and condition of the sanction granted under subsection 2, or despite of refusal of the sanction under the said subsection, the planning authority may direct to such person to by notice writing to stop any work in progress, and after making an inquiry in the prescribed manner, remove or pull down the any work or restore the land. It is the original
Now,
condition.
who has the power to for the initiation of these proceedings?
Please, my lord, planning authority, my lord. Section 30, my lord, is a procedure, my lord, in the, my lord, 1965 rules is there, my lord. As per the rules, my lord, the planning authority initiate action regarding them. That.
So who is the planning authority? I mean, director of town planning?
Town planning, my lord. Director of town planning, my lord.
Director of town.
Here, my lord, this case, my lord, the planning authority.
Just one. Under what rules?
My lord, section 36 of the, my lord, Karnataka planning authority rules, my lord, 1965. Rule 1936. A. Sorry, 36, my lord, 37. 1965 rules, my lord. Karnataka planning authority rules, 1965. 37. 37. 37. The manner of inquiry under sections 15.4 and 17.4, my lord. 15.4, my lord, building is concerned, my lord. 17.4, layout is concerned. Any inquiry under subsection 4, for section 5 or subsection 4 of the section 17 shall be conducted in the manner of prescribed this rule. The planning authority shall serve the notice writing report a person.
Planning authority under the rule means director of town planning.
Please. Planning rules, my lord, 1965 rules.
Here, my lord, it would fall now. Today, my lord, it would fall within the jurisdiction of Bangalore International Airport Authority. So they buy up, my lord. Therefore, my lord, one, it is without jurisdiction, without hearing me. All that I'm praying, my lord, subject to, my lord, all.
So what's the order passed now?
Order passed is for cancellation of my conversion, my lord.
Cancellation of conversion.
Conversion order.
Just take me to the impugned order.
So great. Let the
Page.
I'm sorry. Impugned order relevant page is the operative portion, my lord, this page 28, my lord. I'm just taking your lordships to the operative.
In the preamble, just show us, let us see what they say.
Yes, my lord. My lord, page 23, it starts, my lord. Page 23, the first paragraph, my lord.
Yes.
They talk about, my lords, the letter where they have identified, my lord, certain illegal plots in the layout. In the middle, your lordship, 12 ಅಕ್ರಮ ನಿವೇಶನಗಳನ್ನು ವಿಂಗಡಿಸಿ ಈ ಪೈಕಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಆಸ್ತಿ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಬಿ ಬ್ಲಾಕ್ ಸಂಬಂಧಿಸಿದಂತೆ 3 ಖಾತೆಗಳನ್ನು ನಮೂದಿಸಿದ್ದು, ಉಳಿದ ಅಕ್ರಮ ನಿವೇಶನಗಳಿಗೆ ಖಾತಾ ದಾಖಲಾಗಿರುವ ಬಗ್ಗೆ ಜಾಲಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ ಯಾವುದೇ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಬಗ್ಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸಭಾ ನಡವಳಿಕೆಗಳು ದಾಖಲಿಸಿದೆ.
Yes, yes. So it's basically allegation is second line. ನಾಗರಿಕ ಸೌಲಭ್ಯ ಮತ್ತು ಉದ್ಯಾನವನಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿದ so and so.
Yes.
In that you have made.
Yes, my lord. Then, my lord, from page number 24, my lord, they talk about the orders by which it has converted and I am purchased.
Conclusion.
Yes, my lord. My lord, page number 25, my lord.
Conclusion.
Yes, page 25, one relevant portion. Point number 8.
Yes.
ದಿನಾಂಕ ಸೋನ್ಸೋರಂದು ಸದರಿ ಬಡಾವಣೆಗೆ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಉದ್ಯಾನವನಕ್ಕೆ ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಗಳಿಗೆ ಕಾಯ್ದಿರಿಸಿ ಜಾಗದಲ್ಲಿ ನಿವೇಶನ ವಿಂಗಡಿಸಿ ನಿವೇಶನ ಸಂಖ್ಯೆ ಸೂಚಕ ಕಲ್ಲುಗಳನ್ನು ಹಾಕಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದರೆ ಯಾವುದೇ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಿಲ್ಲ. Therefore, admittedly, my lords, no construction even on the CA sites, alleged CA sites. Next paragraph. ಒಟ್ಟಾರೆ ಈ ಬಡಾವಣೆ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಹಾಗೂ ಉದ್ಯಾನವನಕ್ಕಾಗಿ so and so. Again, my lords, they go saying that these are last but one paragraph in that page, my lords, they note that though notice was issued, no reply is submitted by these. Last but one paragraph in that page. ಸದರಿಯವರು ದಿನಾಂಕ so and so ವಿಚಾರಣೆ ಹಾಜರಾಗಿದ್ದು ಯಾವುದೇ ಲಿಖಿತ ಸಮಜಾಯಿಷಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಪ್ರದೇಶ ವಸತಿ ವಲಯದಲ್ಲಿ ಇರುವ ಬಗ್ಗೆ ದಾಖಲೆ.
Where is that?
Last but one paragraph.
Yes, yes.
The DC would note, my lords, it is not, they have not submitted any reply to the notice that we have given.
But they also say that the very sanction of the layout itself is illegal according to them.
That's right.
The plan is, my lord, not sanctioned the planning authority, my lord. Kindly see annexure.
No, correct. We are not on the merits.
Please.
So one is that in area of civic community and parks, sites have been made. That is, if you take the plan to be correct.
My lord, correct. That's right.
One first premise
Please.
is that even if you take the plan, there are sites and khatas given in areas which is reserved for public purpose.
Park CS sites, road center.
Then second, he says it's not, it's not approved by the sanctioned authority.
Please.
Okay, now, in case of this, who is the jurisdictional authority?
The planning authority by appointment.
Planning. That is under same 17.4 read with
please, rules.
65 rules.
See rules, man.
May I make this? Bayappa came much later.
No, my lord. In the year of 1990 itself, my lord, Bayappa is there, my lord. Before that, my lord, BMRD is there.
May I just make the assumption? Bayappa came much later. My sanction plan is by the local body, my lord, local authority. Now, my lords, the first argument of theirs, my lords, that it is formed in a CA site. My lords, CA site can be identified only when there's a sanctioned plan. Now, my lords, they rely upon the sanctioned plan to say that this is a CA site. In the CA site, you have formed residential sites.
No, correct. Now we are on the point
of natural justice. Yes.
1, 2. Who is the competent authority?
My lord, kindly see, my lord, 336 of the annexure, page number.
Page
336. Annexure H1, man. The first petitioner, my lord. In the year, my lord, 25/4/2006 itself, my lord, you have given endorsement. 336, my lord. 336. Annexure H1, my lord. The endorsement given by them by Bayappa, my lord. May I read, man? ವಿಷಯ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕುಂದಾಣ ಹೋಬಳಿ ಸಿಂಗನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ so and so ಒಟ್ಟು 8 ಎಕರೆ ವಸತಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಬಗ್ಗೆ. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದೆ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕುಂದಾಣ ಹೋಬಳಿ ಸಿಂಗನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಒಟ್ಟು 8 ಎಕರೆ 13 ಗುಂಟೆ ವಸತಿ ಪ್ರದೇಶ ವಿನ್ಯಾಸ ನಕ್ಷೆ ಅನುಮೋದನೆ ಕೋರಿ ಅರ್ಜಿ ಮತ್ತು ಅದರೊಂದಿಗೆ ಲಗಿಸುವ ದಾಖಲಾತಿಗಳನ್ನು ದಿನಾಂಕ 17/4/2000 ನಡೆದ ಪ್ರಾಧಿಕಾರ 27ರ ಸಭೆಯಲ್ಲಿ ವಿಷಯ ಸಂಖ್ಯೆ 27.5ರಲ್ಲಿ ಮಂಡಿಸಲಾಗಿ ಪ್ರಾಧಿಕಾರ ಸಭೆ ನೀಡಿದಂತೆ ಪ್ರಸ್ತಾವನೆ ವಲಯ ನಿಯಮಗಳಿಗೆ ಅನುಗುಣವಾಗಿಲ್ಲದ ಕಾರಣ ನಿಮ್ಮ ಪ್ರಸ್ತಾವನೆಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. If my lord, they say that much later Bayappa is constituted, my lord, why should my lord they give an application to the Bayappa?
Now,
Yes, after the local.
Just one.
Yes,
The village plan was, according to you,
334 and 330.
was approved which year?
My lord, in the year, index, my lord, 2006.
2006,
my lord.
19?
19/5/2006 is the provisional. The final plan is 7/12/2007.
Now.
Yes.
Now the action must be initiated according to you by whom?
Planning authority, my lord, regarding 97 itself, my lord, the planning authority is constituted as per the government order, my lord, 15/5/1997. 15/5/1997.
So then whichever is the planning authority, let it go before the planning.
That's right, my lord. One is, my lord, on planning. My lord, I'm not on the question of planning. They are not taking action to demolish. Now, my lords, the problem is,
correct. So what
DC has directed for cancellation of my conversion order.
No, correct. So what we are seeing.
Insofar as conversion, my lords, neither any notice was issued, nor was I heard. And whatever reply I had submitted is also said to be, my lords, not given to them.
No, just 1 minute. Now, the Yogesh.
Please.
Now, it appears that though the DC has cancelled the conversion order, essentially a dispute relating to plan sanction and its violation. If according to you, it's the director of town planning under the rules.
Please.
Then this order would go and then liberty reserved to the planning authority that
Bayappa.
Appropriate proceedings while reserving rights of the DC to take action in accordance with law at an appropriate stage.
Please, my lord, my respectful submission before that, my lord, the DC, my lord, formed on committee to regarding this case is concerned. Kindly annexure B, my lord.
Annexure?
B.
Annexure B.
Now
page 23, my lord. May I read, my lord? My lord, ಪ್ರಸ್ತಾವನೆ, my lord, first I say that, my lord, the ನಾಗರಿಕ ಸೌಲಭ್ಯ ಮತ್ತು ಉದ್ಯಾನವಕಾಶ ಅನಧಿಕೃತವಾದ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಿರುವ ಸಂಬಂಧ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕಾರಿ, my lord, the petitioner itself, my lord, the notice issued, my lord, inquiry, my lord, they have given notice, their party, my lord, in ಪ್ರತಿವಾದಿಗಳು ಅಂತ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, petitioners all their party.
That is not in dispute. Who
Please,
is
my
the jurisdictional authority in case of sanction plan?
Please, my lord. Regarding, my lord, Bayappa is a sanction authority, my lord. The Panchayat also, my lord, have power to under 64 of the, my lord, Act to regarding only if, my lord, the plan is as per the plan, they are not develop the plan, develop the buildings, my lord. Here, what happened, my lord, we are not respectfully, my lord, in the year of 26 years itself, I reject our application, their applications. Now they say that, my lord, 69 conversion order is, my lord, cancelled. By here, my lord, they are not challenging that order. Here, challenging, my lord, report. Kindly see Annexure A.
Annexure A is the impugned order. Annexure A, page number 28. That is the order and the challenge.
So now, if according to you, the plan given by the village panchayat, if according to you is without jurisdiction.
Please.
Then who's the authority? Again, planning authority.
Please, ma'am.
Who can then recommend to the DC, if at all,
Please,
they find some development has been, they can recommend it.
Please, my lord.
So now we could set aside the order.
Please.
Refer it in terms of 17.4 read with rules.
Please.
Let him examine. If case is made out to initiate appropriate proceedings, he may initiate appropriate proceedings, and if required, it's up to him to refer it to the DC as per law if circumstances are made out.
Please, my lord.
That's
Look.
all.
May I make this request? what would happen is, the moment Gram Panchayat has given a plan, it is not approved by Bayappa. My request for approval of the plan that is already sanctioned can be made to Bayappa, and Bayappa, my lords, can take a decision whether to approve or not to approve it. Now, annexure H that was pointed out, my lords, only said that the relevant documents are not on
No, my
record.
lord, not like that, my lord. The
No, but now rightly or
Yes,
wrongly,
that's right.
order is passed by the DC.
Yes,
That will have to go.
yes,
All aspects would have to be kept open.
yes.
And then if it is,
Appropriate action by appropriate authority.
if it is the planning authority is of the opinion that there is some illegality, they can do it. During the course of exercise of power, if they have to refer it to any revenue officer, as per law, we leave it open. All contentions will be kept open. You can take, in the meanwhile, whatever steps you want, you can take.
There is
After,
one
my
other
lord,
request.
now that plan cannot be, my lord. We are approving, my lord, because, my lord,
Left to the Bayappa.
That I will not say anything.
please,
I will say that petitioner is at liberty to explore whatever avenues in the interregnum and leave it as is
Yes.
permissible under law and leave it.
There's one more request.
Case,
Now,
my lord,
what
I
has
filed
happened
up-
is,
I
my lord,
filed
just,
different-
just before he says that, now what has happened is, my lords, third party rights are being created. My lords, till a decision is taken, let there not be any third party rights, because now if they have to hear, now,
Who's creating third party?
my lords, the builder has already sold in the year 2007 to several persons. Annexure P is the list. Now, my lords, they are the owners of the site. Now, those owners, my lords, are trying to create third party rights.
Now, we don't intend to court, neither court nor Yogesh's client nor Devraj's client will enter into the private dispute.
My lords, if
Now, it is for the planning authority whose reserved liberty to take appropriate action to pass necessary orders in order to prevent creation of third party rights.
My lord,
Yes.
I have filed application for impleading.
Let us see, I'm disposing it off. I'm not passing any order on merit. Yes.
Says that, back in year 2007 itself, I purchased the site. And it was a modified plan has been issued, so again, an exchange of site has been made.
No, correct. So all rights, now still, as of now, once we set aside the order at annexure, there is no order. All persons with any interest are at liberty to appear, and the planning authority will give an opportunity of hearing before any order is passed. Yes. Yes. Yes.
I have filed impleading application, my lord.
Correct. I'll dispose it off, keeping all contentions open. Yes. I will not get into that. Now, if you take a decision, you take a decision. The WP 21755 has been passed. Seeking for issuance of writ of certiorari to set aside the order. Annexure L page. To set aside the order of the Zilla Panchayat. Chief Executive Officer of the Zilla Panchayat. Dated 7/8/2021. But that is different from the. Yes. Of the Chief Executive Officer of the
Submission,
Zilla
my lord.
Panchayat, Bengaluru.
Lord, one submission. First prayer, my lord, annexure is concerned, my lord, is internal communication.
No, I'm on the first trick. Just
Please, please.
Just one.
Please,
Just
please.
one.
Annexure.
Whereby the Chief Executive of the Bengaluru Rural Zilla Panchayat, after taking note of various communications with the Deputy Commissioner.
The same. 16 or 6.
Has observed that sites have been formed in the area reserved for parks and civic amenities. which is illegal. And also that records are not available regarding issuance of kata in the office of the Gram Panchayat. And accordingly, has decided to set aside Form 9 and 11 with respect to sites formed in CA area reserved for civic communities and park, with further direction to the Gram Panchayat to take possession of the same and declare the land as belonging to the Gram Panchayat. Now, this order is complete in itself or has to be ratified by the DC? So this by itself, no, just one. This by itself is not an actionable order. No, just after this, nothing has happened. Full stop. It is seen that the order at annexure L is in fact a communication to the Chief Executive Officer, Taluk Panchayat, Devnalli. Annexure L, page 60. And acting upon such order / communication, it is submitted that the Deputy Commissioner has passed an order in case number LND CR 71/21-22 dated what is the date of this order? 12/11/2021.
Annexure A, page number 21.
Full stop. The said order of the Deputy Commissioner has been challenged in WP 1606 of 2022. As both the writ petitions have an identical factual matrix and relief sought for are intertwined, and the challenge is to common proceedings relating to violation of planning rules. Both are taken up together and disposed of by a common order. Full stop. It is to be noticed that the order of the Deputy Commissioner, which is the actionable order as on date, is assailed on various grounds, including that the Deputy Commissioner lacks jurisdiction to entertain disputes relating to invalidity of plan issued by the village panchayat, as well as violation of the sanctioned plan or rules pursuant to which plan has been sanctioned. Various contentions have been raised, including that there has to be a finding, one, as to whether plan issued by the village panchayat is lawful and legal. Two, if it were to be so, that the plan is held to be lawful and legal, whether the violation and provisions of the sanctioned plan is actionable, and if so, by whom. Next, without entering into the merits of the matter, it is to be noticed that in terms of section 17(4) of the Karnataka Town and Country Planning Act, if any work is taken up in contravention of section 17(1) or in violation of the conditions of sanction under subsection 2, necessary action may be taken after an inquiry. Full stop. Section 17(4) reads as follows. The mode of exercise of power is governed by the Karnataka Planning Authority Rules 1965 and Rule 37 prescribes the manner of inquiry under section 17(4). Rule 37 reads as follows. Next. Admittedly, in the present case, the authority to take any action prima facie would be the authority under planning authority under section 17(4), which is the Bayappa. Full stop. Once matter is taken up by the authority for alleged violation of sanction plan or as regards proceedings regarding development without sanction plan, if the planning authority is of the view that the proceedings have to be initiated by the revenue authority or any other authority as is permissible under law, it's always open for the planning authority to take an appropriate decision. Next, accordingly, the order of the Deputy Commissioner at Annexure A in WP 1606 of 2022 is set aside. The liberty is reserved to the planning authority to take action in accordance with law in terms of the observations made above. Needless to state, the order at Annexure A is being set aside only on the ground that it is not the appropriate authority in light of existence of plan, validity of which is still to be decided. Accordingly, all contentions are kept open and proceedings are disposed of as not calling for any, as not calling for adjudication on merits, while leaving open for the concerned authorities to take appropriate action. Needless to state that the planning authority or any other authority which takes up proceedings as is permissible under law cannot pass any order without hearing all affected parties, which would not only include landowner, developer, but site holders in the site holders who have derived any title.
Those who are owner, my lord, because developer now, my lord, they are not, my lord. Please.
It is for the planning authority or appropriate authority which may institute proceedings to pass appropriate directions regarding creation of further third-party rights which may prejudice the inquiry.
My lord, regarding, my lord, third party is concerned, my lord, the panchayat is very known about, because, my lord, the khata will change there, my lord.
Correct, appropriate authority.
Please. Lord, 65A, my lord, I'm just, my lord, academic reason, my lord, to the Panchayat Raj Act, my lord, in respect of Panchayat itself, my lord, any development, my lord, read with this section, term and control, 65A, my lord. 64 5A.
64?
64 5A, my lord.
Yes.
Lord, the Gram Panchayat shall strictly comply with the provision of the Town and Country Planning Act 1961. The matter issue in the building lines or approval housing residential layouts any approval in violation of any provision of the town and country planning shall be constituted, my lord. It is, my lord, pertaining to, my lord, my respectful submission is, my lord. Even, my lord, they will give, my lord, the concurrence with the planning authority only there, they cannot be given on the plan.
Correct. In
Please.
fact,
Please, my lord.
under the provisions of Town and Country Planning Act,
Please,
it overrides all the other laws.
please, my lord.
Section
76 M2B, my lord. 76 M2B, my lord. On that regard, my lord, Apex Court have a judgment also. My lord.
76
M, my lord. M2B, my lord.
76 M2B.
M, my lord. M2B. M, my lord. Effect of other laws, my lord. 2, my lord. B, my lord. When permission for such development has not been.
That's why primarily we have referred to the planning authority.
Please, please. And also in that regard, my lord, the Apex Court judgment also there.
One the paragraph had. The planning authority has been referred to as the authority to take action also at the first instance, also in light of the legal mandate under section 76M of the Karnataka Town and Country Planning Act 1961, by virtue of which it is the provisions under the Town and Country Planning Act and the rules and regulations and bylaws made under which would have an overriding effect over other laws.
Please, ma'am.
Yes. Let us see that you will be given a hearing, web officer. Yes. Let us. Yes. And the IA for impleading is disposed of as the impleading applicants are always at liberty to seek for an opportunity of hearing before the authorities concerned, who may take any action pursuant to the directions made above. Yes. Yes, yes.
Serial number 10, Mallappa PM, Devaraju.
Petitioner.
Now respond.
I am for the respondent's part, sir.
Yes. Annexure.
Eradu disposal of.
What is the order passed? Now, how do you claim title?
One ಬರೆದಿದ್ದೀನಿ ಕನೆಕ್ಟೆಡ್ ಬರೆದಿದ್ದೀನಿ ಬರ್ದಾಯ್ತು ಒಂದೇ ಒಂದು ಬರೆದಿದ್ದೀನಿ ಇನ್ನೊಂದು ಆಗೋದು ಸೆಕೆಂಡ್ ಒನ್ ಆಗಿದೆ
ವಾಸ್ತವವಾಗಿ ಉತ್ತರ ದಕ್ಷಿಣ 12.5 ಅಡಿ ಮನೆ ಇದ್ದು ದಕ್ಷಿಣ ಭಾಗದಲ್ಲಿ ಕಲ್ಲಿಯನ್ನು ಸೂಚಿಸುವ ಖಾಲಿ ಜಾಗವಿದ್ದು ಅದರಲ್ಲಿ 4.5 ಅಡಿಗಳ ಜಾಗವನ್ನು ಹಕ್ಕುದಾರರಿಗೆ ಸೇರಿಸಿದರೆ ಅಕ್ಕಪಕ್ಕ ಮನೆಯವರು ಓಡಾಡಲು ಮತ್ತು ತರಕಾರಿಗಳನ್ನು ಸಂಸ್ಕರಿಸಲು ಸಾಧ್ಯವಾಗದಂತೆ ಕೇವಲ 2.5 ಅಡಿ ಅಗಲ ಕಲ್ಲಿ ಉಳಿಯುವುದರಿಂದ ನೆರೆಹೊರೆಯವರಿಗೆ ತೊಂದರೆಯಾಗುವ ಬಗ್ಗೆ ವರದಿ ನೀಡಿರುತ್ತಾರೆ. On the basis of that, Your Honor, but the franchise was allowed to enter the data of the respondent number 5 to 7 in their name and try to block the road. And I am not party to the specific. There is a specific statement was given by the authority stating that there is no road to reach.
No. What is the order passed now?
The order
No. What is the effect now? What have they done in the appeal proceedings?
That is one page. On submission.
But,
No, just.
There is no locus standi to file this writ petition. First point. Second point is kindly see the order portion, page number 25, my lord. Order portion. ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಒಳಗೊಂಡು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು, ಅಪೀಲಿದಾರರು ಸಲ್ಲಿಸಿರುವ ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರದ ಸಂಖ್ಯೆ 831ರಿಂದ 834 ಕ್ರಯಪತ್ರದಲ್ಲಿರುವ ವಿಸ್ತೀರ್ಣ ಮತ್ತು ಚಕ್ಕುಬಂದಿಗಳನ್ನು ಆಧರಿಸಿ 1ನೇ ಅಪೀಲುದಾರರ ಶ್ರೀಮತಿ ಗಂಗಮ್ಮ ಲೇಟ್ ಕರಿಯಪ್ಪನವರ ಎದುರಿಗೆ ನಿಯಮಾನುಸಾರ ಪೌತಿ ಆಧಾರದಂತೆ ಈ ಖಾತೆ ದಾಖಲಿಸಲು ಎದುರುದಾರರಾದ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿಕಾರಿ ಅಜ್ಜನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ರವರಿಗೆ ನಿರ್ದೇಶಿಸಿ ಸೋನ್ಸ ಅಂದ್ರೆ ಪೌತಿ ಖಾತೆ ಮಾಡೋದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಓನ್ಲಿ ಫಾರ್ ದೇ petitioner are not party to the proceedings before the trial court, appellate court, and also they are not the owner. And also kindly see the annexure.
may I make one submission?
Annexure C, page number 23.
Devraj is arguing.
Based on the inheritance.
I'm saying Devraj is arguing for you, so you wait.
Please.
Annexure C.
Annexure C, Manash. 2, Anmegowda, he is the petitioner. Subject Ajjanhalli ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯ ಗವಿನಾಗಮಂಗಲ ಗ್ರಾಮದ ಶ್ರೀ ಲೋಕೇಶ್ ಬಿನ್ ಕರಿಯಪ್ಪರವರ ಪೌತಿ ಖಾತೆಯ ಬಗ್ಗೆ. ನೆಕ್ಸ್ಟ್ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಮನಗರ ಜಿಲ್ಲೆ ಮಾಗಡಿ ತಾಲೂಕು ಮಾಡವಾಳ ಹೋಬಳಿ ಅಜ್ಜನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯ ಗವಿನಾಗಮಂಗಲ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಶ್ರೀ ಲೋಕೇಶ್ ಬಿನ್ ಕರಿಯಪ್ಪರವರು ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಪ್ರಕಾರ ತಮ್ಮ ತಂದೆಯವರಾದ ಕರಿಯಪ್ಪರವರ ಹೆಸರಿನಲ್ಲಿ ಇರುವ ಆಸ್ತಿಯನ್ನು ತನ್ನ ತಾಯಿ ಹೆಸರಿಗೆ ಪೌತಿ ಖಾತೆ ಮಾಡಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಾಗಿ ತಿಳಿಸಿರುವುದು ಸರಿಯಷ್ಟೇ. ಆದರೆ ಸದರಿಯವರು ಪಂಚಾಯತಿ ಈ ಸ್ವತ್ತು ಮಾಡಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಅರ್ಜಿಯಲ್ಲಿ ಖಾಲಿ ನಿವೇಶನ ಅಳತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 46 ಅಡಿಗಳು, ಉತ್ತರ ದಕ್ಷಿಣ 36 ಅಡಿಗಳು ಹಾಗೂ ಕಟ್ಟಡ ಪೂರ್ವ ಪಶ್ಚಿಮ 41 ಅಡಿಗಳು, ಉತ್ತರ ದಕ್ಷಿಣ 31 ಅಡಿಗಳು ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಮಾದರಿ ಮಾಡಲು ಇವರ ಕಟ್ಟಡಕ್ಕೆ ನೀಡಿರುವ ಅಳತೆ ಉತ್ತರ ದಕ್ಷಿಣಕ್ಕೆ 31 ಅಡಿ ಸರಿಯಾಗಿದ್ದು ಇವರು 32 ಅಡಿಗಳಿಗೆ ಈ ಸ್ವತ್ತು ಮಾಡಲು ಕೋರುತ್ತಾರೆ. ಆದರೆ ದಕ್ಷಿಣಕ್ಕೆ ಸಾರ್ವಜನಿಕ ಇರುವುದರಿಂದ ಸದರಿಯರ ಕೋರಿಕೆ ಪ್ರಕಾರ ಈ ಸ್ವತ್ತು ನೀಡಲು ಸಾಧ್ಯವಿರುವುದೆಂದು ಈಗಾಗಲೇ ಅರ್ಜಿದಾರರಿಗೆ ಮೌಖಿಕ ಹಾಗೂ ಲಿಖಿತವಾಗಿ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ.
Instead of 36 feet, you have given e-khata only for 31 feet.
Yes.
Leaving out 5 feet.
Yes.
Yes. Now 5 feet is left.
But, the short point is, short point is, in the year 1968.
No,
as per
No, just 1 minute. Now, out of 36 feet, e-khata is given for 31 feet.
36 feet. The kata was already there. I have produced the document at annexure R7.
That may be.
My lord, may I make one
Just one
submission?
minute. Now, in terms
In
of.
the year
No,
1968.
just 1 minute. In terms of annexure C, your application for kata was 36 feet.
Please.
However, by annexure C, they've registered kata only to 31 feet.
No. Construction was for 31 feet. Construction was for 31 feet. The vacant space was another 5 feet. My lord, under this registered sale deed of the year 1968, 12 yards into 25 yards was purchased.
No, you read the last sentence. Read the last sentence in annexure
Yes.
C.
Annexure C.
Last sentence. 4th line from the bottom. Sadari ಸ್ಥಳದಲ್ಲಿ
ಕಟ್ಟಡಕ್ಕೆ ನೀಡಿರುವ ಅಳತೆಯು
ಅಲ್ಲ ಸರ್
ಕಟ್ಟಡಕ್ಕೆ ನೀಡಿರುವ ಅಳತೆಯು ಉತ್ತರದ ದಕ್ಷಿಣದ ಅಳತೆ 31 ಅಡಿ ಸರಿಯಾಗಿತ್ತು.
ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಮಹಜರ್ ಮಾಡಲಾಗಿ ಇವರು ಕಟ್ಟಡಕ್ಕೆ ನೀಡಿರುವ ಅಳತೆಯು ಉತ್ತರ ದಕ್ಷಿಣ ಅಳತೆ 31 ಅಡಿ ಸರಿಯಾಗಿ
ಅದು ಕಟ್ಟಡಕ್ಕೆ
ಜಸ್ಟ್ ರೀಡ್ ದಟ್ ಸೆಂಟೆನ್ಸ್
ಸರಿಯಾಗಿದ್ದು ಇವರು 36 ಅಡಿಗಳಿಗೆ ಈ ಸ್ವತ್ತು ಮಾಡಲು ಕೋರುತ್ತಾರೆ. ಅಂದ್ರೆ ಇವರು
ಓದಿ ಅದನ್ನ
ಕೋರುತ್ತಾರೆ. ಆದರೆ ದಕ್ಷಿಣಕ್ಕೆ ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಇರುವುದರಿಂದ ಸದರಿಯವರ ಕೋರಿಕೆಗೆ ಪ್ರಕಾರ ಈ ಸ್ವತ್ತು ನೀಡಲು ಸಾಧ್ಯವಿರುವುದಿರುವುದು ಈಗಾಗಲೇ ಅರ್ಜಿದಾರರಿಗೆ ಮೌಖಿಕವಾಗಿ. ರಾಷ್ಟ್ರಪ kindly turn to annexure R1.
So e-khata is given to what extent now?
Based on the inheritance, the kata was already there.
Correct. E-khata now has been given for 36 feet or 31 feet.
36 feet.
They've given it.
36. Your Lordship may kindly, under annexure R1, one Tirumalegoda had purchased 12 yards into 25 yards. It is in the year 1968. Thereafter, the husband of the fifth respondent had purchased the very same property as per annexure R2 in the year 1978. Thereafter, the kata was effected in favor of.
No, just 1 minute. Now you'll have to go to the civil court and establish a right of way.
Right, yes, to, because my
just-
kata was already there.
Just 1 minute. Now you'll have to go to the civil court and establish a right of way.
Please let
If-
him establish it.
ಸ್ವಲ್ಪ ಇರ್ತೀರಾ? ಸ್ವಲ್ಪ ಇರಿ. If the sale deed says 36 feet into whatever, and if you are claiming a right of way, then you have to claim your easementary right by initiating appropriate proceedings. Revenue authorities cannot adjudicate.
Let him establish.
Maybe, we don't do.
Annexure R7.
No, maybe, but you cannot establish that in these proceedings. It's only kata. Kata will have. You are not required. If the sale deed shows 36 feet, it will have to be done 36 feet. Firstly, secondly, on the ground that is only pavati, only on the death of the person.
Yes.
Whatever the previous kata is, the same extent will have to continue.
Yes.
In these proceedings, we cannot go beyond the previous kata. If you have a right of way, then you will have to go to the civil court.
Yes.
Now the kata is done as per the sale deed.
Yes.
Correct.
ಅಲ್ಲ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಸೇಲ್ ಡೇಟ್ ಖಾತಾ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
That the revenue authority cannot do anything. They have no.
I am
juris-
told that he has encroached forfeit, whatever be the case.
No, just wait. You just wait now.
Yes.
Now, once the sale deed is there, revenue authorities cannot interpret the sale deed. It's for you to carve out your right before the civil court. If you have an easementary right, even if it's being used as a road, revenue authority cannot do anything. I'll keep it open for you to take appropriate proceedings.
Yes.
That you must go to the civil court. I cannot protect you. They have kata and that cannot be cancelled because that's on the basis of sale deed.
He was nothing to do with the property. Why he should be a party?
The petitioner has filed the present petition seeking for setting aside of the order dated 21/12/2019 at annexure D. Full stop. The executive officer and appellate authority had entertained an appeal. By the fifth of respondents 5 to 7 filed against
on the western side, Sarkari Gully. Their own sale deed that shows that Sarkari. ಅಲ್ಲ ಅಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ಗೆ ಅಷ್ಟೇ ನಾವು ಕೇಳ್ತಾ ಇರೋದು ನಮ್ದು ಏನಿದೆ ಅದೇ.
Correct. That kata independently you can challenge. Now, rightly or wrongly, in terms of annexure D, kata has been given to them. No, you challenge it. Correct. So that kata you challenge independently. You need not be a party. It's on basis between them and the panchayat. Correct. You challenge that. No, you have to challenge the kata that is given to the private respondent. No, that we can't entertain here. If kata is given in violation of the sale deed measurement, or if you have a right of way that has not been taken note of, it's up to you independently to, I will not even say civil court. I leave it open for you. You take appropriate proceeding either before the civil court or by challenging his kata. I will not enter into that. But that is an independent right. You cannot intervene in these proceedings, which is between the PDO and him.
There is no locus standard to find the report.
Filed against the decision of the panchayat not to affect kata, full stop. The application for kata was made by the legal representatives of Karyappa.
Siddhappa alias Karyappa.
Of Karyappa.
Siddhappa alias Karyappa.
Full stop. The authority concerned has allowed the appeal and ordered for effecting of kata. Kata on the basis of on the basis of rights of the legal representatives of Karyappa.
Yes. No.
How? No, based on the inheritance. Why you're
On the basis of Pavati
Kata means
Kata, on the basis of
based on the
Pavati Kata.
inheritance?
I'll take note of Pavati Kata. It is the case of the petitioners that he has a property adjacent, that is on the southern side.
After the conservancy lane.
No, on the southern side.
On the south.
And there is a pathway existing adjacent to the constructed portion of the private respondents, which if blocked would result in the petitioner not having any place to move about. Full stop. Accordingly, the appellate order at Annexure D is sought to be challenged. Next, it is to be noticed that the scope of the proceedings at Annexure D is limited to the application of the legal representatives of Karyappa consequent to his death to effect kata on the basis of Pavati. Full stop. Needless to state that the authority has effected kata commensurate with the measurement as reflected in the earlier kata standing in the name of Karyappa. Full stop. If it is the case of the petitioner that his right of way has been encroached, it is up to the petitioner to take appropriate proceedings independently to challenge either the kata or work out his remedies before the civil court as may be deemed appropriate. Full stop. Accordingly, in light of the limited scope of the order at Annexure D, the court in writ proceedings cannot enlarge the scope of the proceedings at Annexure D in the present proceedings. Accordingly, the petition is rejected, while while the petitioner's grievances are left open to be raised before the appropriate forum. Accordingly, petition is disposed of. No, that you work out your remedy. Yes.
11. Radhanandan BS, Yogesh Nayak.
Yes, my lord, I will take instructions, my lord. To my lord, they will consider, my lord, within 1 month, my lord. No, my lord.
Huh?
My lord, they are placed before the authority meeting, my lord. That is the reason, my lord, they say that, my lord, within 1 month, my lord, they will consider it.
No, what is the prayer?
Shown in the proposed master plan, the proposed law was sought to be relinquished in the remark this also is automatic this to hold that if it is a proposed law in the master plan that cannot be relinquished to a past. Plus other matters that's already disposed of also as well as in the interface. Now, in this matter, there is an interim order already passed on 6/1/2025 that the petitioner has made out a prima facie case And therefore, it will say the portion of the issue not be required to the legal state. And authority is directed to the which are necessary to enable the public. When we met them several occasions, they say time bound
That not listed, they are not stated like that, my lord. They say that, my lord, my plan code prudence. There is, my lord, they say that, my lord, immediate you should issue the plan ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಅವರು ಏನು ಹೇಳಿದ್ದಾರೆ, my lord, they will proceed before the authority meeting, we will pass within 1 month ಹೇಳಿದ್ದಾರೆ.
Now, when was that order passed? Page? In the same. No, so now what? Now you are seeking IA for modification of the interim or a direction.
Direct them, compile the order within
How much time you want?
Weeks, 1 month time, my lord, thought, my lord.
So let us see.
Regarding, my lord,
No, that you are saying we don't know. We are not sitting in the chair of the planning authority.
that is the reason, my lord, they say that, my lord, we are placed before the authority meeting. And my lord, then, my lord, we consider that to.
Without in light of the interim order, without insisting on that,
Please,
subject to compliance, whatever, at the earliest, not later than.
within one month.
No, let us see. It's not you or me who's the planning authority. Let them do it. But we'll keep the main matter pending because we have to decide.
Please, my lord, the main matter is concerned, my lord, I have an objection to regarding, my lord, our regulations very clear.
No, that we'll see.
Please.
That I'm not going to
Please,
decide. Other batch of matters there, similar questions.
Please.
The petitioner, though has filed IA 1 of 25, submits that there may be no necessity to modify the order as long as the planning authority takes note of the interim order dated 6/1/25 and proceeds to consider the application of the petitioner for grant of single layout plan.
Please.
No, just wait. My language is different. I'll come to that. Now, what is your main relief now? Main relief? Correct. Next, the order dated 6/1/25 reads as hereunder. Clearly, the purport of the interim order passed was to the effect that request of the petitioner was to be considered without insisting on relinquishment of land by the authority, subject to the conditions imposed in the said order itself. Full stop. The case of the petitioner, that despite the order having been passed on 6/1/2025, there is no progress of the petitioner's request having been considered. Full stop. Learned Counsel Yogesh Naik, upon instruction, submits before the court that the consequent to the interim order passed on 6/1/2025, the necessary orders would be passed in so far as the request of the petitioner is concerned within 1 month from today. Said undertaking is taken note of. It's made clear that the period of 1 month is an outer limit.
Please.
And if all formalities and clarifications are made before such date, it's open to the authority to expedite such consideration. Full stop. Deal is the matter after 1 month. Yes.
IA may be disposed.
Accordingly, no orders are called for on IA 1 of 25.
12, serial number 12.
Case may not appear for witness 5 and 6. Yesterday they have sent the parawise reply. My lord, 10 days time I request my lord to file the objection.
Huh?
ಇಲ್ಲ. No, they.
The At request of learned counsel are 5 to 7. Relist the matter on
10 days, my lord.
21st.
Much of.
Pleadings to be completed by respondent 5 to 7 by the next date.
Please.
Yes,
13 urgent 14, Chandrasekhar PV.
interim order in operation is extended till the next date. Yes,
14, Chandrasekhar PV.
yes. Put it.
That's 14.
Yes, Mahesh.
In terms of lecture F, is widening of the road. There's one division judge, but
No, now we have, you cannot do it except by acquisition. Kodi.
division bench judgment regarding the road margin also, that may be incorporated. Because road margin goes to PWD department. Fourth line in the first paragraph itself of the order.
Yes, read the relevant portion of that order.
Yes, I am just reading that. Page 3,
Yes,
fourth line from the bottom.
yes.
It has been further stated that no construction is permitted in no construction zone as per the circular issued by the state government dated so and so. No construction zone in respect of national limit up to 40 meters. State highway is up to 40 meters. District main road is up to 25 meters. The court by an order dated so and so, as the petitioner is neighbor of the private, this is all not necessary. Then your lordship will go to paragraph page 6. Page 6. 1, the same thing has been reiterated. No permission should also be granted also. The same thing is reiterated. And then if your lordship goes to page 7. Page 7, second from the top, my lord, the respondent authorities are directed to strictly comply with the conditions in annexure A, so that no construction is made on the highway within the limits prescribed therein. And they are further directed not to allow any construction to remain on the highways which are constructed within the prescribed limit. This is important. Within a period of 2 months from today. The next is also. Of course, we'll have to issue notice to them and say what is the construction made.
Yes, Manjuna.
Hold that,
SV Prakash case, SV Prakash one on the disbursement of highway. The directions.
Again, and if your lordship will see page 8. Page 8.
Yes.
In the light of the aforesaid judgment and also keeping in view the statutory provision and also as per circular dated so and so issued by government of the building constructed crossing the building line has to be demolished to the extent they are crossing the building line. The other important aspect of the matter is the authorities who have granted permission for such unauthorized also deserve. This is there.
So you make an inquiry.
Yes, we'll have to make an issue notice, make an inquiry, and then
under section 82, there must be an inquiry. Under section 82.
Yes, we'll have to make
an inquiry. And in that.
Because now my
correct.
submission is these roads where they were proposed to widen, they come under the PWD. They are state highways. though it is within the municipality, they are not yet handed over to the municipality. It is in their this thing. We only maintain the road. So the PWD also can take an action. And of course, the plan which has been granted, the municipality will be responsible for it.
Yeah, that we'll see. Now, under section 82
Yes,
of the Municipalities Act, an inquiry must be done by the authority.
and
And in the course of such inquiry, the fixation of building line and the encroachment and putting up of construction within the building margin, road margin, will also be a matter that you can consider.
Told that long back, the state highway notification came into exist, my lord. And these shops are in existence for nearly 30 to 40 years. And 20 meters, 21 meters from the road median.
Okay, I'll just read one observation made in another writ petition.
Yeah.
It also observed that the respondent authorities are directed to take note of the provisions contained in chapter 9 of the Act
Yes, ma'am.
relating to prescribing of building lines. If such building lines have not yet been prescribed, necessary steps to be taken.
yes.
What is this building line?
This is the building line,
20
meters, 40 meters, 30 meters from the center of the road. National highway, state highway
So the
and local.
building line will be prescribed, taking note of the road margin. That's how it is.
Yes,
Then you have a look whether this directions at para 5 are sufficient. You read it aloud.
yes, I have that. They have produced it.
Para 5, you just read that of para 5.
Appearing. It is undisputed fact that after hearing both sides, the matter is considered the proposal of Bangalore by the respondent is not to be influenced so far as the right, but rely upon the same as matter. This is the same thing. But this could be added, I said. This could be added to this because this has been produced by them. And this is annexure F which they have produced.
Annexure?
F.
So in terms of annexure F, we'll dispose it of.
And this point also may be observed.
But does it
That
come
the
within the?
division-
So the inquiry will also look into the road margin aspect.
Yes,
Annexure F page.
page 26. In the copy which they have given, it is 26.
No, the
No,
petitioner's property is demolished.
This is.
Now you take your stand, you file a memo stating in terms of the observation so and so orders may be passed. You will adhere.
What my learned friend is submitting, it is not the subject matter of this. If we have violated, they can take action against it. But so far as their building is concerned, petitioners, we are not going to touch now till we make an inquiry.
Now you put a memo. Correct, but you must file a memo with instructions. I'll take note of that and dispose it of.
Yes,
Tomorrow.
yes,
You can file a memo on telephonic instruction.
yes.
Relist tomorrow. Interim order earlier granted is
Yes,
extended
interim
to
order.
the next. Otherwise, I'll pass over, you file a memo.
No, I'll just speak to the commissioner
Correct.
and
Tomorrow.
yes.
List
but
the matter and preliminary hearing tomorrow.
15, Vasant Kumar HT, Pawan Kumar.
Check madam, from office.
Idu.
Huh?
ನೀವು ಬೇಕಾ? ಹೇಳಿ.
Correct. But have you at least maintained the building bylaw? No, just 1 minute. Now, No doubt we have given interim protection. Now you find out if they're putting up the construction in accordance with the building bylaws. If it is so, there ends the matter. If not, then you must make out a case that though there's no plan, nevertheless, it means that it has to be in accordance with the building bylaw.
There's a division bench judgment last time
Put
they
it,
said
put it.
that they have to apply for a plan.
Hmm? Yes, which paragraph?
Last paragraph. That bylaw 7.2 has been explained, my lords.
Just read.
I have one copy only also. The bylaw 7.2 is extracted, my lordship. Then finally, they have said that from the perusal of the aforesaid bylaw, it is evident that the aforesaid bylaw prohibits an authority from sanction of a plan for a residential detached building on a in a writ appeal number so and so plot measuring less than 50 square meters or having width less than 6 meters. The aforesaid bylaw does not exempt a person raising construction not to obtain a plan. So it doesn't give them an exemption. They have to apply for a plan is the judgment.
So they have to obtain a plan.
Obtain a plan.
Seven point two, no plan shall be sanctioned for residential detached building and a plot measuring less than 50 square meter or having width less than 6 meter. Bylaws of 7.2 is very clear.
No, correct, but there may be exemptions in case of EWS, LIG, slum clearance.
Whether they fall in that exemption is to be found out.
That has to be examined.
I will just take instruction whether they fall in that exemption.
Now, where is in which layout? Which layout is your site? Correct. Whether it's a layout of Ashraya sites.
Or to family partition or partition they have got.
No, correct.
If he was required for central association, he was a member of that association, he was allowed to say being member of the double two. The same was executed with the association.
So then that stand must be taken. You must also place material. Suppose it's a layout only of Ashraya sites, etc. Then you place it before them, let them take a decision. That you place before them.
And after lapse of 6 years, state collector issued the notice.
Let us see. The counsel for the petitioner has placed reliance on bylaw 7.2 of the BBMP building bylaws 2003. Bylaw 7.2 reads as hereunder. Accordingly, it is submitted that the petitioner is the owner of a site. Society, is it? Society has formed. Annexure? Is the owner of a site formed by the Karnataka State D Group Employees Central Association. It is submitted that the said layout formed by such society would come within the purview of bylaw 7.2, which envisages sites under housing schemes for certain sections of society, including of sites in densely populated areas and plots subdivided into family partition. The authority may relax conditions. Accordingly, the respondent BBMP to take its stand in writing as to the scope of 7.2 in the present factual matrix. Petitioner is at liberty to place further material before the respondent BBMP to enable it to take a decision. This is the matter in B group. After 2 weeks, interim order earlier granted is extended till the next date. ಅವ್ರಿಗೆ ಬರೀ interim order ಮಾತ್ರ ನೋಡ್ತಿರೋದು ಅವ್ರು ಬೇರೆ ಏನಾದ್ರೂ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಲಿ. No, that's okay. Yes, yes. Next.
16, Siddharth Suman.
Yes.
So what is the issue? Last time the grievance is that inspection is not done in their presence. And show cause and demand notices have been issued. I inquired with them, they said they will look into the file, but normally before show cause notice, we don't give any notices.
Correct.
Either a date may be fixed, we will do the inspection in their presence, and then the.
No, now is there any discrepancy in the go to
In the measurements, because
page 15.
as per my instruction, they have put up an extra floor, my lordship. That is not been shown in the assessment. So if the inspection is done in their presence, the things will be sorted.
Then let there be an inspection in your presence and then let them give a report. We'll see further proceedings. No, madam, what is it now? How are you going to be prejudiced by the order passed? We're only asking them to do a measurement in your presence. Let them give a report. We'll see what is to be done.
Stays there in their way. Stays there.
It is noticed that respondent BBMP has been directed not to take any precipitative steps as per the order dated 18/3/25. Learned counsel for respondent BBMP submits that this may be a case of a difference in the actual constructed area, as a result of which there may be a mismatch between what was declared by the petitioner and the demand notice. In light of that submission, there would be an inspection of the property in the presence of the petitioner. Respondent to make out measurement as regards to the constructed portion and take note of other aspects that may be of relevance to the assessment. For such inspection and measurement by the respondent BBMP, petitioner to be present before the PRO.
Yes, sir. We at the spot only, Malship, the scheduled properties, the commercial.
To be present at the site on
In the second week of April, because of financial year end, they are.
15th of April at 11:30 a.m. Assistant Revenue Officer to make out the inspection under his supervision and submit report to the court. Interim order, that is there. I have not said next date.
A date may be given.
Relist the matter. Yes, next.
17, Jay Prakash Rao.
Yes, office objections you have to clear. Our office always raises fresh installment.
Actually, it's going to expire within a 45 days. It has been issued on 19th February. It is going to expire on 3rd April. Very similar cases.
No, correct. Identical or any change? Which order? Where's the interim order? No, correct. I'm just saying, I'll give an identical order as in that. In pencil, you mark if there's going to be any change. In that order, you examine the demand raised in your case. I'll make an identical order. If it requires any change, make a pencil and then give it. No change. Ground rent. Pawan Kumar accepts notice for the respondent. Interim order as in WP 19623 of 2024. Office objections to be complied with prior to issuance of interim order.
18,
Before you collect a copy, you must finish.
18, Raghu Babu.
Annexure, page, page. Yes.
Number 18 of the order of the aforesaid petition deals as an area of the matter. These representations are the folder of upholding the action notification for issued by the respondent of three. It is open for the petitioner in the action. And
No, no,
if they are
correct.
not
Now what has happened?
action be conducted day after tomorrow. There are two modes of action. One is e-action and another one is the public action. E-action law, very similar, by government need. Notification law.
No, what is your grievance now?
They are not allowing me to participate. They are asking me the undertaking letter.
To the effect?
The effect that ಒಂದು ವಾರದ ಮುಂಚಿತವಾಗಿ ಲಿಖಿತವಾಗಿ ಕೊಡಿಸಬೇಕು.
Page?
Column number 70.
Read.
ಧನ ಉಚ್ಚನೆ ಒಂದು ದಾಖಲಾಗಿದ್ದ petitions, so and so. ಮತ್ತೆ ಪುರಸಭಾ ಮುಂಗಡ ನಡಿಗೆಗಳಿಗೆ ಮಾತ್ರ ಹಾಲಿ ಬಾಡಿಗೆದಾರರು ಮೊದಲು ಸಾಮಾನ್ಯ ಬಹಿರಂಗ ಹರಾಜಿನಲ್ಲಿ ಭಾಗವಹಿಸಿ ಮಾತ್ರ ರೈಟ್ ಆಫ್ ರೆಫ್ಯೂಸಲ್ ಅನ್ನು ಆಯ್ಕೆ ಮಾಡಿಕೊಳ್ಳಲು ಅಥವಾ ನೀಡಲಾಗಿತ್ತು. ಅಂತರನ್ವಯ ಹರಾಜು ದಿನಾಂಕದ ಒಂದು ವಾರ ಮುಂಚಿತವಾಗಿ ಲಿಖಿತವಾಗಿ ತಿಳಿಸತಕ್ಕದ್ದು.
Only later, after the bid, you can exercise your right of first.
But they say, whether you are exercising or not, you have to leave it within 1 week. It is clear to 1 week.
That's a wrong understanding.
And one more thing is that.
Now, one minute, which panchayat is this?
Biru.
Huh?
Biru.
ಯಾರಿದ್ದಾರೆ ಯಾರು?
Biru. Chikmagaluru.
Chikmagalur, who's there? Chikmagalur. Who appeared? Yes, Mahesh.
Mr. Mahesh appeared.
Huh?
What you could see at his face.
Yes, Mahesh. I'll pass over, you just bring him. He's there. He had appeared. Our number ತಗೊಳ್ಳಿ. Number ಇದೆ. ಇಲ್ಲ ಮಹೇಶ್ ಬಂದಿಲ್ಲ. ಎಸ್ ಮಹೇಶ್ ಇವಾಗ appear ಅದು ಯಾವ್ದು ರೋಡ್ ವೈಟಿಂಗ್ ಅವ್ರಿಗೇನೆ ಹೆಸರು. You have Mahesh's number?
I don't got. Just now he has appeared in that.
I'll pass over, you just collect the number and you call him. ಅಲ್ಲ ಆಯ್ತು ಅವ್ರಿಗೆ ಒಂದ್ಸತಿ ಹೇಳ್ಬೋದು ಅಂತ. Office to show the name of Learned Counsel S. Mahesh as representing respondent 3. AG accepts notice for respondent 1 and 2. List the matter tomorrow in the preliminary hearing list. Office objections to be complied with in the interregnum. Kodi. Kodi.
19.
You find out if he appears. If it is so, then we'll hear him and we'll pass.
I will inform.
Week's time granted for necessary compliance.
Copy not served.
If office objections are complied with.
And for the caveator, copy not.
Relist the matter on in the fresh matters list. A copy is to be served on the council for the caveat. Caveat is not put up. Yes. Ashok and Naik.
20, Nagaraj ji.
Week's time is granted to do the needful. Yes. Release the matter week after next. Ala 5 varsha aitu.
21,
Date code 20.
21.
Lord, I appear for the respondent in both the matters. Lord, the Lordship will kindly recall on the last hearing date, I have made a mention regarding settlement between two brothers-in-law. I have spoken to them. Your Lordship may kindly, refer this matter to mediation in Bangalore. Last time the mediation was done in Coorg. We went all the way from Prashant Chandra and I went, and everything got sorted out last minute for some ego problem. It got derailed. Your Lordship may kindly direct the parties to be present in the mediation center Bangalore on a particular date. I will see that they come here, and the issue is very, very small.
Yes, what is?
Settlement, my lord. We will also inform our party to be present in mediation center Bangalore. Currently, senior is unwell. Any date in the first week of April could be possibility.
No, because these are both
No, they don't have any objection to that, so we'll refer it.
Yes, my
Yeah.
lord.
We'll fix a date.
No, fix a date, my lord, before the vacation, so that this could be sorted out. And both of them are on the wrong side of the 80.
Let us see. There's no wrong side in age. You can be even 40 and be on the wrong side. The council appearing for the respondent submits, matter may be referred to mediation. Counsel for the petitioner submits, they're willing to explore the possibility of an amicable resolution of the dispute. Parties to be present before the Bangalore Mediation Center on
Any date, my lord, second week or third week, around the 20,
on 15th of April.
on a Saturday, my lord, but preferably on a Saturday, third Saturday.
19th of April. Yes.
Yes, grateful.
ಇದು records ಹೋಗ್ಬೇಕು. Records ಹೋಗ್ಬೇಕು.
22.
Lordship, this is a matter pertaining to section 67 of the Karnataka Land Revenue Act regarding the road encroachment. Whether the matter has to be remanded back to Deputy Commissioner or to the Tahsildar.
In light of the sale deeds, one question
Please,
arose.
Your Lordship. There is also a recent amendment, Your Lordship.
Whether under section 67, court could look into the aspect
Please.
of sale deeds.
Yes. My lord's
7 also
judgment,
has
my
undergone
lord's,
an amendment, Your Lordship.
No, no. Give it,
We have
give
the
it.
amendment, my lord, Assistant Commissioner is the appropriate authority to.
ಅವೆರಡು ಕೊಡು, ಎರಡು ಕೊಡು. Yes.
Assistant Commissioner is the appropriate.
The amendment now substitutes an Assistant Commissioner, Your Lordship.
ನಿತಿನ್ ಅಲ್ಲ ನರಸಿಂಹ
Deputy Commissioner, Assistant Commissioner.
ನರಸಿಂಹ ನರಸಿಂಹ ಜೂನಿಯರ್.
Or circular officer.
Yes, what does that order say
The order passed by my
Ah.
lordship.
regarding sale deeds, anything?
Yes, my lord. Now ultimately, my lord has taken a view that it will come within the parameters of section 31 of the specific relief act.
That means civil court.
The civil court would be the competent authority is the view that my lord has
Just
taken.
see paragraph.
The observation, my lord, would begin from page number 8, my lord.
Ah.
Exercise of power under section 67(2) of the KLR Act. Lord got that. The page numbers are written at the bottom, my lord.
Yes. These are points for consideration.
Yes, my lord. Now, my lord have dealt with this
The same
aspect
thing.
of section 67(2).
Ah.
Same thing.
And may I request page number 10 may kindly be taken, my lord. Paragraph number 7.
Page number 10.
10, my lord.
Yes.
stated. Is also to be noted that section 67 of the KLR Act can be invoked only where title is not vested in any individual. In all the cases that were pending before the Deputy Commissioner, the petitioners rely on registered instruments, the cancellation of which would require an appropriate declaration by court as per section 31 of the Specific Relief Act 1963. The Deputy Commissioner, acting as an inquiring authority in terms of section 67 of the KLR Act, exercising power in accordance with the procedure as contemplated under KLR rules, clearly reflects of a summary inquiry, and the Deputy Commissioner cannot be construed to be a court for the purpose of section 31 of the Specific Relief Act 1963. Then, my lord, the reliance is placed on the judgment of the Honorable Apex Court. Then, my lord, will kindly come to paragraph number 9, the next page, my lord. To construe that there is no bar on the revenue court on adjudicating issue, which would have the effect of declaration as regards the legal character of or any right in the property, would imply that a revenue court is court for the purpose of section 31 and 34 of the Specific Relief Act, which is untenable as discussed in paragraph number 6 and 7. In the present case, the nature of the inquiry, as contemplated under section 67 of the KLR Act, expressly excludes cases where the dispute relates to property, which are not the property of the individuals, and excludes such disputes where rights of such persons may be established. All of which makes it clear that the adjudicating authority under section 67 of the KLR Act has a self-limiting jurisdiction as noticed above. Accordingly, wherever the facts make out for existence of dispute that involves adjudication by a court in exercise of power conferred under section 31 and 34 of the Specific Relief Act relating to a property, the adjudicating authority under section 67 of KLR Act is ousted from the adjudication of such disputes.
Yes. So then you'll have to see in then what is the appropriate remedy. Examine this aspect and you come back next week. We'll see.
Please.
Prima facie, whether sale deeds, even 67.
The issue is this, Lords, the facts of this case.
67 cannot be invoked once there are sale deeds. That's what it appears to
Correct,
be.
sir.
But examine it and you come back next
Please,
week.
Lords.
I think this judgment is quite on the point because it also relates back to 135 on a peripheral basis. 67, 135, all put together, it confers jurisdiction on civil court wherever. That is the law which was also laid down in the full bench in JM as well. The lordships are aware of.
So examine it and you come back. Please. Relist the matter. What is this amendment?
That is, my lord. There's nothing much, my lord. The deputy commissioner has been substituted by a rank survey officer equivalent to assistant commissioner also.
But now where this issue can be raised.
Yes, the forum.
Matter that has to be revisited.
The question here, or another aspect, Lords, originally, they all rely on a government grant. That's the key element to this aspect, Lords. They all rely upon a government grant. From government grant, they further have sold sale deeds. The sale deeds, what is sold, whether it covers under the government grant is what requires to be looked into.
Correct. But now, once a sale deed is executed and it is contended that the property sold is actually a road or a public way. Under 67, could the state still go under 67? Prima facie, it appears that I've stated no, but I don't know whether the appellate orders have upheld it in entirety or what, I don't know. It has been affirmed till the Supreme Court.
Yes,
Just check.
this has been affirmed. That's what I checked.
So on that aspect, just check and come back.
Please, Lords. Good.
Release the matter in the same stage on.
Next week.
3rd of April. Yes.
Grateful.
23.
I've worried STRR as authority, that is a proper authority, my lords. Even they have filed the counter. There is some miscommunication, I believe. 23, sir.
Now you have impleaded.
No, it is already, they are already on record. My friend has filed counter. STRR is the.
STR has not made a party. Bayappa has made a party.
Sir, R3 ಅಂತ ಆಗಿದೆ.
No, the second respondent not in existence. That is what we have said last time. Howdo? Party
R3 satellite town
second
road
respondent,
authority.
he made Gram Panchayat as a party. Gram Panchayat is not there.
Service.
No, 3rd respondent.
Yes, sir.
The Satellite Town Ring Road Planning Authority.
He has already filed counter. So this
Observation is not necessary.
Yes.
Second respondent he made Gram Panchayat as a party, but Gram Panchayat is not in existence. He has to include a town panchayat. That is what I made submission.
Now
last
there's
time.
a town panchayat.
How? Town panchayat has to make a party.
Which is the town panchayat?
The same name, Basachehalli town panchayat.
Basachehalli town
Town
panchayat.
panchayat. He has to include.
You appear for that authority.
No.
Then you substitute
I will do that.
the second respondent by Basachehalli town
I
panchayat.
will do that.
And notice has to go. Or who is the?
It's Sarva, the
The-
council.
In light of their submission of Land Council, B.J. Somyaji, petitioners permitted to substitute the second respondent by the Basachehalli town panchayat. Full stop. Necessary amendment to be carried out. Issue notice to the newly added second respondent.
I'll find out who is the learned council. In addition that
ಯಾರಾದ್ರೂ ಇದಾರಾ?
I'll find out Manoj myself.
Petitioners at liberty to serve standing counsel if any for the said authority. Relist the matter.
10 days.
Any urgency or let it come in B group?
But it can come in, this is a case where, Malad, I gave up a portion of the land for STRR, formation of road. Now, Malad, in 2012, I executed a relinquishment deed. Subsequently, I come to know that STRR is not formed, therefore there is no formation of road. Now, the additional documents which I have now, I'll file it in the counter, says that STRR has been now aligned to NH 207 and road is already formed, which is around 10 kilometers away. Now, the contention of respond number 3 is that since I have executed relinquishment deed free of cost, now, Malad, I cannot reclaim it. Now, Malad, as per their own regulations, I should get the TDR certificate for the. Now, he has to make a statement.
Either they give back the land or TDR.
TDR. Malad,
Ready to accept.
Malad, if they are not farming, it is already farmed in some other place. I have got the endorsement received under RTI.
Complete your pleadings.
Yes, Malad, I'll do that.
The respondent to complete their pleadings. R1 to R3 to complete its pleadings within 10 days.
He has filed counter already.
They
Friend has filed.
So
He has
then-
not said anything about this.
So the town panchayat, how is it necessary now?
Cannot be now because R3 is a party who is.
There is necessary, my lord, because my lord, section 17(2)A is, my lord, is a beneficiary. Relinquish to the authority, my lord, private
Town
respondent.
panchayat.
Please.
I'll implead, Malad. Within 10 days, I'll take steps.
Relist the matter after 10 days date could. It can be disposed of, isn't it?
Yes.
In respect of my submission is, my lord, I have filed statement objection.
Ah.
Regarding once, my lord, relinquish the, my lord, now is not seek for, my lord, regarding
Correct.
TDR is respect of, my lord, to regarding the, my lord, when.
Forget about TDR. He
Please.
wants his land back.
Please.
TDR is only fallback option.
Please.
He's most happy if he gets his land back. There cannot be unjust enrichment by an authority
Once,
where land is relinquished for what?
Lord,
For some purpose.
when he, my lord, voluntarily, my lord, way of his
No.
rights.
There is a condition.
Because of the condition
Please.
that your sanction plan will not be approved,
Please.
etc. He has given it. Now, there is no road. He wants it back. Simple as that. Now, you're a public authority.
Please.
Let us.
Please.
Yes.
Great.
Before,
He doesn't want TDR. He wants land.
Yes.
You want land or TDR?
Land only. Around 2 acres, Malad.
So don't whisper TDR. You say, I want
No.
land.
Stand
Yes.
correct.
24, Lakshmi Narayana,
Here for the
Pawan Kumar.
petitioner in this matter, my lord.
So in this matter, last time I was not having any instructions. This time, my lordship, they have sent the provisional order to the zonal commissioner. As there is no plan as per my instruction. I will file it along with a memo, my lordship.
Appearing for respondent number 4, my lord.
313 notice was issued. If they have any plan or something, they can
They
reply.
have built up 60 units of apartment, my lord, without any plan on a tank bund buffering zone. If
No,
my
this
lords
is the-
recollect,
No, old construction or good?
new construction, my lord.
Construction
I
is
had filed this petition on the initial
Complete.
stage of foundation when they was laying the foundation, my lord. Now they have already completed the construction, 60 units of apartments on the tank bund buffering.
Correct. So now what is the restraint we can pass now?
It's completed. my
Not to
lord.
induct.
the respondents as,
Now you want some relief means you must ask, no?
as
Huh.
per my instruction, there is no plan, but they are saying that they have a plan.
For
Correct.
respondent number
They
That's
can
different.
approach. They can
And
approach.
then you
with-
produce it.
Next date, shortly I will submit it, my lord.
By that time, I will file the memo. Along with memo, I will file the documents.
Now you have a look at, I think they must not be allowed to occupy, isn't it? The apex court judgment
Yes.
and no utilities
that
must not be given.
utilities to be
Have a
dispatched.
look at this and come next date.
Please.
2024 SEC online SC 3767. 2024 SEC online, SC 3767. Rajendra Kumar versus UP Avas Evam Vikas Parishad and others. What is the consequence? Relook and come. Unless you produce the plan, you're going to suffer some order. Relist the matter on. But they don't have any, in their records, they don't have a plan.
Well, we have, same as. We have plan, my lord. I will submit it by next statement.
Yes. Yes.
25.
They give the date.
I appear for the petitioners in this matter, my lords. This petition, my lords, is seeking to set aside the order passed by the second respondent. That is with respect to an alternative shop, my lords. In brief, my lords, to tell, in the year 1992, my lords.
Yes, Prashant.
Because the order is against the government order.
Huh?
The relief sought is against the government order. BBMP is a formal party in this.
What is the relief you're seeking?
They're
Set
asking for,
aside the order, my lords, passed by the second respondent government, wherein, my lords, the BBMP will pass a resolution to give me an alternative shop. That order, my lords, will be set aside by the government. That is for the reason, my lords, my order should have been a separate order, my lords. I'll explain it, my lords.
No,
The
no,
1992, my lords.
The G
Yes, my lords.
is the order.
At annexure,
G.
yes, my lords.
G.
That you are challenging.
that I'm challenging, my lords.
So what is that? What does that order say?
Please, my lords. In page number 25, the last portion is the order, my lords. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಲಾದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಜಯನಗರ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣದಲ್ಲಿ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ನವರು ನಡೆಸುತ್ತಿದ್ದ WBGF ಮಳಿಗೆಗಳ ಸಂಖ್ಯೆ 42, 43, 51 and 52ಗಳ ಖಾಲಿ ಮಳಿಗೆ ಪಾಲಿಕೆಯ ವಶಕ್ಕೆ ನೀಡಿದ್ದು, ಖಾಲಿಯಾಗಿರುವ ಸದರಿ ಮಳಿಗೆಗಳನ್ನು ನಂಬರ್ 1 ಮಳಿಗೆ ಸಂಖ್ಯೆ 42 ಅನ್ನು ಶ್ರೀ ರೋಹಿತ್ ದೋಷಿ ಅಂಗವಿಕಲು, ಇಟ್ ಇಸ್ ಅ ನ್ಯೂ ಅಲಾಟ್ಮೆಂಟ್. ಮಳಿಗೆ ಸಂಖ್ಯೆ 43 ಅನ್ನು ಟಿ ಕೇಶವಮೂರ್ತಿ ಅಂಗವಿಕಲು, ದಟ್ ಇಸ್ ಆಲ್ಸೋ ನ್ಯೂ ಅಲಾಟ್ಮೆಂಟ್. ನಂಬರ್ 3 KS ಅರುಣ್ ಕುಮಾರ್ ಅವರಿಗೆ ಈಸ್ಟರ್ನ್ ಬ್ಲಾಕ್ ನ ಹಳೆ ಮಳಿಗೆ ಸಂಖ್ಯೆ 33C ಗೆ ಬದಲಾಗಿ ಮಳಿಗೆ ಸಂಖ್ಯೆ 51 ಬದಲಿ ಮಳಿಗೆಯನ್ನು, that is the petitioner.
Now you are the petitioner, serial number?
Serial number 3.
3.
What happens, Melons, for an alternate allotment, I will seek a requisition. BBMP will consider that. They will pass a resolution. After the resolution is passed, Melons, the commissioner, he will write a recommendation to the government stating that new allotments should be done in accordance with law. It has to be put into auction. There is reservation, women reservation, SC/ST reservation, and then handicap reservation. What happens, my lords? My alternate resolution is also stuck in between them. So, my lords, with respect to that, they will pass this order by cancelling the entire resolution. In fact, my lords,
You had voluntarily given it up before it was demolished.
it was not demolished. I sought for an alternate. What happens? I was allotted shop number 33/C. That shop is, my lords, in the outer perimeter. So I sought for a shop which is inside the shopping complex. 51. In fact, my lords, at page number.
No, but now.
Page number 17, my lords, they will give an endorsement. Once the shop is vacant, the shop will be allotted to me. Accordingly, at annexure D, BBMP will pass a resolution. What happens in this resolution, my lords? 3 new shops also will be incorporated in the resolution. Mine is an alternate resolution, alternate shop.
Correct. Now, as of now, you are in shop number?
33C.
As of now?
As of now.
And you had asked for?
51.
That depends, subject to the rules. If it's available, if all rules are followed and it is left out.
Please, my lords, as on the date, 51 shop is vacant.
No, that's a different matter. If the BBMP cannot allot it.
They have allotted, my lords.
No, they cannot allot it to you unless they follow the procedure prescribed.
My lords, for alternative shops, there is no.
You can't, they don't have power to give alternative shops.
Hello, what, my lords, after passing of this resolution till date, my lords, if my lords may kindly peruse.
Yes, BBMP, what is this?
At annexure H, my lords, if my lords may see.
Whether his request can be considered dehors the whatever government order.
They have been giving alternate
One
shops.
second, my lords. Government order is based on the rulings of this High Court.
Correct.
Wherein it has laid down certain guidelines of how a shop needs to be allocated.
Where is that page?
It is mentioned in the government order itself. I have the ruling with me. He didn't read the rest, next part of it, my lords. Annexure G, in that Adesha Sankhya itself.
Page?
Page 25. I'm looking at page 25, my lords. When we come to the government orders portion dated 22/9/2021,
Yeah.
third item is K. Arun Kumar, who is the petitioner. Coming to the last three lines, my lords. ನಿಗದಿಪಡಿಸಿದ ಸದರಿ ಮಳಿಗೆಗಳನ್ನು 5 ವರ್ಷಗಳಿಗೆ ಗುತ್ತಿಗೆಗೆ ಹಂಚಿಕೆ ಮಾಡಲು ಪಾಲಿಕೆಗೆ ಕೌನ್ಸಿಲ್ ಸಭೆಯ ವಿಷಯ ಸೋಣಿಸುವ ದಿನಾಂಕ ರಲ್ಲಿ ಕೈಗೊಂಡಿರುವ ನಿರ್ಣಯವು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ದಿನಾಂಕ 2/6/2003 ಮತ್ತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 37922 of 2011 ನಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶಕ್ಕೆ ವಿರುದ್ಧವಾಗಿರುವುದರಿಂದ ಪಾಲಿಕೆ ಕೌನ್ಸಿಲ್ ಸಭೆಯ ವಿಷಯಕ್ಕೆ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ದಿನಾಂಕದಂದು ಕೈಗೊಂಡಿರುವ ನಿರ್ಣಯ ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಅಧಿನಿಯಮ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ಅನ್ವಯ ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಿದೆ.
As per this resolution, my lord, the BBMP has written a letter on dated 5/4/2021. As per the letter of the BBMP, the government are.
The council gave a resolution, my lords. Thereafter, the High Court passed its order.
No, no, so what is that position now? What is the WP 37922?
It is disposed of, my
It
lords.
is disposed of.
Where is that order?
Within the last date of hearing,
I have
but
a
I
copy with
produced
me.
it before this court.
I have a copy with me.
I have a copy also.
My lords, may I pass on the copy?
So that government order and the High Court order.
Please, my lords. Judgment, my lords, internal page number 10. The allotment made in favor of the petitioner seems to be in contravention of allotment rules of corporation, and it is further seen that before allotment of shops, a notification has to be issued calling applications from the prospective persons on priority and on basis of reservations considering SC, ST, physically handicapped and economically weaker persons, women. The allotment of shops should be made. The allotment made in contravention of corporation allotment rules is unknown to law. This license should be issued for a particular period. The allotment shall not be claimed as a hereditary right. After expiry of the license of allotment, the
This is the
public should.
correct position.
Yes.
Under the, under
This
under the-
order is, my lords, with respect to a new allotment
No,
made.
correct. Old allotments cannot be given, blocking new allotments. Simple. That is the logic.
Please, my lords. Now, my lords, there are two more aspects which I'll have to be considered, my lords. At Annexure H is the,
Now, regularization of daily wages, one of the objection raised is that the government has a policy of recruitment in which SC, ST, physically challenged, a reservation must be given. So if you regularize daily wages, it upsets that proportion of reservation, etc.
my lords,
So suppose he makes a request, you give
Yes,
me
ma'am.
some other shop. That cannot have the effect of going against the procedure prescribed under the allotment rules. So if the allotment rule says that it must be in this manner, etc., there can be no shortcut.
What my learned friend here who appears in similar kind of matters says is that for the shop number 51, there is already a lot of application which is made. And that is also pending consideration before this honorable court.
And there are various writs also
No,
that have been filed before this.
That's a different matter.
No, I'm just bringing to the.
Correct, but I'm saying that's a different matter.
Yes, my lords.
The law is that unless the allotment of site rules provides for giving an alternative allotment,
Absolutely.
the BBMP has no jurisdiction to consider
all.
request for allotment.
Yes, my lords.
That is your position.
Yes, that's.
my lords, this aspect is considered only for this shop. If my lords may kindly produce at Annexure H, my lords, for a moment.
Now, if they've made mistake, that cannot be continued.
No, my lords, this is after passing of this order. At page 27, if my lords may kindly produce.
Yes.
This, my lords, I have obtained this document by on the basis of an RTI.
Correct.
This is an alternative shop which has been granted.
That cannot be done.
There are two shops in this.
So that-
After this also, my lords, filing of this writ petition also, my lords, there are two more shops. I have filed it, I placed it before this
We'll
one.
clarify that. We'll clarify. It
By a
cannot,
memo.
it cannot be done. And it's up to the BBMP to take
There's,
corrective
I
steps.
just provided clarification.
Yeah.
The one annexure H document which my learned friend is showing was an allotment which was done before 22/9/2021, which is the government order which is passed.
Now, where is the government order now?
Government order is was annexure G, which was just read out, my lords. That is dated 22/9/2021. This is an allotment on 31/3/2029, 6 months before
No,
that.
that we'll see. That's in the case of. others.
after passing of the government order also, my lords, there is a allotment which I have placed it before this honorable
No, no,
court.
correct. But you cannot claim negative equality.
Yes, ma'am.
There's one
allotment- Any
that-
allotment done contrary to allotment of site rules and the order of the High Court will have to be revisited in.
The order
accordance
of the
with-
High Court is only with respect to a new allotment.
No, I'm saying it applies to alternative hour.
What happens in this case, my lords, if I am given an alternative shop, my old shop will fall vacant. That shop can be, and Fine,
they have no discretion to do that.
There's one more legal point, my lords, which will come in way of the order passed by the government. On that ground, my lords, it can be quashed. That is, my lords, that is order passed by the second respondent government is in violation of section 72 of the Karnataka Municipal Corporation Act. 72, my lords.
No, now it will be BBMP Act. 72
The
of
time of passing, my lords.
Municipal-
72.
Municipal Corporations Act.
Please, my lord. Karnataka Municipal Corporation.
Yes.
That is, my lord, the obligation laid on remaining municipal authorities to carry out resolutions of the corporation.
Or the councillors, my lords.
Now, my lords, in this case, my lords, the resolution is passed on 8/9/2020. Within 15 days, my lords, they have to implement the order. The commissioner, my lords, will forward a letter after a lapse of 6 months to the government stating that the resolution has to be cancelled. This provision, my lords, clearly states that if within 15 days, if it is not forwarded, my lords, then the resolution has to be implemented. After a lapse of 6 months, my lords, the commissioner will forward a letter and then the order is passed. This, my lords, is in proper violation of section 72.
That's a technical contention. It's a technical contention.
Please, my lords. In fact, my lords, with respect to section 72, my lords, the apex courts have also held that without considering the provisions of section 72, my lords, the commissioner cannot act or pass any comments on the resolution passed by the BBMP. Admittedly, in this case, my lords, in 8/9/2020 is the resolution passed to grant me an allotment, alternative
That
stop.
resolution, if it relates to property, is required to be ratified by the government in terms of section
72.
No, no.
70.
70?
70 subclause 2.
70 subclause?
Every councillor shall have the right to interpret
No,
it on
no,
matter.
there is a provision that property, alienation of property requires government consent.
Please, my lord. But it has to be done within the stipulated time. That is 15 days. After resolution is passed,
My lords,
within the
if
15 days.
clause of section 72 can be read, I think that brings out that, my lords.
Please.
He shall within 15 days of the passing of the resolution, refer the matter to the government for orders and inform the corporation of the committee. As the case may be, of the action taken by him at the next meeting, and until the orders of the government on such reference are received, the commissioner shall not be bound to give effect to the resolution.
No, there is some other provision which says that if it has the effect of alienating property, then government permission must be taken.
No, man, this is with respect to an alternative shop.
No, 72 is only insofar as giving
There-
effect to and in public interest. But property of the corporation, there is something separate. I'll have it next week, just property of the
Soon I'll go through
corporation
it.
cannot be alienated without government permission.
I'll look into that as
I'll verify that, my lords. In fact, there is.
No, but now you are on weak wicket, you examine it. Any alternative site allotment
Shop.
cannot be contrary to the rule. If the rule provides for existing tenants anything, you verify it.
Please, ma'am, I'll verify that. My
We'll-
submission is that, my lords, for alternative shops, there is no prescribed rules.
So you examine the
Please, my lord.
rules and you place it on.
And in fact, my lords, till that there are alternative allotments being made to several people.
No, that is negative.
There's only my shop which has been stuck there.
Relist the matter on next week. 4th of April.
Great.
Third, my lords.
4th April. Third amendment.
Fourth, there is some inconvenience, or the next week, Monday or Tuesday.
4th minutes. You okay?
8th.
Please.
26, I think 27, Varun, yes, Shivram.
Small office objection, my lord, that page 62, my lord, is a legible copy. It's an FIR, my lord, that 2-3 lines, my lord, the office wants to legible copy to be produced. That is the small objection in the IA. I have filed application for vacating stay, my lord. On the last occasion, this honorable court, my lord, directed the corporation, my lord, to find out, my lord, they are kindly see the order, my lord.
What have they challenged?
That's the closure notice has been
Closure
challenged
notice, my lord.
by the BBMP, Annexure A, my lords. I'm led by senior, my lords. I request for a copy of this application. And I may be
I have
permitted
already
to.
given, I have already given and served.
No, now pleadings are complete.
Pleadings are complete, your lord.
No, And then you must.
No, on the last occasion, my lord, may kindly see the order, my lord, page 59/2023.
Correct. Now we have to dispose of the matter.
Yes, your lord.
So let the BBMP complete its pleading.
That's correct. 59/2023 order, my lord, may kindly see. 59/2023.
Maybe, my lord, since then, interim order is in operation. They've also filed the vacate stay last year in June, my lords. They've chosen not to move it. It's a private feud, which is being perpetrated by the petitioner against the, by the third respondent against the petitioner, my lords.
No.
59/2023 order.
Let BBMP complete the pleadings.
No, that's
you
why,
have
my
to-
lord, this order was passed on 2023, my lord.
We'll
Now
fix
we are
it.
in 2025.
Yes, Pavan.
In this time, I will file my objections.
The hearing of IA vacating stay would have the effect of disposing the petition. Accordingly, R1 and R2 to complete their instructions within 10 days. Relist the matter on
Also,
17th of April.
17th.
my lords, the interim order may kindly be extended.
Interim order operation is extended till the next date.
Grateful. My lords, in the meantime, also requesting my learned senior to share a copy of this IA.
I have already
have it.
served the copy.
ಅಲ್ಲ ಆಯ್ತು ಇನ್ನೊಂದು ಕೇಳಿ.
ಕೊಡ್ತೀನಿ ಇನ್ನೊಂದು ಕೊಡಿ ಅಂತ ಕೇಳಿ ಕೊಡ್ಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳೋದು ಬೇಡ ಅಂತ.
ಅಲ್ಲ, ಅದನ್ನೇ ಕೇಳ್ತಿರ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದೀನಿ
ಹಾ.
ಅಷ್ಟೇ.
Yes.
28 dozen, 29.
Without serving the copy, otherwise office will
ಅಲ್ಲ,
object.
Yes.
Grateful.
29. Kumar Jain.
Delay of 28 days, I have not mentioned it.
Who has died?
The fourth petitioner.
Now you have filed an application.
Yes, I myself is filed. I am for the petitioner.
You have filed the legal representative of the
Of the deceased fourth petitioner.
Wakalat is filed.
Yes, Wakalat also filed.
The
LR application.
petitioner.
One. Even the respondent ಏನಿಲ್ಲ.
It is submitted that
ನನ್ನದೇ party.
the fourth petitioner has died during the
Petitioner.
pendency of the present proceedings. On 14/8/2024, the legal representatives have filed the present application to come on record and represent the interest of the fourth petitioner. Full stop. IA 1/24 has been filed seeking condonation of delay in filing the application to bring the LRs on record. IA 2/24 filed to set aside abatement, and 3/2024 is filed to permit the applicants to come on record as legal representatives of deceased petitioner number 4 and to defend the interests of petitioner number 4 in light of the amendments made in the affidavits in support of the application. IAs are allowed. IA 1/24 is allowed. The delay in filing application to bring LRs on record is condoned. Abatement is set aside accordingly. IA 2/24 is allowed, and IA 3/2024 is allowed, and the LRs are permitted to come on record. Necessary amendment to be carried out to the cost title. Office objections.
Amended cost title is furnished. Amended, I will carry out the amended.
Amended cost title is furnished, same is taken on record. You just see what the office objections.
Only delay, 28 days delay not mentioned. That's all.
Office objections are waived, taking note of the
But
submission made by
My lord,
counsel for the applicants.
I will carry out the amendment. Any day may be fixed
Petitioner is
because
permitted to amend the main petition.
main relief only sought for mandamus because 73 we purchased in auction. It is not yet finalized. Direction is given to the fifth respondent to hold inquiry. He has only issued notice. Thereafter, no further proceeding. That way request within a week, any day. Fifth respondent, not he is appearing for some other respondent.
Who appears for the fifth respondent?
Fifth respondent, and this may time to take next week. This is going on since last 70 years. 70 years in there.
Any
No, who has to finalize now?
fifth respondent has to final, against whom I have sought for the
No, fifth notice on the question ಮಾಡಿದೆ. This may can take next week. Yes, fine.
That is the state.
Yes, madam.
AGA.
Because we purchased these.
Accepts notice for
because
the fifth respondent.
The inquiry notice itself is a question.
No, now the deputy commissioner must take a decision, is it?
Melon, no, not that one. No, no,
Fifth respondent, Department of Urban Development, MS building by Principal Secretary. Fifth respondent.
The fifth, page number 13.
So what is the order passed in 15607?
One by hold inquiry with regard, because we have, we are the auction purchaser in 1973. There are various, the education department disputed. Various writ petitions have been filed. Final writ petition was mandamus issued to the fifth respondent to hold inquiry and pass orders. After the mandamus, only notice only issued. No further proceedings is taken place.
Notice is issued. Yes, question is notice itself.
No, let us see.
Notice annexure B I have produced. Annexure B is the notice.
He has only sought for expediting the inquiry.
Aste.
He has not challenged that. He
Expedition.
wants it to be concluded at the earliest.
Earliest 23 notice issue ಮಾಡಿದ ಮೇಲೆ.
Yes, you please take instruction. Now that annexure B proceedings, he wants to know why it's not concluded. You take instruction. Relist the matter in preliminary hearing list on. Only on that limited point.
9th of April.
Yes.
On any date is.
Date.
Yes.
9th of April. Serial number 30.
Yes.
This
The
matter
other
last,
side was directed to,
last time my lordship have directed to file the objections. I have received the records, my lordship. The issues with relate to, they are also asking for TDR and compensation. The matter is pending before the Supreme Court in SLP number, where by one person by name Chamundi Hotels. Also, they have also claimed ownership over the property, my lordship. So I need to take my stand.
Then you take your stand in writing.
Yes, my lordship, it will take.
Counsel for R4 submits a statement of objections will be filed by the next date. Relist the matter.
16th, my lord. 16th or 15th.
16th in B group. We'll have to hear it.
It has to be heard.
Yes, next.
31. For the petition. Last
Yes.
Producing a copy of the affidavit. Actually, the person has sent it. He has sent from Mangalore. I have not received the original, but what they want to say, they have stated in the affidavit. The measures which are required to control the pollution, they are stated, my lordship. Petitioner
Receive the
has-
copy notes, just go through it, my lords, and make
Your lordship.
You share a copy with them.
I have given copy.
You have a
With
look
the
at it.
submission, your lordship.
Ah.
Here, the matter is, both this writ petition is arised out of the order passed by the Taluk Panchayat. Even Taluk Panchayat allu kuda, they have observed the same. Idರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ pollution control board ಅವರು ಒಂದು operative portion I am trying to read, your lordship. Okay. Karnataka Grama Swaraj Panchayat Raj Adhiniyama 93 ಪ್ರಕಾರ
You're reading at page?
page 30 of writ petition number 17619. ಒಡಾಡಿಕೆ ಸುಲಿಯುವ ಘಟಕಕ್ಕೆ ಪ್ರಸ್ತುತ ಪರವಾನಗಿಯು ಚಾಲ್ತಿಯಲ್ಲಿ ಇಲ್ಲದಿರುವುದರಿಂದ 7 ದಿನಗಳ ಒಳಗೆ ಸದರಿ ಘಟಕವನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವಂತೆ ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ನಿರ್ದೇಶಿಸಿದೆ. ಮುಂದುವರಿದು ಪರವಾನಗಿ ನವೀಕರಣಕ್ಕಾಗಿ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯನ್ನು ದೂರಿನಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಅಂಶಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಘಟಕದ ಸುತ್ತಮುತ್ತಲ ನಿವಾಸಿಗಳಿಗೆ ಯಾವುದೇ ತೊಂದರೆ ಆಗದಂತೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಗಳಿಂದ ಪರಿಶೀಲನಾ ವರದಿ, ಇದು NOC ಅಂತ ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು, ಪರಿಶೀಲನಾ ವರದಿ ಪಡೆದುಕೊಂಡು ಪರವಾನಗಿಯನ್ನು ನವೀಕರಿಸುವ ಅಥವಾ ರದ್ದುಪಡಿಸುವ ನಿರ್ಣಯವನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. See now in both this order is similar order. This is appeal number 1, and the other order is appeal number 2, in the similar order. And being agreed with this order, the petitioner has prepared a writ petition. And there is lacuna in the order passed by the Taluk Panchayat. Only contention taken by the petitioner is, this is the order passed by the Taluk Panchayat is not taken concurrence of the Jilla Panchayat. That's the only technical point they have taken the contention.
Who appears now for the authority?
The-
Who appears for
No,
the?
I appear for the authorities, my lord. I'm for the
Yes.
respondent number for the Gram Panchayat, Taluk Panchayat and the Jilla Panchayat.
So what is your stand now?
No, my lord, the Taluk, my lord, what has happened in this matter is, trade license was granted to the petitioner. He had first applied on 21/9/22. And the trade license was issued on 5/11/22. Subsequently, it expired in the year 23. It was not renewed. He'll be continuing to running the industry. He sought, subsequently, he again sought for renewal of license on 4/5/24, for which they have given a reply stating on 29/5/24 that you please take necessary permissions from the competent authorities. He took a license for arecanut peeling by hand. But when the PDO, the Gram Panchayat PDO went and inspected the place, he found out that he's running machines and there is a lot of noise coming, and the Pollution Control Board has also given a report stating that the noise is about 10 decibels more than normal. So the Gram Panchayat basically told him, you take the required permissions from the competent authorities and we will consider your trade license. He has, on that, one of the Gram Panchayat members has challenges before the Taluk Panchayat. Taluk Panchayat has passed another order saying that is what has been challenged before your honors now. So there are several, the point here, what I'm trying to point out here, my lord, is if he wants to run the trade, the industry, he will have to take necessary permissions. And the issue, one more issue is, a lot of complaints are coming from the ground, from people there saying that it's creating a lot of noise, and there's some health hazard as well. So we have asked him to maintain status quo. So my only request is any appropriate orders may be passed directing him to take necessary permissions, and if he wants to run the industry, and then we will consider if trade license can be given.
No, insofar as the Pollution Control Board is concerned, they filed an affidavit that is agriculture related. They don't have any say, and exempt the Pollution Control Board from entering into it. That's the stand of the Pollution Control Board. Now, whoever the other authorities, whatever is required, you put it in writing. We'll ask him what is to be done and close the matter. If there is noise above certain decibel, you have to specify under the rule number so and so, there is such a restriction that you place it on record, whatever your stand is.
Yes.
Along with my objection, I have filed a Pollution Control Board report where they have reported that there is a sound pollution, and that is a part of my objection statement. That too, during the non-running the industry, avagaddu sound pollution kuda there is above normal. And that is the report I submitted along with my objection. And even Pollution Control Board, they say that here. However, the applicant may be informed to use the machineries with acoustics and adequate measures like windbreak, walls, dust control measures, all these things. With this observation, at least this petition may be disposed of. And our condition may even Panchayat can take over the decision on the direction of the sun.
Now I'll have it next week. You state what are in writing you state what is required to be taken. Now you are saying some permission, whatever that is, you place it on record. Case PCB says not required. There ends the matter insofar as the Pollution Control Board. What other permission is to be required? You place it on record. We'll ask them and then you take a decision on it.
May I submit?
Yes.
My lords, health officer has given a report saying that, my lords, there is no health hazards. And my lords, it is these entire proceedings came to be initiated, my lords, at the instance of rival, my lords, persons.
That we'll see. Let them first place on record.
Now, my lords, it is a seasonal, my lords, agro industry, arecanut, my lords, peeling of arecanut, my lords. Seasonal, that too, my lords, only, my lords, post October.
You appear, Mr. Prabhakar, you appear?
I appear for sixth respondent.
Who's the sixth respondent?
Yes. 6 to 10.
They are the, my lords, private,
they are
private
the
parties.
Villagers in the.
Lords, I have given employment for, my lords.
Just one.
Yeah, I'm sorry.
No, now, what is your grievance could be taken care of by putting them on terms? You mentioned we will ask them to follow such procedures to avoid noise pollution or other kind of pollution. And then we will dispose it.
Yeah, that's what now.
Ah.
And I mean, your lordship has directed the panchayat to, because they are the decision maker to what are the things to be directed to be, because we are the villager. We have put forth the grievances to the panchayat, and the panchayat should take a decision on our grievance and considering their application.
No, now you put it in writing, what other permission the petitioner is required to take, what condition of noise pollution otherwise, according to you, on the basis of complaints that they need to take care of. I'll have it next week. You put it and then we'll see what is to be done.
May I suggest this, my lords?
Yes.
My lords, let there be some inspection, my lords, by the officer from the pollution control board.
No,
And from
pollution control board is now stated on affidavit that this is agriculture link, they don't
Yes.
want to come. Let the PD only do it.
Let there be some sort of inspection, my lords, by joint inspection. Even the villagers who are claiming that, my lords, we are causing pollution and, my lords, noise pollution. Let them also be present there. And let the
accept
petitioner
that.
also be present there. PDO also let them, and even all the panchayat members also, my lords, let them go.
Taking note of the contentions raised, it would be appropriate if there is a joint inspection of the enterprise of the petitioner in the presence of all the respondents.
And villagers.
Respondents and villagers.
ವಿಲೇಜರ್ಸ್ ಅಂದ್ರೆ ಅದು ಮತ್ತೆ ಅಲ್ಲಿ ಪ್ರೊಟೆಸ್ಟ್ ಇದು ಒಂಥರ
protest
ಎಲೆಕ್ಷನ್ ರ್ಯಾಲಿ ಆದಂಗ ಆಗತ್ತೆ ಎಲ್ರು ಬೇಕು ಬೇಡ ಅನ್ನೋರ್ದಾಗುತ್ತೆ.
Respondents and neighboring.
The health officer, health officer, I mean, concerned health officer.
The respondents, including neighboring, including the local
ಅದು
neighboring residents.
ನೇಬರಿಂಗ್ ರೆಸಿಡೆಂಟ್ಸೇ ಇವರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
Including the neighboring residents. Full stop.
And health officer.
The PDO is at liberty to involve other officers, including of the health department as may be necessary.
Much.
Full stop. The inspection, after inspection, report to be filed, taking note of the grievances made by the private respondents. Full stop. The PDO also to state any other compliance required to be taken by the petitioner. Said report to be filed within a week of the inspection. Inspection to be carried on. Date fixed.
15th or 16th.
Parties to be present on such date.
Much.
Time, my lords, at 11 a.m.
Matter on reopening date.
28th, my lords.
For the 1 week after. On 28th.
My lords, may I request for time, my lords, on 15th, some
At
time,
11:30 AM.
please.
Yes.
Interim order to continue.
Interim operation is continued till the next date. Affidavit. Yes, Pawan Kumar, that affidavit.
Original, I have not received it. They are sending. File it in the.
Affidavit as directed to be filed in the register before the next date.
32,
Grateful.
Ajay, 32.
I appear for the fifth respondent in this case.
This matter
Is
was
I who moved the matter on the last occasion, but the matter came to be adjourned on account of my absence in the court. My lord, I submitted on the last occasion my matter. There were 92 matters in the first list. My matter was in the second list, fourth matter. By the time I came,
But now what is the main?
yeah, please, my lord, this is a case of illegal construct.
May I just make some creations in respect of a building. My lord, first, initially, my lord, 248, 1 and 2 notices were issued, followed by 248, 3 notices. Subsequently, that was challenged before the Chief Commissioner. Chief Commissioner says that inspection was not carried out in the presence of the petitioner and directed the officials, my lord, to conduct inquiry afresh. Subsequently, 248, 1 and 2 were again issued, my lord, wherein inspection of the building were carried out in the presence of the petitioner as well as the respondent. There appears, my lord, that there is 100% deviation as far as the setbacks are concerned. Subsequently, following which, my lord, since no action was taken by the petitioner, my lord, to bring it in consonance with the sanction plan, 248.3 was issued. He challenges the 248, 1 to 3 notices before the Chief Commissioner. There, it ends in a dismissal. Now, the only grievance here is when inspection was carried out in his presence as on 16/8/2023, he was not afforded an opportunity of airing his grievance. My lord, 248(3), my lord, was issued on 31/8, my lord. Now there was a gap of 15 days. In the gap of 15 days, it is not a disputed fact that inspection was carried out in the presence of the petitioner. And admittedly, my lord, or at least it is not disputed, my lord, that he has not filed any objections to the 248(1) and 2 notice. Challenging that order passed by the Chief Commissioner, my lord, he has appeared in this. Now it appears, my lord, from the records that there is 100% deviation on all the sites. And even on the last occasion, my lord, he had undertaken to demolish the top floor of the building. But it so appears, my lord, that nothing has been done. This being the situation, my lord, now 356 has come into play. And as per 356, notice was given to the petitioner to quit the building so that demolition activities can be. Inspection again is carried out for preparing an estimate as to how much cost would be incurred for demolition. Permission has been accorded. An amount of ₹7 lakhs has been fixed for demolition of the building. And the contractor is also fixed. Now, only thing is the law has to take its course. This is the situation.
Your Lordship, the matter was supposed to be listed on 9th April, my lord, and on earlier occasion, if your Lordship could please recollect, the respondent number 5 made a statement that the whole process was initiated on a complaint based on complaint dated 14/9/2022.
No, correct. Now,
Please,
we just go to the 248(3) order. Let us have a look.
Please,
and
madam.
the 248(3), first 248(1) order dated 30/11/22, is it?
8/2023, because
Page.
32,
Page.
page number 56 to 58.
You have all the records with you?
My lord, I just have the petition, my lord, everything is recorded here.
No, correct. But in case of any cross-verifying,
If at all, my lord, if at all, he says what.
let us.
If at all.
Lord, may I make?
I have produced all the records, my lord, for your lordship's
Just one
consent.
moment. Take your lordships to page number 56, my lord. Page number 56 is the order under section 248 clause 1, where, my lord, I will not trouble your lordships, but I will just persuade your lordships to see only the table, where on all the sides, my lord, there is 100% deviation. Subsequently, my lord, at page number 58, my lord, 248,
There is no setback.
no setback, absolutely. This is followed by 248(3) notice, my lord, which is at page number 59.
Page number
59, my lord, annexure H. Subsequently, my lord, may I just persuade your lordship to turn to page number 65, my lord, which is the appeal filed before the Chief Commissioner. Page number 65. Paragraph number 18, my lord.
Yes.
Lordship. My lord, may I be permitted? That on 16/8/2023, the appellant was present at the site and the respondent visited the site, and without following the directions passed in the order dated 17/6/2023, the respondent drew a sketch and took the signature of the appellant. I just pause here. Now, everything, my lord, has been done in his presence. His signature is also obtained, my lord, as on the spot, Mahajan. This honorable authority has observed that the appellant has to be given an opportunity to file objections and explanation, but the respondent, though visited the site on 2023, failed to take any explanation from the appellant. The respondent, without giving any opportunity of explaining the details of construction, drew a sketch and took the signature, believing that the order of this honorable authority is complied by taking the signature of the appellant. The appellant wanted to inform the respondent that the site measures so and so and not 30 to 40, and he also wanted the light and ventilation which is legal inside from the 13 case. I just pause here for a moment. What I would like to impress upon your lordship is that a spot inspection was conducted on 16/8/2023. 248(1) and 2 has been issued on 16/8/2023.
Correct.
Now, if your lordship may kindly see the 248(3) notice, my lord, it has been issued on 31/8/2020. I have not denied him any opportunity of airing his grievance, whatever it may be. It is his responsibility to file whatever he wants to. He admits that the spot inspection has taken place. He admits that 248(1) and 2 has been issued, my lord. And when there is no response from the side of from the petitioner side, my lord, obviously I will have to follow the due process of law, which I have done, my lord, by taking into consideration 248(3). I have issued that. Here 15 days time has been given. This is the very admission made by the petitioner himself. Now we cannot say that opportunity of hearing was not been afforded to him.
No, that was not the only contention, one. That itself was not the one of the contention. Reason is this, my lord. During the first proceedings before the learned chief commissioner, my lord, admittedly, yes, no inspection was taken place, 100% deviation was ordered, my lord. The matter was remanded back to the BBMP, my lord. What they did is, the matter was fixed for hearing on 17 January is what I understand. On that particular day, they come and draw the sketch, my lord. That means they have not complied the order of the earlier order of the learned chief commissioner. Now, my lord, now the question with regard to the setbacks are concerned. It is true that I have admitted, yes, there is one portion which I have escalated and have extended it. I'm ready to remove it. But the question here is, the learned, the BBMP, my lord, has not considered the fact that an inspection report was supposed to be submitted before this honorable court in this writ petition, my lord. That is contrary to what the 100% deviation is. Kindly see, my lord, on 15/1/2025, they file an inspection report.
No, we can't enter into anything done during the pendency of the proceedings. Now I am on the merits.
No, on merits also.
16/8/2023 inspection is made, report is filed.
Please, my lord.
Now, is it a fact that the setback violation on all the three sides 100%?
Lord, I'll just take your lordship to this. The whole initiation was on one complaint, that is by respondent number 5, who is a neighbor at site number 13. His grievance was on 49/2022. He sends a legal notice to the BBMP. What he says is illegal unauthorized deviation. No, I'll place it on record, though it is not part because.
No, but now we are only on whether there is any defect in the 248(3) order. We are on the limited point. Is there
The 100% claim what they are claiming is wrong is what my contention.
So what according to you?
Reason is, reason is.
No, so what is the deviation? You remove it, there ends the matter.
No, I'll just. Here what happens is, the site number 14 measures originally 4,800 square feet, my lord. He being the neighbor, site number 13 also, his measurement is equivalent to that also, somewhere around 4,800 to 4,600 in and around. My lord, in site number 14, there are 3 buildings erected.
The separate kata or one?
Separate kata is there.
Then there ends.
My lord, I'll come to that issue, my lord. I'll come to that issue also. Why? Because kindly see the malifieds in this complaint, my lord, and how the process has taken place. He writes a complaint to the BBMP saying that illegal unauthorized deviation on site number 14. My lord, I am not site number 14. I'm site number 14/1. What he says is, my client is immediate neighbor of the property bearing site number 14.
No, that's now who makes the complaint is irrelevant. It is now brought to the notice of
my lord,
the
what comes to my aid is.
Now we are only on the point whether there's any defect in the 248(3).
Yes, my lord. I still
what
say
is
so.
What is the defect?
What
if
why
it's
I
a
still
finding
say-
of fact, I am not going to enter into. I'm not going to enter into any finding of fact.
Correct.
Any jurisdiction error you point out. It is done in your presence. 15 days time.
Lord, it was not done. That no, not why I
16/8/2023. You were there.
Lord, what?
Para 18 of your appeal memo.
I'll come to that, my lord. On 16/8/2023, the appellant was present at the site and the respondent visited the site and without following the directions. My lord, this is my grievance.
That may be so.
Please, my
That
lord.
may be so, but how are you prejudiced? What is it now?
Why not?
Measurement was done in your presence or no?
Measurement was done and the learned chief commissioner had asked me to file my objections also. They didn't entertain. What are the things which I'll tell it, my lord. Lord, what the BBMP Act says is, your lordship may kindly see, bylaw 9.2.
Exterior open spaces, setbacks, coverage.
Now we are only in writ jurisdiction. We cannot enter into anything other than jurisdictional errors.
I understood, man. There are photographs also.
Bylaw number?
9.2, table 6, my lord.
Yes.
Your lordship will find note 12, my lord. Note 9 and note 12. The very next page, if your lordship.
Yes.
My lord, note 9, I will read, my lord. In case of irregular plots, my lord, for your lord, this is 1,381 square feet, my lord. It's a irregular plot. In case of irregular plot, the setback are to be calculated according to the depth or width at the points where the depths or widths are varying. Average setback shall not be considered in such cases. This has not been considered. Point number 1. Second point is, in case of note 12, I'm reading, my lord. Note 12. In case of 2 or more buildings proposed on a single site, the setbacks shall be applied by considering them as a common building. Now, my lord, for a moment, if I could pause, I have produced photographs of the buildings, the structures erected, where your lordship will find.
Once Kata is bifurcated, there is no single site.
My lord, Kata, my lord, I'll come to that point also. My lord. So far as Kata bifurcated, what happens, my lord? My lord, if I could take an example of an apartment structures also. Suppose if I sell the second floor, Kata will be bifurcated, my lord. Then again, I can't go and take a separate setback for the bifurcated Kata.
Unless there's a common plan for the entirety of all the whole project, it's a different matter. Here, plan itself was obtained only after bifurcation.
Even at that's not the case, my lord. The Kata have been bifurcated after I purchased, but it comes around within site number 14.
Plan was applied when after bifurcation.
Please.
Then?
Lord, if there is 12 feet passage between my property and his property.
That I don't know. For your site, after you applied, after it was bifurcated, you obtained a plan.
I obtained the plan.
In terms of the plan, have you maintained the setback or?
But in terms of the plan, yes, my lord, there is an error of me, even this one also, and I have not considered this aspect, my lord. On one occasion before this honorable court, I have admitted, yes, there is an error, but that can be rectified is what my understanding.
Then you rectify it.
Lord,
I'll give you an opportunity.
My lord, that is what
I'll give you an opportunity.
My lord, the BB, my lord, even at the time of making representation to the BBMP, my lord, what they said is you get an order from the court, then we'll try to consider whether it can be regularized or whether.
Without, just 1 minute, without prejudice to the present proceedings.
Please, my lord.
You appear before them, you rectify. Then let them,
Lord, I
let
can
them state whether it has rectified or not.
Lord, so far as rectification is concerned, my lord, the top floor, which I have said, my lord, what their complaint altogether is that I have taken plans for ground floor, first floor and second floor. The remaining 2 floors, that is not the case. I have taken plan for ground, first, second and third. The 4th floor has been extended. The headroom is extended, which I'm ready to remove. Now the setbacks for your lordship, may kindly see the photograph.
No, I'm not going to enter into factual dispute. You appear before the BBMP, you rectify it. Let them
I make a representation to them. I'll also bring in these, my lord, I'll bring in these facts, my lord. I may be given that liberty. I'll make this representation. Let them consider it.
This is now building bylaw has no equity. If you have to leave setback, you have to leave it.
No, my
now
lord.
you appear before them, you rectify it. I am not going to enter into correctness otherwise. BBMP certifies there ends the matter.
Lord, may I make one last submission? Please, my lord. When site number 14 was also constructing along with me, my lord, he is the one who has extended the setbacks and he has attached it. There is no action against him.
No,
there is absolutely no against him, my lord.
That you take action against him. If law permits, let his building also go.
No, the whole setback, your lordship may kindly consider, my lord. The fact being that the this bylaw, my lord, will definitely come to my aid.
That allows the BBMP to look into it. You go before them, you rectify whatever is possible, let the BBMP certify it. I'll have it and then we'll see.
No, photographs even I have produced. All these or read before the chief commissioner. No, I have, my lord. That was one of my ground. No, that is one of my ground. From what I could decipher, my lord, there is only one thing, my lord, that he has not been afforded an offer.
That uneven site is not raised.
That is raised, my lord. It is raised, my lord. My lord, para 28 of my appeal.
Anyhow, now that I'm not entering into that, you go before the BBMP, you remove admittedly what your violation is. You explain to them, let it come back. We'll see. Let him place whatever it is. You consider it and you get back.
No, so far as this, they may consider this aspect of 9.2 bylaw also, my lord, because
I'll ask them to look into it. But finally, we are sitting only in writ jurisdiction. But anyhow, you appear before him, whatever admitted deviation, you undertake to remove it. Insofar as that 1 point, I'll ask them to look into it and then we'll decide them.
And another aspect which, my lord, the formal ground which I had raised, my lord, the Zonal commissioner had not passed the orders,
No, that
which is
will
pending consideration before the division. my lord.
that we'll see, that we'll see. The petitioner has raised and has contended that note 9 of BBMP bylaw 2003 provides for calculation of setbacks according to depth or width at the points where the depth of widths are varying. Full stop. It is further contended that average setback shall not be considered in such cases. That aspect is a matter that may be raised before the respondent BBMP. Full stop. As per prima facie, there appears to be deviations apart from the contention of the petitioner. Admitted deviations, petitioner submits, he is ready to remove.
The top floor one which has been.
Petitioner to appear before the
Zonal commission.
before the zonal commissioner, jurisdictional zonal commissioner on date good. Date.
My lord, need specific date. Should kindly be fixed, my lord.
They are all present in the office itself.
I did go.
On the one vara time ಕೊಟ್ಟು ಸಾಕು.
Of April at 11:30 AM.
9th of April.
On
9th of April.
9th of April at 11:30 AM. Matter to be posted 1 week thereafter, 9th of May.
1 week. 1 week.
On 21st.
Please.
Necessary report to be filed by the BBMP on the next date.
Lord. Another thing, my lord, just for a lordship consideration, they claim 100% deviation. This court, while granting an interim order, asked them to make another attempt for inspection. Lord. That is totally contrary. That was done in my presence.
No,
Totally contrary.
Yeah.
Totally contrary to 100% claim.
No, but then there is no end. Now tomorrow when they're there, you want to have one more inspection, you do it. Let us see.
My
I'll
lord, let
leave
them
it-
cons- my lord,
I'll
my
leave it
grievance
open
is-
for-
My lord,
My grievance,
my lord.
let them consider this 9.2 bylaw.
May I make one submission, my lord. Any amount of inspection will not solve the problem of my learned friend. Your lordship may kindly look into this. Kindly. Not an inch, not an inch of space is left. It is almost on the footpath. The deviation is almost on the footpath. How can there be even if there is an inspection, it is incurable. Inspection ಮಾಡಿದ್ರು ಕೂಡ ಏನೂ ಆಗೋದಿಲ್ಲ. He has to demolish right from the bottom. Foundation ಇಂದ ಮಾಡಬೇಕು. But there is one decision of the apex court, my lord, I have produced it. ತಾವು ಅದನ್ನು ಓದಿದ್ರೆ.
2024.
Please, my lord.
Yes, yes.
ಅದನ್ನ it has
Clear, that's clear.
Yes, my lord. The Supreme Court has directed the distribution of the judgment to all the state secretaries, including the High Court, all the High Court registrars.
That is,
I have produced it, my lord, your lordship may kindly go through that.
no, that's correct. There's not much discretion.
Yes, yes.
Now, so far as that, just look into that aspect. And then you come back. Whatever he wants to rectify, you look into that, make a report and submit.
My lord, my one more submission, my lord. This matter is being dragged for 5 years, my lord. In the year 2019, I have taken up the matter. Today, we are in 25. It is going on, my lord. This matter is simply going on. This has come up before 5 learned judges of this honorable court.
And then you have to advise your client.
As early as possible, but
Be an end to it. Now, suppose there is some, now you have relied on that note.
Please, no.
Suppose there's some slight setback variation that may be so. I'm saying even after that,
Please.
still if it's in violation, then what can?
that
Nobody
is
can-
exactly the point.
Consider the purpose of the
No, I'll not get into that. What I'm saying,
Please.
even if you look into that uneven size of the site, there may be a slight variation in the setback at the most, but it looks like it's an incurable defect. If it's incurable, the whole thing will have to go. We can't do
12
it.
feet, my lord, the BBMP says it should be 3 feet setback. There is 12 feet passage is what my submission is. And they always say.
Not on all the 3 sides.
Not 4 sides. So 3 sides, on 3 sides. On three sides it is. Lord, this is my grievance from day one. And Lord, even before the chief commissioner, I took the note that I will demolish the extended version. But even then, Lord, I'm suffering. If their case, they are.
Now, anyhow, you play,
Please,
you,
my lord, we will appear before 9th.
you videograph the whole exercise.
Please, my lord.
The respondent BBMP to videograph the entirety of the exercise at the cost of the petitioner.
Yes.
No, you
Suffered.
no,
Your
no.
lordship, I have already suffered.
There's no sufferance. You want to get rid of this, you have to pay. This is a small cost. I don't know how big a cost you have to pay.
That's sorry, my worry, my lord.
Yes. And use whatever some latest apps.
Lord, they have done with laser machines, my lord. They have done it.
Yes, next.
Lord, my humble submission, my lord, kindly, my lord, as early as possible, let this matter be disposed of.
Let us see.
For 5 years, this illegal construction is being prolonged.
Let us see.
Ultimately, the Supreme Court has come down very heavily on this illegal construction.
Let us see.
Please.
Grateful.
33, sir.
33.
Gutran.
34 in this case, I'm for the respondent number 5, my lord.
Petitioner intimate.
My lord, they have intentionally dragged the matter, my lord.
It's done.
ಅವರು ಸೋಮವಾರ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ ಬಂದಿಲ್ಲ ಸರ್.
Kindly interim or order may be vacated, my lord, please.
Madam, I'm putting it into the entirety of the dispute. Just wait. The petitioner had submitted before this court that
ಬಂತು ಮತ್ತೆ ಕರೆಯೋದು.
the order dated 4/3/2025 reads as hereunder. Subsequently, counsel for petitioner submitted that there was no response from the petitioner. Order dated 14/3/2025 reads as hereunder. The 14/3 ಆದ್ಮೇಲೆ 14/3 ಆದ್ಮೇಲೆ ಇವತ್ತಲ್ಲ 14/3 ಆದ್ಮೇಲೆ next order. On 21/3/2025, order reads as follows. Petitioner had filed his memo of retirement. The memo of retirement filed by the petitioner contained a letter addressed to the petitioner and receipt for having sent the communication by registered post. Matter was once again adjourned on 21/3/2025 as the petitioner submitted that he would inform telephonically. Petitioner has filed a memo and enclosed copy of communications sent by WhatsApp. In light of the same, memo of retirement is accepted. Petitioner's counsel is permitted to retire from prosecuting the proceedings on behalf of the petitioner. The petitioner is not present, nor has he made any arrangements for his appearance. The orders extracted above clearly evidence sufficient opportunity given. Accordingly, petition is dismissed for non-prosecution.
My lord's one submission.
230. 230. Mentioned to the court of
ನಾನು ಇಟ್ಕೊಂಡಿರ್ತೀನಿ. ಆಯಮ್ಮ ಒಂದು 100 ತಲೆ ತಿನ್ನುತ್ತೆ. ಹೇಳಿದೀನಿ.
My lords, with respect to matter at serial number 16.
One,
Matter at serial number 16, my lords.
16,
16.
second list.
First list, my lords. It is already adjourned, my lords.
Ah.
My one submission is that I had filed in WP is seeking for set aside of the notice issued by the BBMP, my lords, on the ground that the procedure was not followed, my lords.
I passed an order saying there has to be inspection.
Please, my lords, my lords' order says that cannot be done, my lords. First,
No, I've said inspection report. Then next date after the report comes, we'll ask them to redo the whole exercise.
but my lords' order.
Pass an order. I only asked them to inspect, make measurement and submit the report. After the report comes, we'll ask them to redo the entirety of exercise in terms of this direction. So you make a mention on the next date, we'll see what.
Please, my lords, next date can be given on Tuesday, my lords.
I've passed an order, madam, in which I've said, let the BBMP inspect and give a report. Let the report come, I'll ask them to redo it. We don't continue with the earlier notices. The direction issued would be that you redo the whole exercise after following the procedure. Yes.
And mentioning, my lord, serial number 14, the first list, my lords.
Ah.
You have adjourned it for tomorrow, my lord.
Ah.
Let it be on Friday, my lord. There is some inconvenience tomorrow, my
No,
lord.
no. Sign again. No.
List 114, serial number 14, my lord.
You inform the others.
I have informed the other side.
Yes.
No, serial number 28, list 2, my lords. List 2, serial number 28, my lords. Lords, IA is filed for, not for direction. Lords, IA is not put up in the lords, the hospital, for list, lord.
28.
28, my lords. List 2.
IA for?
IA for direction, my lords.
You inform the other side.
I'll inform, lords.
Both are there. I mentioned the connected matter.
Relist.
Any date, my lords, convened to the court, my
Date
lord.
But I may be.
Office to put up IA for direction stated to have been filed in WP 1507 of 20. Yes.
Please. End of fresh matter. Fresh matter serial number 1. Dilraj Rohit.
Petitioner by me, my lord. My lord, here, the Mangalore City Corporation, without issuing any notice, my lord, has demolished the compound wall. The permission is to, my lord, to lay the concrete road.
Who appears for Mangalore City Corporation?
Harish
Bandari.
You bring in.
Please,
I'll pass over. You bring in.
please, ma'am.
Pass over.
serial number 2. SK Acharya.
This is the Panchayat demolition drive, eviction drive, your lordship, day before yesterday's order, no panel council. Same building. Insofar as the petitioners are concerned.
Same identical order.
Pardon me, Lord.
Identical order.
Same building, same.
Emergent notice to the respondents. Also, the petitioner submits that in a matter involving identical factual matrix relating to occupants of the same building, this court in WP 8263 of 2025 had passed an interim order, and on parity, the same order may be passed in the present matter also. Full stop. The interim order passed in WP 82663 of 2025 reads as follows. Accordingly, there would be, accordingly, the petitioners would not be dispossessed except in accordance with law, even if auction proceedings were to be concluded. The possession of the petitioners is protected in the next date of hearing. List the matter along with WP 8263 of.
Please, my lord.
2025.
Grateful. May seek for hand delivery, my lord. Tomorrow is there.
2025 is allowed and petitioners dispense with production of certified copy of annexure C, subject to the undertaking the same would be produced in due course.
Please, my lord.
Pass over matters, serial number 7. So please that age.
I'm the petitioner in this case, my lord. The respondent number 4 has acquired the land measuring survey number 75, my lord, and they have formed the layout, my lord. Thereafter, they have allotted to the site number 5, 1 Sri Narsegowda, my lord. And Sri Narsegowda sold the site in favor of Sen Uchaya on 1966, my lord, annexure A, my lord, through register sale deed, my lord. Thereafter, the Senna Uchaya also sold in favor of Arlegowda, my lord, on 12/11/1976, my lord. The annexure B, my lord, through register sale deed, my lord. Thereafter, the Arlegowda died, leaving behind his son, my lord, Narsaya, my lord. The Pautikata was effected in favor of Narsimaya, my lord. Thereafter, he also died, my lord.
The place where they're putting up construction.
Without leaving setback, my lord. And
no, correct. That let them find out. They'll find out and then get back. Then we'll see what is to be done.
My lord, this property belongs to, my lord, the Panchayat Gram Thana. Now we has encroached on the road and we have left, my lord, 11 feet, which is accessible. I find out from the PDO. He want 30 feet extension of road.
No, my lord, we want only 20 feet, my lord.
And it, my lord, he has to file a suit for injunction. That is the prayer he has sought for.
Oh, my lord. They have formed the site, my lord. Respondent number 5 only formed the site, my lord. They have issued the license to me, my lord, annexure M, my lord.
Now let us see. Let them find out and come back by Monday. You find out and come back by Monday, we'll see.
Till date, maintain status quo, my lord. Otherwise, the construction will be
But we are
completed.
putting up construction in the Panchayat land. It's belong to the Panchayat area and we are putting up construction in the Panchayat site. He wants, my lord, a 30 feet road. You have left 11 feet road. That is the information, but I will get back.
Oh, my lord, except 20 feet, we want now.
Let us see. If it is a public road, it's a different matter. We'll see. Let us. AG is directed to accept notice of first respondent. Joint Counsel A. Nagarajappa for respondents 224. List the matter in the orders list on Monday.
Till date, my lord, maintain status quo, my lord. Kindly see the photographs, my lord. Annexure Q, my lord, 6 feet.
Now, correct. Is it a public road? We don't know. Let him find out. In case case is made out that it's a public road, notified, then we will ask him to pull it down.
They formed the layout, my lord, in the year 1962, my lord.
Let us see.
They have allotted the site in favor of my previous vendor, my lord. Annexure Q, kindly see, my lord, for a moment, my lord. In northern side of my site, my lord, there is a road, my lord. On 2 to 3 feet ಮಾತ್ರ ಬಿಟ್ಟು putting ಹಾಕಿದ್ದಾರೆ. Already construction is going on, my lord. Plinth ಕೂಡ rise ಮಾಡಿದ್ದಾರೆ, column ಕೂಡ rise ಆಗಿದೆ, my lord.
Correct. Where is the road now? Is it notified as a road?
There is a road, my lord. Kindly see, my lord, annexure M, my lord.
It's a road as we see it, but is it notified road? If there is no notified road, then you can't help it.
They have issued the kata in favor of me, my lord, showing that there is a road, my lord. Kindly see.
What is the width of the road? We don't know. We don't know the width of the road.
Annexure G, my lord, page number 46, my lord.
Correct. So what is the width of the road now?
18 feet ಬಿಟ್ಟಿದ್ದಾರೆ, ಬೇರೆ ಎಲ್ಲ ಕಡೆ 18 feet ಬಿಟ್ಟಿದ್ದಾರೆ, my lordship. In this, we are adjacent to, they are blocking my road and put up the construction.
My lord, you want to park his cars, my lord, in the
No,
premises. That
it's
is
a public road, my lord. We don't want park the car, my lord.
No, we don't know what is the width of the road.
Till date, my lord, maintain status quo, my lord, please. I'm humble request, my lord. Otherwise, they have put up the construction, my lord.
Correct. What is the width of the road now? Now, if it's 11 feet road, you have said they've left 11 feet.
No, my lord, 18 feet already,
No, how much have they left now? What is the width of the portion that they've left?
4 to 5 feet they are left, my lord. Kindly see annexure Q, my lord, page number 62, my lord. Kindly see the photographs, my lord. Immediate to my site, my lord, they are putting the construction, my lord. And dig the road and put up the construction, my lord. Raising the column, my lord.
So what is the space that is left?
2 to 3 feet, my lord. That's all, my lord. And page number 64, my lord, annexure Q, my lord. There is a road, my lord. Kindly see, my lord.
Now you find out and get inside.
Find out.
Needless to state, any construction by the respondents would be subject to orders to be passed. List the matter in the orders list on Monday. You find out now if in the kata it is shown as road, then you must say how much feet you have left, 10 feet, 11 feet. Yes.
8 feet.
Is to 34.
Mahesh, Vijay, 34, Pawan Kumar.
Now you're ready to rectify.
Lord, one floor, additional floor, no, Lord, it is a bedroom tenement is constructed on 4th floor, which is, of course, my lord, admittedly beyond the permissible limit. So it is about 500 square feet built up area, 2-bedroom house. It is fully furnished now. That is the reason we may require some considerable period of time, my lord. I have.
Give the affidavit.
I have- I have stated on oath about, my lord, my hardship. Paragraphs 5, my lord.
I am helpless.
No, of course, my lord, I would remove that. Only thing is, my lord, I may be granted 3 to 4 months time. That is what I have stated. Because initially I may have to remove all the materials, my lord, without causing any damage to them. Then only I have to demolish.
Stand. Now, if according to you, additional plan modification is impermissible, so be it. But don't wait till the lapse of 3 months. If according to you, it is not possible to permit him to put up one more floor or to regularize it, so be it, you issue an endorsement. There ends the matter. The petitioner has filed an affidavit in which undertaking is made that they will remove the extra flow, additional flow within a period of 5 to 6 months.
They have said 3 to 4 months.
Huh?
In last, they have said
3 to 4 months. 3 to 4 months. In light of the said undertaking, respondents not to take any action pursuant to the impugned orders for the present. Now, the Chief Commissioner's order you have challenged.
Yes.
Necessary records relating to the 248 proceedings be placed before the court at the time of hearing. The respondents could file a photocopy of the proceedings. List a week after next.
Yes.
One serial number 35.
Lordship permission, my lord. Monday, my lord, holiday, my lord. Ramjan, Friday, my lord. We have it on Friday, my lord.
First of it.
Friday, my lord, 28, my lord.
Friday. First of it.
28, my lord. Otherwise, they will complete the construction, my lord.
They are only going to put columns. If there is no road, we will pass orders. I have already said subject to outcome.
Please, my lord, grateful.
35. Serial number 35. Girisha PL,
For respondent number 4,
Karthik
my
AL.
lords.
Yes, what is the matter? What is the matter?
There is the petitioner, in the premises of the petitioner, there was a cutting down of the tree which had fallen on the person who was walking towards the footpath.
There was a
There was a cutting of the tree inside the premises of the.
tree.
My lords,
The tree was cut by whom?
by themselves, the petitioner.
Ah,
And it fell on the person who was walking on the footpath. So we had on humanitarian grounds, we had given them the 3 lakh rupees. The lordships are suggested to provide education for the kid.
no. Who cut the tree? Who cut the tree?
Petitioner themselves.
Then why are you responsible?
My lords,
Huh?
the tree was in the premises of respondent number 4.
No, I'm saying, why is the BBMP responsible for their cutting the tree?
That's what, my lords, we had given a permission letter on the day of the cutting down of the tree. They had provided the request on the. They had given a letter, my lords. My lords, I represent for.
No, have you followed the procedure? Have you followed the procedure
My lords, they
of
did
giving
not fo-
permission?
My lords, the discussion on the previous occasion was to whether the BBMP has to held responsible or not, my lords. That was the discussion we had.
Whatever oral discussion,
We are not responsible for.
no, don't tell me about any oral discussion. Any written order is passed, you take off from the written order.
On 13/2,
Ah.
this court has ordered to file a disability certificate, my lords, by the petitioner.
No, now who has cut the tree?
My lords, there is no cutting of tree, my lords. Your branches itself fell on the petitioner, my lords. The tree was inside my premises, my lords. Respondent number 4. I'm the school, my lords. I'm the school, my lords. I'm a respondent number 4, my lords. The tree
Anyhow,
was in my premises. my
let the pleadings be complete. You file whatever you want in writing.
The petitioner, they have to file the disability certificate, my lords. That was the order passed by the other bench.
Let us see you complete it. Pleadings to be completed by the respondents. List after 2 weeks. Yes.
36.
That's great.
36.
Petitioners,
Kindly pass over the matter also.
matter pertains to TDR, my lords,
Ah.
where I had relinquished petitioner number 1, 2 to 8, my lord, are the owners. And petitioner number 1, my lord, had entered into an agreement for sale. And the corporation wanted, my lord, property on the basis of TDR. The owners, my lord, were not willing to give up the property for TDR. So, my lord, the petitioner number.
Now, some proceedings, it was referred to BDA. This is the
No,
part.
no, my lord, not this. This is, that is a different matter, my lords.
Now you appear for whom?
I,
R2.
the authority, MUDA, my lords. Bangalore Urban Development
Who's the
Authority.
answering respondent?
MUDA, my lords.
Let us see, I'll pass over. If time permits, we'll take it.
Yes. Because land is relinquished, my lord. Land is relinquished. They are utilizing it. Corporation has sent the recommendation to grant TDR. So all the preconditions of 14B are met.
So what remains now?
Our in the statement of objections, they are saying, my lord, they doubt whether it is a public purpose or not. Solid waste management ticket tagondidare.
You pass over. Let us.
Yes,
Or we'll have it some other day. Pass over, I'm doubtful.
very well. Any other date?
Relist on. Yes.
16.
Grateful, Your Lords.
37.
Apply.
Point number 7.
Yes.
But I appear for petitioner number 11, my lords.
37.1 connected matter. Here the bank in this matter.
No, what is the first matter, 37?
No, we are for a petition, madam.
What is the
This is, madam, BBMP has sealed the properties of the shops without any issue of show cause notice or even a demand notice, madam. So since the shop were sealed, we approach, tenants have approached before the Honorable Court, and during the pendency of this petition, we have paid 50 lakhs, madam. 50 lakhs during the pendency of this petition.
Yes.
I am for respondent 6, my lord.
Owner.
No, who appears for BBMP? Yes.
We have received 22,94,000 alone. The rest of the amount we have not been informed.
How much is the due?
It was around 50.
How? Huh? Huh. Huh. Huh.
Who has to pay the tax is the question.
Hmm.
The main time, the LIC or also connected where they are so they also want to auction the property. BBMP is due of 1 crore 85.
But if reassess the entire premises means we are ready to pay, my lord. Discuss with me.
No, no, now you are ready to,
1.8, 1 crore 80 lakhs is the, with penalty, 1 crore 80 lakhs is the dues, my lord, tax. So they are not reassess the entire premises, my lord. The tax is higher than normal slab. my lord.
correct. So how much you will pay now? They have paid 50 lakhs.
Total 50 lakhs.
Tenants have paid, not you.
Before 25 lakhs I paid.
In the earlier round of litigation, my lord, last year, owner has paid 25 lakhs, my lord. Since our submission is done, if the reassessment is done by this Honorable Court has directed in the earlier round of litigation to make a reassessment, because 1:4 is the penalty that they have done it, my lord. So this is not the, even there is no demand notice served to the tenant or to the owners, my lord. Hence, we request this Honorable Court to direct the authority to reassess the tax and fix the exact liability, my lord. Then we will be paying the tax as per this, because there are multiple proceedings. The bank is also initiating proceedings. There is a civil court is proceedings. Hence, in order to ascertain the tax liability.
This report is filed. No, but how many times we can go on giving opportunity?
Owner, there is a
No, last time the inspection report is filed.
but there is no reassessment, madam. Inspection report was ordered in order to make a reassessment, madam. But there is no reassessment by the BBMP till date, madam. That is the problem. We are unable to find out the exact liability, madam. 1.585 crore, there is no even demand notice, madam. So how it is ascertained, we don't know, madam.
It is 1:4, my lord.
Then
We
you
are
have,
not reassess the entire.
no, you appear before them. I'll have it next week. You appear before them. Let them, you appear before the BBMP and you come back next week.
Please, madam, please.
I have a submission, Lordship. I am the pleading applicant, Lordship. I am also sitting in the same footing of
Let us,
petitioner.
let us.
My shop is also closed. Other petitioners, shops got open, Lordship. I will also be entitled to the similar value. I paid 15 lakh rupees as a lease amount to the owner,
No,
Lordship.
no, how much tax you're going to pay, we'll consider. How much tax you're going to pay? They paid together 50 lakhs.
They are the
Yes, sir.
tenant, Lordship. I am on the lease. I have paid a 15 lakh rupees
Correct.
lease.
So how much tax you're going to contribute, we'll see, then we'll deseal the premises.
2.5
Otherwise,
lakh rupees.
How much you'll pay?
2.5 lakh rupees I'll contribute.
Now you have,
I am a pleading applicant. I may be plead as a petitioner and direction may be issued to pay 2.5 lakh rupees and my premise will be allowed to.
the court has been reduced to street vendor.
No, Lordship, because we are a sufferer because Lordship, this is a dispute between the landowner.
Deseal it. The
Other petitioner
Pleading
shops got
applicant.
desealed. Lordship.
pleading applicant in IA number 1 of 2025 undertakes to pay a sum of rupees 2.5 lakhs to the respondent BBMP, which may be accepted towards legally payable dues. In light, within how much time you'll pay?
Within 4 weeks, Lordship. Within 2 weeks, Lordship.
Said payment to be made within 2 weeks to the respondent BBMP. Necessary affidavit to be filed to the effect that the payment would be made within the period granted by this court. In light of the same, respondent BBMP to deseal the premises of the impleading applicant. Relist the petitioners as well as the impleading applicants to appear before
BBMP.
ARO, Assistant Revenue Officer, on date good.
And after 2 weeks,
Second week of April, Lordship.
after 2 weeks, madam.
No, 1 week next week.
My lords may say that
On 5th of April, the respondent BBMP to consider taking further steps for reassessment.
Reassess.
The respondent BBMP to take its stance regarding the amount of tax in due. Relist the matter on.
Direct the reassessment.
70.
regard, my lord.
My lords, I appear
Reassessment.
for petitioner number 11 in this matter, my lords.
Let us,
No, my lords, I am a bank and I stand on a different footing in the sense that I have undertaken to vacate and I have made payments already, my lords. So my lords may only say that petitioners number 1 to 10 and the impleading applicant may meet, my lords. In fact,
1 to 10.
please, 1 to 10.
Respondent number.
You are vacating.
Because I am
11
vacating.
is vacating.
Lord, it's recorded in an order of this honorable.
Yes, yes.
My lord, 37.1, it's a connected matter.
Yeah. So you also are subject to the same condition. Different.
No, there is a different
My
matter.
lord, 37.1 is a connected matter wherein where the financial institution was given loan to the
Now let us see. We're not,
Yes.
we're not putting the property in auction as of now.
No, we are going to take possession only as symbolic possession.
No, there is a time limit to submit a reply also. We have not even submitted the reply also.
Let us see.
13 notice also.
Let us see.
Yes.
BBMP is now not going to take any action
Much of
insofar as the property. We'll see.
Much of.
Yes.
Lordship, my humble submission, Lordship, it's a
Yes.
dispute between the owner and the BBMP.
Yes.
The tenants are facing the difficulty.
BBMP has nothing to do with the disputes. It wants its tax. You pay and recover from
No,
the.
no, the property, the tax is the liability of the owner, Lordship.
No, no, no. Whoever is in occupation has to pay and you recover from the owner.
So at least he also should appear along with us and to participate in the proceeding, because ultimately,
Needless to state, the owner is required to be present along with the petitioners and the petitioner number 1 to 10
1 to
10
and the impleading applicant.
and the impleading applicant. Yes.
38, Girish Baldare.
Much of. Interim order
Much of.
continue.
Interim order in operation is extended to the next.
Much of.
38,
Order number 2, of the construction without obtaining any sanction plan and license. Annexure Q, my lordship.
No, no, who, somebody must appear now.
Respondent
Commissioner
4, I
Chikmagalur-
trying to serve the by hand summons.
Huh?
I made an attempt to serve the hand summons to the respondent number 4, but I didn't receive
My
it.
lord, we have received the copy today, my lord.
You appear for?
We appear for R
R2
R2. Yeah.
You appear for which respondent?
R2.
R2.
R2 to R2, my lords.
Learned Council.
R1 and
That's on
R2,
Bendy
R3 is the
itself.
government.
R1 and R3, I will take notice, R2 represented.
Learned
R4
Council
is the
A
private
Nagaraj
party.
accepts notice for
R2,
the
my
respondent.
lordship.
AGA accepts
1 and 3.
appears for respondents 1 and 3.
3, 1 and 3.
So what is the relief you are seeking?
I'm stay of the further proceedings in the interim prayer.
No, no, what is the main relief?
Main relief seeking writ of mandamus, my lords, which is in page number 118, my lords.
Who's putting up construction?
The respondent number 4, my lords. I also produced the photographs. Now construction is continued.
We'll see.
I also obtained the interim order. 116 photographs I have produced along with the writ petition 116 and 117.
No,
Now-
there's civil dispute pending.
Yes, my lords.
Let us see, let us see.
Well, a civil dispute I have obtained the
us-
interim order, but the vendor against the vendor of the respondent number 4.
Now you find out if there's any plan.
There is no plan and sanction plan
you-
and license is not obtained by the respondent number
That
4
you
without
find
doing
out.
so.
And make your submission. I'll have it on Monday.
Yes, my lords.
Learned
Much okay.
counsel for the second respondent is the second respondent directed to ascertain whether the construction of the fourth respondent is with a sanction plan. Relist the matter in the orders list on Monday,
Tuesday.
Tuesday,
Monday is
Tuesday.
holiday, my lords. Tuesday.
Tuesday. Yes.
39,
Tuesday.
serial number 39, first of April.
Yes.
Having the report of audition.
What is the matter?
The report was supposed to be filed in this residential area. They are running some industry regarding. So this court, my lord, Panchayat has not renewed the license because of the sound in the middle of the residential area. This court directed the pollution control board submit a report after inspection. Now they have submitted a report. I saw, my lord, in the report also they have suggested certain remedial measures, that is the last para.
Conclusion.
Conclusion.
I put a flag in the report.
In fourth page. Conclusion.
Now you take your stand.
I
You
will
file
take-
your affidavit regarding this report.
Please, my lord, please,
Let us see.
please.
Petitioner to take his stand as regards the conclusion mentioned in the report by the environmental officer, KSPCB, full stop. Such stand to be taken by way of affidavit by the next date.
Entry
Release
order.
the matter.
Entry order maybe.
No, that late.
Please, please.
You are required to rectify this.
Please.
Interim order is extended till the next date. Release the matter on
17th.
17th. Yes. Now you have to rectify it or make changes and place it on record.
And
Now
the
they're saying
pollution control
machines-
officer has stated that, ma'am, there is a sound.
Yes.
But in the village level, his report says he diluted the report also, maybe because of the vehicle sound. It may not be true, but let them file an affidavit. Thereafter I will.
No, in case they have said that you have to replace some machines, etc.
Ah.
You have to place on affidavit.
Yes.
How you are going to take note of the conclusion?
Yes.
40.
Petitioner, my lord. Last time directed to
Present
file
the-
objections by the respondent.
That my submission may kindly be taken on record, my lord, but writ petition can be disposed of. But we will not evict the petitioner from the premises without due process of law. But the petitioner is due a sum of rupees 1,36,710 as arrears of rent. The last rent paid is on 14/5/2024. 14/5/2024. Since then, my lord, he has not paid the rents to the.
You file a memo.
Please.
Insofar as the rents are concerned.
Please, let the petitioner be directed to pay the arrears of rent, my lord.
I will
Till the
file
time
memo.
bound,
Memo filed.
I will file memo of calculation.
Memo filed by the respondent to the effect that the petitioner is in due of rent of rupees 1,36,710.
10.
It is further submitted that no rents have been paid since 14/5/2024.
Please,
You file the memo.
please.
For the stand of the petitioner regarding the same, relist the matter on date could. The interim order earlier passed is extended till the next date. Meanwhile, you get an extract of the accounts extract
Please,
by the next date
please,
and place the accounts extract on record.
Please.
Let him have a look at it.
I will file memo, my lord, memo of calculation if I paid.
Yes. You place the accounts extract.
please.
Yes, next.
41. Rajeshwara PL.
44 is also, my lord, similar matter. Your lordship may kindly take up for serial number 44 matter, my lord, because I have, my lord, seeking for, my lord, mandamus, my lord, grant a opportunity to, my lord, to file, to cross-examine the on the same day, my lord, fix the date, my lord, on the same day.
No, who appears now?
My lord, I served the copy, memo is also, my lord, coming to this court. I filed the acknowledgement, he said, my lord, he will appear, my lord.
Who appears? Who
My
is
lord,
it?
Narayan Swami, my lord, he is an advocate, local advocate. My lord, I served the memo, my lord.
No. How will he appear here?
Well,
Yeah. As a local council or there?
my lord, local council, he is, my lord, I intimated him, my lord, he said, my lord, I will take note of that, my lord, WhatsApp appeal memorandum and annexures I have sent. By WhatsApp, he has acknowledged also, my lord. He has acknowledged, he has received.
Right now, WhatsApp ಅಲ್ಲಿ ಮಾತಾಡ್ಬೋದಾ?
ಅಲ್ಲ ಅವ್ರು ಚಿಕ್ಕಬಳ್ಳಾಪುರದ.
Correct, ಅದಕ್ಕೆ ಹೇಳೋದು. Some local council means we can call. Somebody must put in appearance, isn't it? What we can do?
My lord, I requested him, my lord, to please engage some other advocate at least, my lord. But he has, he said, my lord.
Notice ಏನಾಗಿದೆ?
My lord,
My lord, emergent notice sent, my lord.
Well,
It is, my lord.
5/3 it was ordered to, it was posted for orders, my lord. Till today, nothing is going on, my lord. Necessarily, it is dragging the matter, and the first 41st petition become infructuous. Because by virtue of the second petition filed, challenging the very opportunity has not given for cross-examination. 41st petition is challenging the very initiation of the proceedings. So that become automatically infructuous.
No, that does not survive.
No, sir.
My lord,
They have
it is
participated in
survived,
the
my lord. It
proceedings.
is survived, my lord, because the complaint has given on the individual capacity, my lord.
No, that it cannot be raised at the stage of order stage of the.
My lord, now, my lord, now I'm, my lord, pressing for
Yes, they have
second petition, my
participated
lord.
and
No, no,
in the proceedings,
No, that does not survive.
Please, my
that
lord.
does not survive.
41 does not survive.
Yes, my lord.
Please, 44, my
No, unless there's somebody who
My lord,
served.
my lord,
Uh,
he said, my lord, he fixed the date, my lord, any date, my lord, I will cross it on the same day, my lord, let them post it for judgment.
Can't pass an order until they are there.
My lord, I request, my lord, I will take hand summons, my lord.
Petitioners at
My lord,
liberty.
because
Seat
DC,
number 41
Please. 44.
has been filed. Seeking for. But notice ಏನಾಗಿದೆ ನೋಡಿದ್ರೆ 44. Petitioners filed a writ. Present writ petition. Seeking for setting aside the proceedings pursuant to the complaint dated 26/9/2024. Though various legal contentions have been raised, it is noticed that the petition for disqualification has now been posted for orders. And in light of the same, it would not be appropriate at this stage to take note of the contention raised, which has been raised at a belated stage. Accordingly, petition is disposed of as not calling for adjudication, taking note of the stage of the proceedings before the Deputy Commissioner.
yes,
All contentions, however, are kept open to be urged at the time of to be urged. All contentions, however, are kept open.
Yes.
44th order. ಇದ್ರಲ್ಲಿ ನೀವು PFA ಕೊಟ್ಟಿಲ್ಲ.
ಇದು ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ ಅದು ಸೇಮ್ ಡೇ ಮೈ ಲಾರ್ಡ್
44
ಅಕ್ನಾಮೆಂಟ್ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇವತ್ತು
44 ಅಲ್ಲಿ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ ಐ ಹ್ಯಾವ್ ಗಿವನ್ ದ ಪ್ರೋಸೆಸ್ ಮೈ ಲಾರ್ಡ್ ಐ ಹ್ಯಾವ್ ಆನ್ ದ ಸೇಮ್ ಡೇ ಐ ಹ್ಯಾವ್ ಗಿವನ್ ದ ಪ್ರೋಸೆಸ್ ಮೈ ಲಾರ್ಡ್ ಇಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಬಿಕಾಸ್ ಮ್ಯಾಟರ್ ಇಸ್ 2 days ಬರ್ತಾ ಇರೋದ್ರಿಂದ ಅವ್ರು ಪುಟ್ ಅಪ್ ಮಾಡಿಲ್ವಂತೆ ಅವರು ಅಕ್ನಾಮೆಂಟ್ ಇಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ ಅಕ್ನಾಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್ ಐ ಹ್ಯಾವ್ ಸಬ್ಮಿಟ್ ಮೈ ಲಾರ್ಡ್.
The petitioner is permitted to take out a notice by way of hand summons to the respondent 2 and 3.
Dispose of.
2 and 3.
Please.
Relist the matter on Friday.
Lord, a oral direction has been given to DC not to pass orders, my lord. 8 order may kindly be passed, whether to pass or not.
Till the next date, no orders to be passed by the Deputy Commissioner. Relist the matter on
48 may kindly.
Friday.
Please.
Now, if you don't, ನೀವು ಸುಮ್ಮನೆ ಆರ್ಡರ್ ಇದೆ ಅಂತ
My lord, today itself I will take the hand summons, my lord, I will serve.
you must serve the hand summons by Friday.
Please.
This time ಅವ್ರು ಹೋದ್ವಾರನೇ ತಗೊಂಡಿದ್ರೆ ಇಷ್ಟೊತ್ತಿಗೆ ಆರ್ಡರ್
to issue
ಅಲ್ಲ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಇದ್ರಲ್ಲ.
to issue emergent notice to the respondents. Notice is also ordered through special bailiff at the cost of the petitioner. Yes. Yes. Next.
42, BB Shivkumar.
ಅದು Tuesday, Monday, Tuesday.
Yes, fine.
CBMP was directed to file some report.
My lordship, grant me 2 days time to file a 248 proceeding, my lordship. My lordship direct to the produce the 248 proceeding. So please grant me 2 days time, my lordship. I'll place the all records, my lordship.
Proceedings.
Yes, my lord.
You have not been served.
No. That is their contention.
They have contested, we filed the appeal also.
Appeal it came to dismiss, my lordship. They have to challenge before this court. So I'll place all the records 2 days time grant, my lordship. 248 proceeding, my lordship.
Who's 5 to 8?
I'm for respondent 5 to 8, my lords.
Ah.
We have filed our statement of objections yesterday, my lords, where we have annexed the photographs of the notices having been pasted on the compound wall during the construction period in 2023, my lords. And some of the photographs, my lords, annexures are 2 onwards, my lords. And more particularly, page 17, my lords, page 16 and 17, which is annexures R5, my lords. It can be seen that the notices were pasted on the pillar and the construction work is ongoing, my lords. This work was completed from 2023, they complete the work, and the status as on this date, my lords, is enclosed from annexure R9 onwards, my lords. Annexure R9 onwards, my lords. We are the private respondents, my lords. We are the immediate abutting neighbors, my lords. We've been agitating this particular issue since 2023, my lords. R9 today, the status, if it is compared from what it was at the stage of notice issuance and what it is today, your lordships, they have put up additional floors without any setbacks. And moreover, the construction has come up from the road itself, my lords. Most of these defects are incurable, my lords.
Let them place it on record.
I place
Yes,
it, my lordship.
Relist the matter.
So only
of
some next week, my lordship.
date good. 9.
Much obliged.
43. Prakash.
I'm per respond 2 and 3, my lords.
Prepared for the petitioner. Lord, the allegation is that encroachment on government land, annexure C, annexure E at page 27. Lord, the very same subject matter, my lord, the special court, my lord, constituted under the Land Grabbing Prohibition Act, Lord, has already registered a case, my lord, and as a proceedings are initiated at annexure F in page 29. The very same subject matter, my lord.
Yes, Jagdishwara.
Yes, my lords. There are proceedings initiated before the land grabbing court by the BMTF, my lord, but under the act we are empowered to take action. That is second respondent, my lord. We have issued a notice calling upon them to produce the document along with the objection. He has filed objections as per annexure G, my lord. We will consider it, we will dispose it up, my lords. Annexure G, page 55. He has replied for my notice. Before passing any order or before taking any decision by the concerned officer, they approach this honorable court for filing the present petition.
We have submitted our reply, my lord. Now my only submission, my lord, is that when the special court is seized with the matter, which is a civil court insofar as civil issues.
Let us see. Now you examine the contention that there can be no parallel remedies and you make submission. I'll have it on the next date. They are raising this submission that there cannot be any parallel proceedings. Examine that and make your take your stand.
Please, madam.
The notice, impugned notice says, my lord, that immediately we will be evicted, my lord. That is
No. We have called for objection statement from him.
It's only at the initial stage. We'll see.
Yes.
The respondent counsel for the respondent number 2 and 3 to take their stand regarding the contention of the petitioners that there cannot be parallel proceedings under the Karnataka Land Grabbing Prohibition Act 2011, as well as under the
Lake Authority Act.
Lake Authority Act.
Under the
Lake Authority Act.
Under the Lake Authority Act.
Under annexure C,
relist on. Yes.
Let them not precipitate.
No, let us see. Nothing will happen now.
Nothing will happen. We only called for objection from him.
Yes.
After 10 days, may not send a date.
Date could. 17. Government is not so efficient. Yes.
Wherever they are active, my lord, without notice also they will demolish. My lord has seen several instances.
Let us see.
Date, my lord, 17.
17th of April,
Yes.
44,045, serial number 45.
That your lordship may kindly come to annexure H, mal that, challenging that notice issued by the second respondent regarding that removal of encroachment, mal that demolition notice has been issued, mal that. That the petitioner is an owner of the constructed house number 83, mal that.
Just 1 minute, Pradeep Kumar.
Pradeep Kumar, HL Pradeep Kumar.
The earlier direction not to take any precipitative action pursuant to annexure H is extended till the next date. Relist the matter on date.
20th of April.
Yes.
46, sir.
Yes,
Chidambaram.
Yes, Somayaji.
Somayaji. Somayaji.
Passover. He was there, just see. Passover. Yes.
47. Serial number 47.
June 2021, Muda auctions a site. The reserve price, my lord, is fixed at 45,66,000. My lord, the auction requires 2 bidders and enhancement of 10,000 at a minimum bid. But I placed a bid of 47,66,000. I am notified as the highest bidder. An SMS is sent. I paid 25,000, 25% of the auction amount. Thereafter, my lord, the Muda cancels my bid on the ground that they have not received the expected amount as the enhanced bid. This, my lord, was not one of the conditions of the public notice which they had given. In the statement of objections, my lord, now which they have filed, they contend, my lord, in the adjoining sites, they have received an higher amount. Therefore, they are entitled to cancel my bid. This auction of the adjoining sites, my lord, was done 3 months after my auction.
Let us, yes, what is the legal position?
My lord, may kindly take the notifications, my lord, that e-auction notification annexure A. My lord, may kindly see the condition number 9.
Condition number?
Condition number 9. My lord would find in the 5th line. We'll start from the 5th line. At the bottom of the page, my lord. My lord gets it. Not as per
yes.
Rule 6 clause 2.
As per?
Condition number 9.
Yes.
As per Karnataka Urban Development Authority Corner and Commercial Sites Rules 1991 column, that should be Rule 6 clause 2. The commissioner.
Just one.
Please.
Rules code. Karnataka Urban Development Authority Corner and Commercial Site Rules. Yes, read.
The Commissioner, Mysore Urban Development Authority has the right to accept or reject the bids of auction sites. Now, what happens, my lord? The base price was fixed at, my lord, 45 lakhs and odd, whereas the bid was about 2 lakhs more than that. Lord, it was found, my lord, that the bid amount was not satisfactory and it was not competitive. Now, 2 months later, there was one more notification which has been produced along with the notification, I mean, writ petition itself.
So now, you just point out the legal position that in such public auctions, you have the right to cancel it after this stage. You point out, then we'll see.
6 clause 2.
Is there any case law on the point?
That I need to examine.
There's no case law, my lord.
Do your investigation.
Yes, madam.
And you come back.
Please, madam.
Now, if there is any discretion, even at this stage of the bid having been accepted.
Please, madam.
Whether at that stage also you can resile from it, you point out the legal position wins.
Yes.
Another clarification they'll have to give, my lord. At para 14, I pointed out, my lord, where for a sum of rupees more less than 2 lakhs, they accepted the bid and executed the sale deeds.
So correct. Now we are not so much on the next sale deed or the amount, but on the point whether you retain any discretion in these matters. That you point out, let us.
Please.
6.2 is clarifies that also. My lord, may see rule 6.2. It says, my lord, that to assign the officer conducting the auction sale shall have the right to accept or refuse any bid after assigning reasons.
Now, at least in terms of rule 6.2.
No reasons are assigned, my lord. No reasons are assigned.
You have
but yes.
place something on record.
Please, my lord. It's not that no reasons have been assigned. We have categorically said, my lord, that it did not attract the competitive price. I'll investigate in so far as
The legal
rulings on this point is concerned. I'll place it before the court.
relist the matter after 10 days. Now that amount, you keep it at least in an FD so that it earns
Please,
some
my lord.
interest.
Please, my lord. Please.
Interim order to continue. my lord.
Interim order earlier granted is extended till the next date. Yes.
Grateful, my lord.
Ravi Shankar, say, 48.
My lord, I
Ask for
appear
more
for
than
respond
45
number 2 and 3, my lord. I sought for some instruction, my lord. Kindly have it day after tomorrow. My lord.
Last date of hearing also, my lord. The same submission had been.
Note on. At request of R2 and R3. List the matter on
9th,
9th. Yes.
49. Second BS, 49.
What's for the petitioner? Whereas the petitioners are the educational trust members, Al Hasanath Education Trust. In the previous occasion, Coordinate Bench has directed us to file an affidavit saying that the educational trust which we are going to build, construct a building, that shall be restricted to use for the cultural and library purpose. And accordingly, we have filed an affidavit, my lord.
What is the endorsement now?
Endorsement is that, my lord, that the Panchayat has conducted a meeting and they have passed in a resolution saying that the educational trust is being misused and it's used for the religious purposes. But we have filed an affidavit that we shall restrict ourselves for the educational purpose only.
Now, where is the proceedings? Proceedings at annexure A.
Please, my lords.
Just let us see.
Please, my lords. My lords, typed copies there, my lord, in page number 19.
Yes. Now, pleadings are completed.
Please, my lord.
They are filed.
Please, my lord.
So, what is the impugned and resolution?
Impugned resolution is that, my lord. My lords, in page number 20, my lords.
19.
19 and 20.
Read.
Please. Al Hasanath Education ಮತ್ತು ಕಲ್ಚರಲ್ ಟ್ರಸ್ಟ್ ಅಳದಂಗಡಿ ಇವರು ಶ್ರೀಲಾಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 126/5ರಲ್ಲಿ ವಾಣಿಜ್ಯ ಉದ್ದೇಶದ ಬಗ್ಗೆ ಭೂಪರಿಣತಿಗೊಂಡು ಸ್ಥಳದಲ್ಲಿ ಕಲ್ಚರಲ್ ಸೆಂಟರ್ ಮತ್ತು ಲೈಬ್ರರಿ ಕಟ್ಟಡ ಪರವಾನಗಿ ಕೋರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಟ್ರಸ್ಟ್ಗೆ ಜಿಲ್ಲಾ ಗ್ರಂಥಾಲಯ ಇಲಾಖೆಯಿಂದ ನಿರಾಕ್ಷೇಪಣಾ ಪತ್ರ ಮತ್ತು ಅಳದಂಗಡಿ ಗ್ರಾಮದಲ್ಲಿ ಕಚೇರಿ ಹೊಂದಿರುವ ಬಗ್ಗೆ ಅಳದಂಗಡಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಪರವಾನಗಿ ಒದಗಿಸುವಂತೆ ದಿನಾಂಕ ಸಾಮಾನ್ಯ ಸಭೆಯ ನಿರ್ಣಯ 24/2021-22 ದಿನಾಂಕ 18/12/2020 ನಿರ್ಣಯದಂತೆ ಈ ಕಚೇರಿಯ ಪತ್ರ ದಿನಾಂಕ 3/7/2021ರಂತೆ ಹಿಂಬರ ನೀಡಲಾಗಿತ್ತು. ಅದರಂತೆ ಅಲ್ ಹಸನತ್ ಎಜುಕೇಶನ್ ಅವರು ಕಚೇರಿ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಗ್ರಂಥಾಲಯ ಇಲಾಖೆಯಿಂದ ನಿರೀಕ್ಷಣಾ ಪತ್ರ ನಂಬರ್ 854 ದಿನಾಂಕ 16/12/2021 ನಿರಾಕ್ಷೇಪಣಾ ಪತ್ರವನ್ನು ಅಳದಂಗಡಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಉದ್ಯಮ ಮತ್ತು ವ್ಯಾಪಾರ ಲೈಸೆನ್ಸ್ ನಂಬರ್ 261 ದಿನಾಂಕ 6/11/2021 ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ನೀಡಿರುವುದನ್ನು ಸಾಮಾನ್ಯ ಸಭೆಗೆ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯವರು ಹಾಜರುಪಡಿಸಿ ಸದರಿ ಟ್ರಸ್ಟಿನ ಕಟ್ಟಡ ಪರವಾನಗಿಗೆ ಅರ್ಜಿಯು ಕ್ರಮಬದ್ಧವಾಗಿದೆ ಎಂದು ತಿಳಿಸಿದರು. ಈ ಬಗ್ಗೆ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಚರ್ಚೆ ನಡೆದು ಸದರಿ ಟ್ರಸ್ಟ್ನ ಅರ್ಜಿ ಕ್ರಮಬದ್ಧವಾಗಿದ್ದಲ್ಲಿ ಸದರಿ ಟ್ರಸ್ಟ್ಗೆ ಕೋರಿರುವ ಉದ್ದೇಶಕ್ಕೆ ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಲು ನನ್ನ ಒಪ್ಪಿಗೆ ಇದೆ ಎಂದು ಶಿರ್ಲಾಲು 1ನೇ ವಾರ್ಡ್ನ ಸದಸ್ಯರಾದ ಸೋ ಅವರು ತಿಳಿಸಿದರು. ಉಳಿದ ಎಲ್ಲ ಸದಸ್ಯರು ಆಕ್ಷೇಪಪಡಿಸಿದರು. ಸದರಿ ಟ್ರಸ್ಟ್ಗೆ ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಲು ಸಾರ್ವಜನಿಕ ಆಕ್ಷೇಪ ಇರುವುದರಿಂದ ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡುವುದು ಸೂಕ್ತವಲ್ಲ ಮತ್ತು ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಿದಲ್ಲಿ ಸದರಿ ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಿದಲ್ಲಿ ಕಟ್ಟಡವನ್ನು ಕೋರಿದ ಉದ್ದೇಶಕ್ಕೆ ಉಪಯೋಗಿಸದೆ ಅನಧಿಕೃತ ಧಾರ್ಮಿಕ ಚಟುವಟಿಕೆಗಳಿಗೆ ಉಪಯೋಗಿಸುವುದು ಸ್ಪಷ್ಟವಾಗಿದೆ ಎಂದು ತಿಳಿಸಿದರು. ಆದ್ದರಿಂದ ಸದರಿ ನಿರಾಕರಿಸುವುದರಿಂದ ಸಭೆಯ ಬಹುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಅದರಂತೆ ಸದರಿ ಟ್ರಸ್ಟ್ ಹಿಂಬರವನ್ನು ನೀಡಲು ಸಾಮಾನ್ಯ ಸಭೆಯು ಸೂಚಿಸಿತು.
What is the provision for grant of building license?
Please, my lords. Under
section
60, my lords. My lords, my application.
No, what is the provision for grant of building license? Now you have sought for building license.
Please, my lords.
Yes.
My lord, first of all, before I submit, my lord, this is an appealable order before the executive officer of the Taluk Panchayat, my lord. And the entire ground of the petitioner is that it's a deemed permission should be given under 64 subclause 2. So my only request is that maybe a petition may be disposed, he may be directed to go before the EO because it's an appealable provision. And if you see annexure E, the annexure E that he's relying on, saying that as per annexure E is the application given by him, that's at page number 53, my lord. He says, I have given it on 31/7/2021. But if you see, there is no acknowledgement in that document that he's relying on, that he has given it on that date. So I only request if the petition may be disposed of, he may give direction to go before the executive officer, and he can, it's an appealable order.
No, correct. Now you have refused it, isn't it?
Please, my lord.
Yeah, no, PDO has refused it, Gram Panchayat has refused it. He has
correct.
relied on one judgment of this honorable court, the last annexure that he has produced. And the very same judgment itself is a judgment in which they have approached the executive officer, and because the executive officer gave a stay, this honorable court relied on 64(2). Even the same judgment he petitioner is relying on. So he has an appeal provision. So my only requesting is let him approach the executive officer. And as per the Gram Panchayat Act, he has to approach within 30 days under section 70 subclause 3. For 2 years, he has not done anything after the endorsement. Endorsement was given.
Let us have a look at what is the provision under which permission is building licenses are granted.
Yes.
This is the Gram Panchayat Act.
Please, my lord.
What is the provision under which building license is granted? Whether the ground of refusal comes within such power. You examine that, I'll have it next week. I only want to know under what provision you exercise power, whether the refusal as reflected in the resolution comes within the scope of exercise of such power. Then we'll see.
Please, my lord.
Relist the matter in the orders list on date
9th of April.
9th.
Oblige, my lords.
If the exercise of power falls within that, then we can see whether he has to go and appeal. If it is on a ground extraneous to the power of refusal, then you will have to reconsider. Examine.
Oblige, my lords.
50. Serial number 50.
Short
Akshay Kumar
accommodation
Ji.
is matter.
Yes,
I prefer short accommodation. Senior is held up.
that request list week after next.
Please. 51. Shankar Reddy.
My lord, I appear for the petitioner in this matter. My lord, I have challenged the order of the Karnataka Appellate Tribunal. My lord, proceedings initiated under section 321, not for deviation. My lord, during the pendency of the present writ petition, my lord, I had made an application for regularization, my lord, for issue of modified sanction plan. My lord, they have issued an endorsement stating, my lord, that because already deviation notices have been issued, they cannot consider it. My lord, the same has been challenged before this honorable court. My lord, in fact, writ petition has been filed today before this honorable court, my lord, challenging the endorsement not issued by the BBMP, stating that because there is already a notice for deviation issued, they will not consider it. Therefore, my lord, your lordships may kindly grant some time. I still see that it is listed before the court, my lord, in short time.
List this matter along with the WP number.
My lord, it is FR number, my lord, 10,128 of 2025.
WP FR number
10,128/2025.
on Monday.
1st of April. Please.
Interim order may kindly be extended till then.
The earlier grant is extended till the next day. Now BBMP may be right to state that regularization question may not arise when already.
My lord, it's for issue of modified sanction plan, my lord. If there are certain deviations, my lord, within permissible limits, that can be taken care of.
Legal remedy available under the BBMP Act, my lords, against rejection of modified sanction plan. They could file an appeal before the Chief Commissioner.
Anyway, examine it. We are having it, and also examine. Let's assume that his application can be considered. Even if it is considered, whether your building bylaw permits, whether the FAR permits, whether the setbacks. Let's assume that FAR permits for some more. If the setback violation is there, you can't do anything. So you take your stand, one, on the legal position that once proceedings are initiated, whether you can do it or not. Second, let's assume that you can consider it. Is FAR permissible? Is there setback violation? That you examine it and take your stand.
Yes, my lord,
Monday.
Monday is holiday, Tuesday, my lord.
Tuesday.
first of April.
Please.
Yes. ಬೇರೆ ಯಾವ್ದು ಇದೆ ನೋಡಿ.
Issue 2, orders, serial number 1. If you will work further.
Petitioner, my lord. I place 2 days time to amend the cost data.
Weeks time granted. Necessary compliance. Office to put up report regarding notice issued to R11.
Serial number 2, OPPM,
Memo for withdrawal.
delegate.
Counsel for the petitioners filed a memo which reads as follows. Light of the same petition is dismissed as withdrawn.
Serial number 3,
Appearing for petitioner. I've already served the hand summons to the petitioner. I filed the acknowledgement also. Yesterday I filed the acknowledgement, my lords. So they are covered by the first matter is covered by your lordship's order.
So who is R2 now?
It's a town municipality Karkala, my lords.
There is no standing counsel.
There is no standing, earlier it was ordered for to serve a summons on standing counsel, but he said he is not, no more a standing counsel for the town municipality Karkala. Hence, hand summons was ordered, my lords. I have served a copy. I served the hand summons and I filed the acknowledgement also before this honorable court.
Yes, Bopanna, find out why somebody must represent, isn't it? I'll have it next week. Just find out.
Yes, sir.
They must have some counsel. Find out.
Earlier, Mr. Chandranath Ariga was appearing, but the problem is, my lords, he says only if the town municipality or
To
directs
find
him
out
to appear, he will appear.
telephonically, ask them to have some standing counsel. Relist in same stage on.
8th of April.
Yes.
There.
Serial number 4,
An auction notice of the BBMP is challenged in respect of an apartment which owes me, my lord, 1.5 crores in
Some
arrears.
interim order were passed.
Interim order was granted. My lord, I have paid the dues. As an association, I have paid the dues. As stated in the auction notice, my lord, at page 14. 1.98 lakhs was said to be due. I have
Correct. So
cleared it.
let us see. So you have to complete your pleadings. And counsel for the respondent submits pleadings would be completed within 10 days. List the matter after 2 weeks.
Please, Lord.
Interim order.
serial number 5,
Interim order in operation is extended till the next date.
5, Arun KS.
They are intending to file an application. In spite of the interim order passed by this honorable court, my lord, the construction is going on. We are intending to file photographs along with the application.
So what else can we do?
The premises is sealed, my lord.
Sealed.
We have put a lock. We have given police complaints also, and there is a seal.
The premises is sealed is what.
Yesterday they said that interior work is going on, even if it is locked. Today also they have gone to the spot. Today's photograph also there. We have asked them to go and we have sealed it.
No, the
Lock
premises has been sealed. Premises has been sealed. Memo filed by respondent BBMP is taken on record. The respondent BBMP has also approached the SHO Malleshwaram seeking for necessary assistance. Further, respondent BBMP has issued appropriate communication to the concerned engineers that if construction is permitted to be continued, necessary disciplinary action will be taken. Photograph is produced. which would, and it is submitted that the premises has been sealed,
Locked, my lord.
locked, has been locked. Now they've locked the premises.
Yes, my lord, but what had transpired in between is inside work is going on still.
Correct, so what is to be
And,
done? No, you tell us what is to be done.
Now, my lord, I am intending to file an application. It may be short passover, I am asking. It has gone for notarization. I need to file an application against the officials of the BBMP for not obeying the interim order of this honorable court. And moreover, my lord, they have approached the petitioner also for some sort of settlement. Though the,
Possible.
please, ma'am.
Because of this matter, my lord, your lordship are
Six.
pleased to
The respondent, my lord. But the
direct us
matter
to
has be
pay
listed
the
on 9/4.
license fees, my lord. License fee are paying, my lords. But now they are demanding something more than the license fee. Your lordship may kindly turn to page 98, my lords. And also I produced one of the receipts at page 95, my lords, my. Next year E1. ಆದರೆ ಬಟ್ಟೆ ಅಂಗಡಿಯ ಬಾಡಿಗೆ ರಹದಾರಿ ಶುಲ್ಕ ಪಾವತಿ ಮಾಡಿ ನವೀಕರಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ಸಂಘದ ಸದಸ್ಯರುಗಳ ರಹದಾರಿ ಶುಲ್ಕದ ಜೊತೆಗೆ ಅಂಗಡಿಗಳ ಸಿಆರ್ ಇಲ್ಲವೆಂದು ರಹದಾರಿ ಶುಲ್ಕ ಮೊತ್ತಕ್ಕೆ ಸರಿಸಮಾನ ಸಿಆರ್ ಶುಲ್ಕವನ್ನು ವಸೂಲಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಹಾಗೆ ಅಂಗಡಿಗಳು ಬಟ್ಟೆಯ ಬಂಡಲ್ಗಳ ಶೇಖರಣೆ ಮಾಡಲು ಮತ್ತು ಮಧ್ಯಾಹ್ನ ಊಟ ಮತ್ತು ವಿಶ್ರಾಂತಿ ಮ್ಯಾಸ್ನೈನ್ ಅನ್ನು ಮಾಡಿಕೊಂಡು ಬಾಬ್ತು ಇದಕ್ಕೂ ಸಹ ರಹದಾರಿ ಶುಲ್ಕವನ್ನು ವಸೂಲಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. This is, I don't want this to be recovered, my lord, till the disposal of the writ petition. Additional amount over and above the tax. The tax is at
What is
page
this?
page 84,
Was listed on
84, my
21st, my
lord.
lord. I sought for instructions, your lordship, but that is listed on 9/4. Meanwhile, let him, let the petitioner pay the amount, my lord. As per the, my lord, annexure of the trade license, the amount is 6,000 odd, my lord. Even in demand notice, the same amount, 6,000 odd. Now they say that we are charging more.
No, this, now you have paid this 6,000.
They are not paid, my lord.
Have you paid the tax?
Now by 31st they are ready to pay, my lord, but they are demanding the higher amount.
Apart from the, you pay that.
What is actual tax at page 84? We are ready to pay, my lords.
Annexure D and annexure F are the same, my lord. Annexure D is the demand.
That's all.
Annexure F is the amount 6,636.
Annexure D.
D, my lord. Annexure D.
Page 84.
Page 84, my lord. Same, the amounts are the same. But now they say that we are seeking more.
Page 84, what is the amount?
84, column 125, my lord. Siddha Udupugalu Batte Vyapara. 6,636, my lord. Your lordship may. The annexure F is the same amount, my lord, 6,636.
This amount we are ready to pay. Over and above this, we are not ready to pay.
You pay this amount.
This amount, that may be clarified, my lord.
Let's see number 125.
Please, my lord.
So we'll
That may be clarified.
This is the same amount, 6,636. Now their submission is that we are seeking more.
Lord, I have produced one annexure at page 98, my lords. Their demand is 6,636.
Now their submission is we are seeking more than this.
No, 6,636.
For a shop measuring 2 ಚದರಡಿ 3,318. ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು 6,336. I have produced an annexure F, my lord, page 98. Double the amount.
Same amount, my lord. Even annexure D is the same amount.
Now you look at the measurement of the premises and you get back next week. Look at the measurement of the premises. Now for 3318. If it is beyond 300 square feet, it's 663.
Please, my lord.
Now you pay according to page 84 as per the applicable slab.
Please, my lord.
Page 84.
Page 84, we are ready to pay.
That's all.
That's all. They cannot demand, your lordship may turn to annexure F, my lord, page 98.
No, that means
They are demanding double the amount.
Petitioner is to pay in terms of the slab as indicated at serial 125 at page 84.
Please, my lord.
Depending on the area.
Annexure D, my lords.
Depending-
Annexure D, page 84.
Depending on the area.
Please, my lord.
Relist
Much
week
obliged.
after next. You take your stand in writing.
Please.
Yes, next.
Seven, number 7. Narayan.
The three matters. So all these three matters, my lord, pertain to a property, my lord, which is known as Mantri Square, Mantri Mall. Lords, may kindly recall, my lord, I had an occasion to argue before your lordships, my lord, a couple of matters.
Now the pleading is complete, is it?
Look, in
Pleadings are
one matter,
complete.
I have to
One
file-
nimsham, Monish.
one I have to file
7.2
objection.
may have to be delinked because, my lord, 7.2 is, my lord, we have sought for certain reliefs in respect of a TDR which is granted to us in respect of, my lord, the area consumed. My lord, that, my lord, matter, my lord, does not pertain to the subject matter of 7 and 7.1.
So 7.2 is to be delinked.
Yes, my lord, it is pertaining to TDR. My lord, what happened was, my lord, a large extent of our property, my lord,
No,
adjoining.
just 1 minute. Yes.
May I respectfully submit this way? Certain portion, please, my lords, of their lands was consumed for the purposes of road. Now, at that point of time, what they would do is, for the purposes, please, my lord, they have conveyed to us, that's the private properties, some other properties, not their properties, state properties are also conveyed.
No, that's why 7.2 is to be delinked.
It could all be clubbed and I have no.
Not exactly, my lord. It cannot be clubbed because the subject matter is totally different, my lord. 7.2, precisely, my lord, I'll only take 1 minute.
No, 7 and 7.1 relate to what?
7.1, it relates to, my lord, the building Mantri Square Mall.
So what is the question, dispute?
The
What-
question of dispute, my lord, in 7, my lord, my lord, when the building was being constructed, we sought for modification of the plan. The plan was, my lord, it was not approved. The deemed plan went ahead. Later on, the building was complete. And my lord, the building is now assessed and the BBMP are collecting taxes. Occupancy certificate is in place. Therefore, my lord, in fact, 7 may not even survive. The relief that was asked under, my lord, the petition at item number 7 is, my lord, seeking for a mandamus for the commencement certificate that has spent its time. But still, my lord, we'll argue, my lord, on the other points. 7.1, my lord, is with respect to certain order passed by, my lord, the divisional commissioner, regional commissioner, wherein, my lord, my amalgamation was, my lord, rejected and the regional commissioner, my lord, would go to pass an order saying that there are deviations in the building that has to be brought into control, etc., which is not, my lord, his jurisdiction. That is what, my lord, these two petitions concerns the Mantri Square building. 7.3, 7.2, my lord.
Yes.
That is with respect to 7.2 is with respect to TDR, my lord. A vast extent of our property was acquired by the BBMP for the purpose of, my lord, formation of road, etc.
No, that's not linked to this.
No, my lord, not at all, not at all.
7.2 is to be delinked and listed separately. Now, this matter of pleadings are complete.
Pleadings are complete. My lords may kindly fix a date, my lord. We'll argue the matter. It may have to be finally.
2024 matter, my lords, I'll have to file my objections.
Which one in which?
2024 matter, the latest matter, my lords, I'll have to
In
file my
7.2.
objections. In that it is ready, my lords, I'll send it.
The counsel for respondent to file a statement of objections within 2 weeks. List the matter after 2 weeks. 7 and 7.1 pleadings are complete.
Pleadings are complete.
Relist. After 10th, some date.
Interim orders may kindly be.
Interim orders in operation are extended till the next date. Yes.
Serial number 8.
I'm grateful.
Keshav Reddy M.
Hold in this case, my lord. I am here for the respondent number 4, a pays for a short accommodation, my lord. I'll file my wakalat on behalf of the
So
respondent
and
number
so
4.
undertakes to file wakalat for the second respondent.
4th respondent, my lord. I'll file NOC wakalat.
For the 4th respondent.
Yes.
Relist the matter after 2 weeks. Yes.
9 urgent 10. Serial number 10.
Respondent's counsel is not keeping well, may kindly be called after a week or 10 days, my lord. Mr. Prabhakar appears for the respondent.
Government was directed to take a stand in this by filing objections. They have not yet done.
Who is answering respondent? Government.
No, government also has to say, because deputy commissioner says this was originally a pond and thereafter it was given to Piriyapatnam municipality.
municipality has conducted auction in the year 1977. I being the highest bidder, bid was settled in my favor and sales certificate was executed in the year 1991. Thereafter, I'm in continuous possession. 2013, when I obtained construction license to commence the construction, then two persons, Ravi Kumar and another person, went ahead and cancelled the construction license and also the kata also without issuing notice to me.
So this land was granted to you by?
No, it was purchased through public auction in the year 1977.
No, that is lake land is the contention.
No, that was, the challenge was made in PIL, that PIL came to be dismissed, my lord, recently. That issue is settled now.
So
Now only issue is violation of section 72(2) of Municipalities Act. As it existed on the date of auction, any property in excess of 5,000 rupees, prior approval of the government had to be taken. On that ground, Deputy Commissioner says that the auction is not proper because prior approval of the government is not taken. That is the reason second prayer I have made alternative prayer. If in the event
state government to complete their instructions in writing by the next date. Relist date.
17th, oblige.
Now state you have to take it in writing.
Hearing for respondent number 1 to 4, my lord. My lord, we are yet to receive the copy of the petition.
They're
My
not
lord,
where, my lord, 9 guntas.
Since 22, madam.
yes, my lord, we have not received the copy of.
Correct, at least you must ask them, isn't it? That you have to file
Lord,
objections.
we are the recently
But in
completed
fact,
party.
the matter is 9 guntas of land have been used by the corporation.
My lord,
for widening the road is concerned. And they have not paid the compensation, therefore we filed a writ of mandamus. This honorable court directed the corporation to conduct a survey and submit a report. Now they submitted the report. Report is not very clear whether any encroachment or land.
my lords,
is used or
we
not.
are
To file
recent.
some report.
Yes,
No,
report
my lords,
is
we
there.
were not representing the parties then. We only accepted the notice on the behalf of respondent number 1 to 4 on 5th March, my lords.
No, report is filed by whom then?
My lords, the councils who were, that report has been filed by ADLR. We were not a party to the proceedings, my lords.
Have
then.
filed a report pursuant to the order passed by this
Then,
honorable court. Order of this honorable court is 3rd November 2022 by Honorable Justice M.G.S. Kamal.
No, now you serve a copy. What can we say? You serve a copy on them.
This report copy, madam.
No, petition papers also there.
Sir, madam.
Copy of,
They are appearing, I don't.
Respondent number 1 to 4.
copy of petition to be filed on council for R1 to R4. Government?
Government is not a party.
Then ADLR, how was the ADLR directed then?
This honorable court directed ADLR to conduct the survey and submit a report. A report was submitted. In fact, Annexure D may not a survey have taken place. It indicates the encroachment of 9 guntas in formation of the road. Page 65.
No, but PBMP was not present during the surveys.
This honorable court directed ADLR to conduct the survey. That order was passed by this honorable court on may not be.
Anyhow, go through everything. Relist on. No, but how can you, there is an order, survey is done and you don't know anything?
My lords, if you go through the order dated 5th March, the office was supposed to delete the name of the council, Shri Ajit Anand. He was earlier representing the respondent number 1 to 4. So that day we have replaced him and that day we received notice on his behalf. So now we need the petition copy.
Yes.
Earlier advocate and record could have been informed all these facts to the subsequent incumbent.
Let us see. Yes, next.
17.4.
Like-
Well, Arjan, serial number 13. Sushma Pratik, 13, 14%. 14%.
I place 1 week time, lords. The petition is misplaced, lords.
Yes.
Property tax is.
No, no, now, who's the party in person? You have filed wakalat. Huh?
Property tax,
No, no, who is appearing now?
13.
Correct. So you have filed wakalat, is it?
No, sir, we are both a party in person.
Permission.
Good. Both.
Council. But ಇದನ್ನು ಈ party in person ಇರ್ತದೆ. Cause list ಅಲ್ಲಿ. Yes, C certificate ಇದೆ.
What we have filed, my lawyer. That's it.
Yes.
That's in this matter.
Your lordship may kindly.
I place 1 week time, file is misplaced in this office,
Let them take their stand.
please,
Relist the matter. At request of the respondent. On.
17th of April.
publish.
Yes.
14, 17th of April.
Sir, your lordship, I will not be available here. We are from Rajasthan, Jaipur.
You
On
can
17th.
come through video conference.
Video conference.
You can log in through video conference.
Yes.
Serial number 14, my lord. I am
14?
for respondent. I pressed 2 weeks time to file my statement of objections, my lord. We wrote a letter to the authority to get the instructions. Within 2 days, I will
Yes,
file.
my lord. 2004, the site was allotted. It was found it was in marshy soil. Moda asked me to that cancel the sale deed and execute a fresh sale deed. In 2007, the fresh sale deed was executed, except bearing site number. Neither the developer the site is earmarked nor number, nothing. It's remained only in papers. In spite of my efforts from 2010, nothing has happened. 2010, the allotee died, leaving his legal heirs. And this is why, in spite of my sincere efforts following up on the BDA, Muda, nothing has taken place except the sale deed that had been executed in the year 2007. Neither the site is identified, nor layout is developed.
Yes.
In spite of my efforts, their response is totally.
But we wrote a letter to the authority, my lord, obtaining the instruction. Finally, 2 weeks time may be given.
The
my lord.
matter, no, not 2 weeks. List the matter in the preliminary hearing list on next week date.
9th of April.
9th, please. Yes.
15, Kevin Narasimha.
We are for the fifth respondent.
Not appearing for the petitioner, senior.
But in
held up
this
in an-
matter, I have to place a plan under which, my lord, we wanted to seek modification of the plan and license. Now, we have already filed a grievance before the municipality, my lord. We are yet to take a decision. Those matters I wanted to place it on record. Your lordship may kindly have this matter on Wednesday, my lord. We will place all this material after serve the copy to the other side. There is an urgency where a commercial activities is now stopped because of an interim order granted by this honorable court.
You appear for whom?
I'm appearing for the respondent number
9.
9.
Now
ninth respondent.
What is the interim order passed?
Interim order is granted and I should not book any functions in my community hall. I sought for vacating thereafter. Matter have been listed often and often. There are so many things. Then ultimately I advised my client to remove all these deficiencies as notified. Substantially, which are deficiencies are removed. Then, my lord, we made a modified plan, have already submitted for approval to the planning of the municipality. They have to take a decision.
Place it on record.
That's the reason, my lord, may kindly be listed on the next step.
Relist on.
Of April.
No, but now what is the main matter is relating
Main
to?
matter is, my lord, the property is being used and using as a commercial activity in a residential zone. Second, there is setbacks and other thing problems are there. It is not provided. It's a license of 2002 and 3, my lord. That's we'll argue the matter on that day, my lord. We will place the materials on record. At present, it is suffice. If a direction is issued to the municipality to consider our latest developments, and if they take a decision, then it will be enabled for us to proceed with matter. That is the reason I make an application along with providing all the copies.
Release the matter on.
There is an interim.
Third, my lord.
Yes.
16, Rajeshwara PN.
Interim order in operations extended to the next date.
16, Rajeshwara PN.
I appear for the petitioner, madam. I'm seeking mandamus to the respondent authorities, BBMP authorities, to include the sale deed in respect of balance extent of 5 feet into 25 feet of northern, southern, and eastern side of the property, abutting the property bearing number 20 by at Vasant Nagara, my lord. Your lordship may kindly peruse Annexure A,
No, no,
the
just-
proceedings of administrator of the.
Yes, Monish Kumar.
Yes.
Take your stand in writing.
Please, my lords. Only
Take your stand in writing. They're asking marginal land, what are the rules, is it permissible, etc. Respondent 1 and 2 to take their stand in writing as to whether, as regards the allotment of marginal lands. Yes.
The date, because
Date.
your lord,
Date put in.
my lord, because
21st. Yes.
21st, please.
17,
Appear for petitioner in this matter, my lords.
Yes.
I
Yes.
appear for respondent number 4 to 7 in this case, please.
My lords, petition, my lords, challenged the order passed by the executive officer, annexure H, my lords. My lords, originally, my lords, the property belongs to petitioner father, my lords. He purchased the property in the year 1977, my lords. My lords, in the year 1994-95, my lords, the Gram Panchayat, my lords, round off the name of petitioner father and
Just 1 minute. Just 1 minute. Yes.
My lordship, I'm representing for respondent number 3 and 4. My lords, as per the objections.
You have filed your objections.
No, my lordship.
My lords, I appear for respondent number 4 to 7 in this case. I have filed objection to the petition, please.
Correct. The authority also must take its stand.
My lords, kindly peruse annexure H for a moment, please. My lords, essentially it's a civil dispute. My lords, the Shafiullah
Let
Khan.
the petition, correct, but let the petitioner have his say.
Please.
my lords, may I proceed?
Yes. How
My
much
lords,
how much time will you take?
let's just 10 minutes, enough, my lords.
Just wait. 2:30. I have a parted matter. I'll take it on some other day.
Let's date may be fixed, my lords.
Yes. Relist on
17.
Date
17.
70. Okay.
Please. Let it be listed in preliminary hearing list, my lords, please.
So let us see, it requires some hearing.
Please, my lords.
Next one, serial number 52, Madhukar Deshpande, Monish Kumar.
The matters are not likely to reach. Please take the dates from the court office. Yes. Mandamus. Yes. Wherever interim order is there, it will stand extent.
First matter.
Have a parted matter, other matters are not likely to reach. You take dates.
My lords, just one submission, my lords. Serial number 16, it has already been adjourned, my lords. The direction also has been given to conduct a survey, but I just have a submission to that effect and clarification. If you can have it tomorrow or on Tuesday, my lords.
I passed an order, I've heard you. Your colleague has represented. I have also clarified. On
My
the next
lords,
date, you make a submission.
On Tuesday, my lords.
I've already passed an order and already signed.
It was actually handsome.
13.
I have submitted in 11th month itself. Today it's not, because it is posted for review. It doesn't reach at all. Half time it reached. Somebody in my family died.
It was not 23.
The Lordship has given tomorrow's date that. But it has come 23. It may be heard by that.
Not today, not today. I have a parted matter now.
Tomorrow or day after.
I didn't know. 17.
23 serial numbers.
17.
May I submit? Serial number 5 in the second list. You may be permitted to file the application.
But I have a parted matter. I'll take it. I'll relist it. Short date.
Please move.
Application filed by the petitioners taken on record. You serve a copy and BBMP.
Yes, sir.
Relist the matter on. What is the original date?
9/4, my lord.
9. 9th.
My lord, shorter date, ma'am.
No. Now what we can do? Now
My lord, the construction is
correct. So now police, we have given, you file contempt now. Police help.
that is the application filed, my lord.
Correct. Now that you file before Kotal, the roster bench regarding contempt. Regarding jurisdictional police, I have given permission.
Please, my lord.
Make use of the order. If there's a contempt, you go before the contempt bench and initiate it immediately. Let us.
Please. Much obliged.
Lord, serial number 24, my lord.
Yes.
For the petitioner, my lord, for mandamus to do e-kata. My project has been altered. I am unable to get the plan sanction done. My request is kindly a short date may be fixed.
Yes.
Two submissions, my lord, before they commence. Two additional submissions which were omitted, my lord. One is they cannot sanction the plan, challenge the sanction plan before the writ jurisdiction because there is an appeal is provided under section 253 of BBMP Act.
Yes.
Therefore, repetition is not. Another argument that they advanced, now the already 2 years expired. Therefore, I cannot continue the work. My lord, the plan was sanctioned in 2021. They lodged a complaint in 2022. By that time, the construction was already started. The provision, bylaw provision 5.2, my lord, says the construction and reconstruction of a building shall be commenced within 2 years from the date of issuance of license. Before the expiry of the 2 years, the owner shall give intimation to the authority of intention to start the work in the form prescribed. Further, the owner shall give intimation to the authority on completion of the foundation of footings, walls, and columns on foundation. Now, already construction is commenced. At the time of footing levels, only they filed a. Their case is that I have not obtained a commencement certificate. Merely I have not obtained a commencement certificate, it does not mean that my plan stands lapsed. There is an amendment, my lord. Even earlier there was a circular, now by way of amendment. Page number 10, my lord, clause G. Page number 10, clause number G. Penalty imposed at the time of issuance of occupancy certificate for not obtaining commencement certificate at the commencement of construction at such rate not exceeding 0.25% of the guidance value of the vacant site under section so and so. So there is a provision to regularize it. My lord, to complete the construction from the commencement, it is 5 years, my lord. 5.6, the bylaw 5.6 says, occupancy certificate. Every person shall, before the expiry of the 5 years from the date of issuance of license, shall complete the construction or reconstruction of a building for which the license was obtained and shall be complete the construction of a building for which it was obtained. See, 5 years is the time period, my lord. 2021 is the plan. I have a time till 2026. The petitioner cannot object the construction, saying that it is a violation, bylaws violation, everything is objecting to construction also. At the same time, he cannot urge, saying that you have not commenced the construction. He cannot approbate and reprobate. So that those two arguments may not be sustained.
Lords, may appreciate it. I just have two submissions to make. Originally, please, my lords, the plan sanction consists of block A, my lords, wing 1 and wing 2. Block A, wing 1 and wing 2. That is what the original plan was sanctioned. Now, wing 1, my lords, will consist of 11 upper floors. Wing 2 will consist of 11 upper floors. Wing 1 construction is complete, occupied, my lords, by the petitioner society, and OC is also issued. Partial OC is occupancy has already been issued. Petitioner society is restricted only to block A, wing 1. Lords, wing 2, block A. At this stage, please, my lords, we receive an application for modified plan. Instead of constructing, please, my lords, 11 upper floors in wing 2, it is restricted to 2 floors. Restricted to 9 floors. That is, 2 floors they have not built. My humble submission is only 9 floors are being.
To 9 floors.
9 floors.
When was this modification?
Modified plan, please, my lords, as per the recent modified plan.
When was that?
I'll give 2021. Impugned plan itself, please. Annexure HLO, no?
Yes.
Now, this is what is sought. So here, let's wing 2, block A. From existing 11 floors, what was earlier sanctioned, the modified plan that has been sought is restricting this to 9 floors, and my lords, to the eastern end, my lords, 2 floors commercial block is sought to be proposed. For which purpose, my lords, a modified plan is sought to be sanctioned. In this area, please, my lords, wing 2 does not belong to the petitioner society. And where the commercial block is proposed also does not belong to them. This is in conformity with the zoning regulations on the building bylaws. Lords, the sanction, my lords, for block A, wing 1 and 2 is dated 12. My lords, I have also submitted, my lords, a synopsis, 1-page synopsis.
All the 1 pages have become many pages. Yes.
Lords, In the synopsis, my lords, it is just one page along with my plan that I have
Yes.
submitted. Original description, my lords, original sanction was for one block, block A, wing 1 and 2, residential apartment construction, 2 basement, ground floor plus 11 upper floors. Height was 37.20 meters. Sanctioned remarks, my lord, sanctioned in the year 2015. Fire Force NOC is secured on 19/4/2013 for residential wings, 2 wings construction, 2 wings, my lords, comprising of so and so, so and so. Occupation certificate is issued for block A, wing 1. That is towards the southern end. Now, height of this building is 37.20 meters. 5 floors clearance is also secured. Initially, my lords, it is no objection. At the time of occupation, my lords, it is clearance. Clearance is also secured. But at this stage, please, my lords, the builder has approached the BBMP for remodified plan. Now, as per the remodified plan, please, my lord, wing 2, he proposes, please, my lord, that he will only construct 9 floors instead of original sanction of 11 floors. And 2 floors, my lords, he wants to have a commercial activity, please, my lords, to the eastern end. That is all, please, my lord, that is sought to be, my lords, constructed. And for this, my lords, because the height of the building for the commercial purposes, it is only 2 floors, my lords. The NOC from the fire is not requirement. For the others, my lord, there is already an NOC from the fire department. It is only, my lords, 10.5 meters height, the commercial. It is less than 15, my lords, 15 meters in height. NOC from the fire department is not a requirement. That is as per the notification of the state.
Now the sanction originally
Please, my
in
lords.
block A was for wing 1 and wing 2.
Block A, wing 1 and
And
wing
wing 2,
Wing 2.
for which fire force clearance was given.
Yes, yes, for both fire forces given. Wing 1 and wing 2, both they have
The
secured the fire.
modification was with respect to additional commercial.
Modification is,
Though it was for reduction, that's one part of it.
please,
The second part is however for additional commercial.
yes, please. my lords.
Now for that commercial, there is no fire
There
clearance.
is no fire force because of this reason, not, we have explained it also. It is 10.5 meters in height. If it is exceeding 15 meters, my lords, we will, as per the state notification, NOC was a requirement. For these 2, there is a fire force NOC.
Where is
Wing
this,
1 and wing 2, there is fire force.
where is this 7/7/2011 government notification?
That is the notification of the state, my lords. I think they have produced it also. That states, please, my lords, that below 15 meters, there is no requirement for fire force NOC. This notification, they are also aware. There is no change in the setback. If there is any change in the setback, then fire force is a requirement. There is no change in the setback.
meters and above.
Please, 15 meters and above, please, my lords, it is a requirement. This is hardly, my lords, I think 10.5 meters. So therefore, please, my lords, it is not a requirement. And with regard to wing 2, my lords, after clearance, my lords, from the fire force only, occupancy, it will be considered for occupation certificate, occupancy certification. Wing 2.
Wing 2,
After clearance, my lords, from the fire force, it will be considered for occupancy certification. Only wing 1 is now granted. Wing 2, they have not yet come up for occupancy. Construction is complete. They'll have to take the necessary fire force approvals, and thereafter they'll have to come to us. After that, at that stage, we will consider it. So, but initial plan sanction is there for wing 1 and wing 2. Block A.
yes.
That is all, please. And I was directed to furnish a report. I have not filed the report. Our engineers have gone there, earlier order of this honorable court. We have gone there, we have inspected, and the entire report is placed at the hands of my lords.
Yes.
Yes. But I will try to respond to the submission made by the parties. Only my difficulty is that, my lord, while reply, I may overlap with my main argument, my lord. I may be condoned to that extent. My lord, the state has made the submission on behalf of the fire department, my lord. The government advocate has made a submission that they have submitted 2 reports, my lord. The first report they had submitted, and in that particular first report, what they had submitted, the government advocate made the submission that in that particular first report also, they have observed regarding variations in the construction. That is what the submission was made, my lord. Then pursuant to the direction issued by this honorable court, one more report was submitted before this honorable court. In that particular report, it was specifically observed by the fire department that it is difficult for the fire department to conduct any rescue operation in the property. So that was the submission made by the government advocate. At the end, my lord, the government advocate made the submission that there is a violation. The 8 meters sufficient space is not available, and proper rescue operation drill was, and they are unable to conduct, and vehicles cannot move. But only thing is that they express their inability, saying that it is the BBMP which is required to take the action, because fire department cannot take the action, because it is a BBMP which is competent. Though this particular fire department is work is entrusted to the home department and the police authority, my lord. Since it is a civil dispute, they cannot step into it, and only the BBMP can take the appropriate action.
Now, under the Fire Act,
Yes, my lord.
Setback, etc.
Yes, ma'am.
Is independent or a part of the bylaws of BBMP?
No, my lord, it is independent of it. So it is not part of the BBMP bylaw. Fire requirement, insofar as Karnataka is concerned, my lord, after beyond Carlton, it is an independent legislation, independent requirement, my lord.
So what does the Act say?
The Act says that, my lord, the Act.
Does it stipulate?
Yes, ma'am. It states that National Building Code has to be followed. And at so many places in the 7/7/2011 notification, my lords referred to, my lords was holding it. At so many places, my lord, there is a reference to the National Building Code.
Fire department strictly act upon this notification. Fire and emergency services department to the act according to this notification. Para 8, my lord. Here it says the power. The power with the fire and emergency services is only at the time of when the builder approaches the fire department for occupancy certificate. Then it will visit the place and verify whether it is in accordance with bylaw or sanction plan. If it is not, it can cease the given for OC. Occupancy certificate, it may refuse, and at the most it can direct the BESCOM or HISCOM to disconnect the electricity. That is the only power vested with the fire and emergency department. Is clearly mentioned in para 8, in that notification. Can brought to the notices of all the authorities. Power is only, it can direct the BESCOM authority to disconnect the electricity.
So for high-rise buildings above 15 meters, technically no plan can be given without obtaining NOC from the fire department.
Initially, we will give if it is in accordance with the sanction plan. At the time of asking for OC.
Once again.
After the completion of the project.
Once again,
we will visit the place and come to know whether it is satisfied all the conditions of the whatever the sanction plan submitted at the time of obtaining invoice. If it is not in accordance with the sanction plan, then we can ask the DISCOM to disconnect the electricity. And we can write the appropriate authority to take appropriate action. Para 5 is specifically stated what are the powers. Page 3 paragraph.
Now, I'm just asking that in case of the commercial, they have applied for some modified plans. Now they're putting up construction. Occupancy certificate cannot be given finally after they complete without your inspection. Then under subsection 4 of the notification, fire safety certificate has to be renewed every 2 years, once in 2 years.
Periodical.
They have to, for all high-rise buildings. This the 12, 13, 14 last little.
Yes, my lord, I will just try to provide.
Yes.
My lord, I will just explain, my lord, how the fire NOC and the fire department plays a role in this particular entire issuance of sanction plan, my lord.
Yes.
My lord, before seeking for the approval of the sanction plan, my lord, with reference of a high-rising building, my lord, not for all the buildings, my lord, with reference to high-rising building, which are 15 meters and more than 15 meters, the draft sanction plan or the draft plan is supposed to be submitted to the fire department even before approaching to the BBMP, my lord. That is the first step, my lord. Insofar as Karnataka is concerned. So once that particular the draft sanction plan is submitted, then the fire department would look into it with regard to the that particular compliances, more particularly in the light of National Building Code, my lord. That particular plan, they would understand, examine it in the light of National Building Code, my lord. The reason is that, my lord, in the notification dated 7/7/2011, it is specifically mentioned that insofar as high-rising building is concerned, National Building Code is required to be followed. That is what it has been mentioned.
Now they have to integrate this into the building bylaws.
Yes, ma'am. It is
I
now the
think
national.
Eventually,
yes, ma'am.
This fire, whatever stipulation is there,
yes, ma'am,
must be incorporated in the building bylaw itself, so that there is no confusion or it is.
It is also incorporated, my lord, in the building bylaws. With respect of submission of the application, they say that you are supposed to approach the fire department, obtain the NOC, and only thereafter your application will be processed. That is what the building bylaw speaks about. So it is in requirement of building bylaws. They are supposed to submit the draft application for NOC with the draft sanction plan, my lord.
No, one also says.
Yes, ma'am.
BBMP
shall not grant building plan
license
without obtaining no objection certificate from the fire and emergency services. Similar power is also available in the bylaws. Bylaws also mandate that a builder who is putting up the high-rising building supposed to go to the fire department and obtain the NOC.
Yes.
And he is supposed to apply it. That particular plan will be looked into by the fire department in the light of the National Building Code, my lord, as per the requirement of number 2, my lord. Number 2, it speaks about it. If my lord takes page number 2. In high-rising buildings,
wherein fire safety measures are required to be provided under the building bylaws, zonal regulation, the building bylaws as well as zonal regulation, my lord, the height of the building, what is the setback, it is provided. National building code. In addition to building bylaws, zonal regulation, my lord, national building code is also incorporated. So it is at par with that. As well as under other provisions which are applicable, the builder, developer, organizers, contractors, architects and engineers, society, association of persons, etc. constructing building shall provide fire safety measures as per the provisions, and without such measures, the BBMP shall not grant occupancy certificate. So the condition is that, my lord, they are supposed to obtain the NOC. At the time of obtaining the NOC, their application, their plan should be in tandem with the zonal regulation. Zonal regulation also fixes what is the area should be left out with regard to the fire ingress and egress, my lord, that with respect to the open space. And also, my lord, National Building Code also explains about it. So this is what they are supposed to. Once that approval is given, NOC is no objection certificate is given, my lord, then the builder, along with other NOC, that is the NOC issued by the Airport Authority, BSNL, my lord, then the BWSSB, BESCOM, my lord, he would submit the application for issuance of a license and sanction plan under the bylaws to the BBMP, my lord. Then, my lord, BBMP would issue the sanction plan as well as license. Once the sanction plan and license is issued, my lord, periodically the engineer is supposed to examine the buildings, more particularly high-rising building, my lord. More particularly, these type of buildings, my lord, before completion of, after the completion of the foundation. Once the foundation is completed, my lord, he is supposed to examine that particular building, my lord. Then only he can issue the commencement certificate. I don't want to enter that particular area, my lord. May not be relevant for the present dispute, but I'm trying to explain. Then he would issue the commencement certificate because he is supposed to ensure that whatever the foundation they have put in, it is as per the sanction plan. If the foundation is not as per the sanction plan, if the foundation is in some other place, there is bound to be a deviation. For that reason, my lord, he would issue the commencement certificate.
It has remained on paper.
That is the reason.
And
now they have issued this particular, the Sudhakar has filed this particular rule, which says that, my lord, it can be condoned and the amount can be collected at the time of occupancy certificate. Then, my lord, once the commencement certificate is issued, my lord, then they are supposed to put up the construction. Once the construction is completed, they are supposed to prepare the as-built plan, my lord. As per the requirement of bylaws, my lord, as-built plan is required to be prepared. And then they are supposed to inform what is the difference between the sanction plan and as-built plan, both the fire department as well as the by BBMP. That is the as-built plan, my lord. Once the as-built plan is prepared with the architect certificate as well as certificate from the structural engineer, because it is a high-rising building, my lord, they are supposed to approach the fire department for the clearance certificate, my lord. Then, my lord, the fire department would visit the place. Then they will issue the clearance certificate. Once the clearance certificate is issued, my lord, on the basis of the as-built plan, structural engineering certificate, architectural certificate, clearance certificate, builder is supposed to approach the BBMP for issuance of the occupancy certificate. At that time, once again, the BBMP is required to inspect the premises, my lord. Then they are supposed to look into it. Then they will issue the completion certificate and thereafter occupancy certificate. Once the occupancy certificate is issued, my lord, on the basis of that, the tax demand register, the entry has to be made with respect of each of the houses, because the vertical and horizontal, there will be a much difference. For that reason, the individual khata will be having a multiple khatas with respect of more than one particular person khata will be issued. So that particular name of the persons, either in the name of the owner or in the name of the prospective purchaser, khata will be issued, my lord. Once that khata is issued, my lord, insofar as that particular building is concerned, my lord, the sanction plan, the occupancy certificate is complete in all respect, my lord. That particular khata or any plan cannot be meddled with or cannot be changed. Once that is done, my lord, the tax demand will also be made on the basis of that particular amount, my lord, that particular khata certificate. So this is the entire process, my lord, from the NOC, from the fire department to the Khata certificate. If there is any deviation, if there is any the violation, my lord, the occupancy certificate cannot be issued. If the occupancy certificate is not issued, my lord, Khata cannot be issued at all. There cannot be any tax demand also. If this is scrupulously followed, my lord, this entire irregularity can be controlled, my lord. This is the entire process.
The Khata will be issued only after the OC.
Yes, ma'am. Khata will be issued only after OC because there will be one particular Khata, ma'am.
Now they're not insisting on OCs. They're giving Khatas without.
My lord, what happens is that, my lord, the concept of B Khata is now being extended with respect of this type of high-rising building also, my lord. That is not proper, my lord. They cannot issue, my lord. This is my.
But for B Khata, they don't give plan also.
They will not give the plan also.
But
And my understanding, I may be wrong, my lord, with respect of these type of buildings also, high-rising buildings also, at some time, my lord, they have issued the Khata certificate without there being a completion certificate and occupancy certificate. So there must be a fire NOC, my lord. After the fire NOC, there must be a sanction plan. After the sanction plan, there must be a commencement certificate. Thereafter, there must be a as-built plan. Thereafter, there should be a clearance certificate. That clearance certificate, once it is issued, the structural certificate should be there. Architectural certificate should be there. Once that is issued, my lord, then the next step is that, my lord, completion certificate is there. After issuance of completion certificate, occupancy certificate, then, my lord, tax demand register, the entry has to be made, then the Khata certificate has to be issued. These are the steps which has to be followed, my lord. So at two places, my lord, the fire department will participate. Initially at the
before sanction plan one.
Yes, my lord. Before sanction plan once.
And second, before occupancy.
Before occupancy certificate. Once the occupancy is issued, my lord, their role ends for the time being, my lord. Every 2 years, they are supposed to interfere and they are supposed to conduct they are supposed to examine whether the fire requirements have been met with or not, my lord. They are supposed to examine.
Is only extinguishers and so on and so forth, my lords. What they
Correct.
prescribe,
No,
that they will have to. My lords.
No.
Once the
If there is
setback
any
is
obstruction,
complete, occupancy is issued. My lords, fire force, my lord, based on the fire force permission only, the occupancy will be issued. It is in strict conformity with the laws. When the fire force will come into picture is, my lords, thereafter, please, my lords, every year they will come 6 months, some staggered duration. They will come, please, my lord, and check if the extinguishers are in place. If the other norms, please, my lords, are in place. That is all. It is a regular formality.
Or if the conditions of the NOC are adhered to.
Yes.
Once permission is,
Permission
every
is
2 years, they have to see that everything
And,
is working. Sprinkles are working, or other. That is why that the other clause was saying every 2 years they have to inspect. That is post completion.
And my respectful submission is this: what submissions are now sought to be advanced, they are beyond the scope of the petition. There are neither averments nor there is any prayer sought. So my humble submission is this, my lord, at at face value, my lords, cannot be submitted at this stage.
Yes.
my lord, it is not just restricted to the fire equipment and apparatus, my lord. They are supposed to see whether whether there is any obstruction. My lord, when in the high-rising building, my lord, as per the National Building Code, my lord, at every height, my lord, at every height, for example, 6th floor, there must be a refuge area. At the, for example, in the 6th floor, or above the 6th floor, at the 12th floor, there must be a refuge area. That is the refuge area where the assembly of the people has to happen. For example, in the high-rising building projects, my lord, the assembly, they will mention it as an assembly or a refuge area. That is the place where we are not supposed to park the vehicle. We are not supposed to keep any permanent structure, or we are not supposed to keep anything which is difficult to move. So they are also supposed to look into it, whether there is any obstruction have been laid, or whether there is any restrictions have been put with respect of refuge area as well as the assemble. It is not just restricted to the apparatus as well as the machines, my lord. My lord, in this case, my lord, if my lords considers the submission of the government, my lord, the government has made the submission that the fire requirement has not been met with. Once the fire department requirement has not been met with, my lord, whether I have filed a suit, whether I have filed a writ petition, dehaus of that particular situation, my lord, the entire construction activity has to be stopped. And the BBMP has to ensure that the constructions come to a standstill. The builder should comply with that requirement. Only thereafter he complies all the requirement, he can commence the construction, my lord. My submission is that, my lord, insofar as my grievance is concerned, the state government and the fire department is with me, my lord. Their reports are also supports my case, my lord. Unfortunately, my lord, the government report as well as the fire department report was not available with me when I had instituted the suit, my lord. So this is the sea change from the date when I instituted the suit in the month of December 2023 and today, my lord, because now the fire department has submitted its 2 reports, which supports the case of the petitioner, my lord.
Just one.
One clarification, please, Malad, with regard to what my learned friend has been.
My lord, ಮಹೇಶ್ವರಿ ನಾನು ಮುಗಿಸ್ತೀನಿ. ತಾವು ಮುಗಿಸಿದ್ರೆ ಇಲ್ಲ ನೀವು ಇದನ್ನ ಮಾಡಿ ನಾನು ಇದನ್ನ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಇಲ್ಲ.
Yes.
Insofar as, my lord, fire NOC is concerned, my lord, and fire clearance certificate is concerned, my lord, the BBMP cannot sit on appeal. It is only the fire authority which can make its submission.
Yes.
The BBMP, as per this notification, my lord, is only an implementing agency as per the reports of the fire department. My lord, the submission of the BBMP was that, my lord, everything is legal, my lord. And that was the submission was made on behalf of the BBMP, my lord. And the one more submission was made, my lord, that there is no need of requirement of fire NOC because the commercial building is, height of the commercial building is 10.5 meters.
Ten 10.5 meters.
10.5 meters. Whether the fire NOC is required or not, it is not the BBMP cannot make the comment on that, my lord. It is not the BBMP, it is the fire department which is required to make the comment. And the fire department rightly has issued the fire NOC, which is under challenge. The builder has produced he has obtained the fire NOC, my lord. I have produced before this honorable court, my lord. It is too late in the day for the BBMP to make the submission that there was no occasion for, there was no need to obtain the fire NOC. And therefore it is not the submission of the builder, my lord. The builder is not making that submission, that fire NOC is not required. It is the BBMP which is making that submission. The BBMP submission is contrary to the notification.
We'll continue.
Yes.
Election petition. All about election petition.
That's me. One advertence of my lords, at page
Let us
number
see, let
one.
us see. I have some meeting.
Oh, please, I'm sorry.
First of April.
Serial number 36, I was not present in. After I held up in some other court. At first. At 16th.
First of April, I have something.
Next.
Second.
Yes.
16 4 again ಹಾಕೊಂಡಿರ್ತಾವೆ 16 I am not in station. Earlier date ಹಾಕೊಂಡಿರ್ತು ಅಂದ್ರೆ
ಯಾವ್ದು ನೋಡಿ.
Serial number
36 Anand Ram and that TDR matter.
16 4 ಅಂತ ಇದೆ.
16 4 I am not in station. ಆ weekಲ್ ಇರಲ್ಲ ನಾನು.
21st.
21st ನೋಡ್ದೆ. So earlier date
36.
26. 26 26.
21st.
21st.
21st ಗೆ ಬರೋದು ನಾನು ಇರಲ್ಲ.
Second list.
23rd. Please.
My lordship, second list.
No, dates.
20 interim order also extended. Interim
Serial number
order.
ಎಷ್ಟು ಸರ್?
21 sir, second list. Janardhan.
ಸರ್ serial number 21.
After 3 weeks ಕೊಡಿ interim order extension ಮಾಡಿ.
21 9/4.
3 weeks 9 ಬೇಡ ಅದ್ರ next week
ಕೇಳಿ ಸರ್ ಡೇಟ್ ಕೇಳಿ ತಗೊಂಡ
9/4 ಕೊಟ್ಟು. Interim order extension.
ಎಲ್ಲ ಬರ್ದಾಗ ಹೋಗಿದೆ ಸರ್
Sir, interim order extension. Sir, interim order extension ಮಾಡಿ.
ಸರ್ ಎಲ್ಲ ಬರ್ದಾಗ
Sir, interim order extension. Sir, interim order extension.
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಸರ್? ಸರ್ ಅವತ್ತು ಅವತ್ತು ರೀಚ್ ಆದ್ರೆ
Sir, interim order extension ಮಾಡ್ಬಿಡಿ.
ಇದ್ರೆ ಆಗಿರುತ್ತೆ ಅಲ್ಲಿ.
ಇದೆ ಕಂಟಿನ್ಯೂ
ಇರುತ್ತೆ.
Eligible copy ಕೇಳಿ. Para 12, 13, 14.
ಆಯ್ತು ಸರ್. R3. ಮಾಡ್ಕೊಂಡ್ರ 9/4 ಮಾಡಿದ್ವಿ. ಆಯ್ತು ಸರ್ ಆಯ್ತು. ಒಂದು ನಿಮಿಷ ಸರ್. ಹೇಳಿ. ಎಲ್ಲ 2 weeks ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಹೋಗಿ. ಯಾವ್ದು 31 2 weeks ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ. ಡೇಟ್ ಇಲ್ಲ. ನೀವು ಆಮೇಲೆ ಅವ್ರು ಮೂವ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.